I open this hearing of the Senate Legal, Constitutional Affairs Legislation Committee for additional estimates. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. The Senate has referred to the committee the particulars of proposed expenditure for 2025-26 for the portfolio of Home Affairs and the Attorney-General and other related documents. These are additional estimates proceedings, and the outcomes to be heard during today's proceedings estimates are from the Home Affairs portfolio. The committee has set Friday the 20th of February as a date by which written questions on notice should be provided to the Secretariat. The committee has also decided that answers to questions on notice should be returned to the Secretariat by 5 p.m. on Friday the 10th of April 2026. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate has endorsed the following tests of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of the information or the document. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring the cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphone. The committee proceedings today will begin with the National Emergency Management Agency. I welcome Senator, the Honourable Jenny McAllister, representing the Minister for Emergency Management, and I also call officers from the National Emergency Management Agency. Minister, would you like to make an opening statement?
Yes, please. Thank you, Chair.
Thanks.
And good morning, Senators. We are currently in the middle of the high-risk weather season. Australia has been facing a rapidly changing risk environment, and the Albanese government is focused on making sure that our nation is prepared and is able to respond. Minister McBain has been working diligently over the summer period, responding to bushfires in Victoria, flooding in Queensland and other emergencies around the country. Minister McBain would like to thank all of our emergency services workers, first responders, local councils and the many volunteers who have been on the ground this summer protecting lives and communities in the face of extreme weather. Now, of course, when that immediate threat is over, there is a very long road to recovery for many of these communities. Minister McBain has been on the ground in a number of these areas, including Colac, Castlemaine, Yark, Alexandra, Euroa, Ruffy and Harcourt in Victoria, and in Queensland, Cloncurry, Richmond, Claremont and Julia Creek. She's been hearing firsthand what those communities need in their recovery journeys. The Albanese Government supports the states with the costs of providing relief and recovery assistance to communities through the jointly funded disaster recovery funding arrangements. So under the DRFA, the state and territory governments determine the type and the level of assistance to make available following a disaster. These arrangements recognise that the states are best placed to identify the type and level of assistance to make available following a disaster in accordance with their responsibility for disaster management. We have also activated the Australian Government Disaster Recovery Payment, that is the AGDRP, for 60 locations within 13 LGAs in Victoria. And the Disaster Recovery Allowance is available in 23 LGAs, as well as the Lake Mountain Alpine Resort. So far, Services Australia have processed more than $1.6 million in AGDRP and DRA payments to Victorians who are impacted by these fires. The National Emergency Management Stockpile has been used to support firefighters in South Australia, and this includes temporary accommodation to support up to 128 personnel engaged in bushfire response operations. Initiatives such as the National Emergency Management Stockpile, the High Risk Weather Season Preparedness Program and our annual national exercises ensure that we can anticipate, prepare for and respond to disasters. And investments like the Disaster Ready Fund and the National Aerial Firefighting Fleet show our commitment to future-proofing the nation against the impacts of climate change. These investments and this capacity for collaboration reflect a clear national purpose to ensure that we are prepared for the disasters of today and resilient to those that lie ahead. The Minister thanks NEMA for their continued efforts to keep our country safe.
Thank you, Minister. Mr Moon, do you have an opening statement?
Yes, thank you, Chair. Brendan Moon, the Coordinator General of the National Emergency Management Agency, and thank you, Chair and Committee, for the opportunity to make a statement. At its core, the National Emergency Management Agency exists to support people when they need it most. Over recent months, Australians across multiple states and territories have faced an exceptionally challenging period. And throughout this time, NEMA's priority has remained ensuring that individuals, families and communities receive timely support and that the Australian Government's response remains coordinated, consistent and complementary with our state and territory partners. Ongoing devastating bushfires conditions in Victoria have sadly claimed a life, destroyed more than 400 homes, hundreds of structures and caused significant agricultural and livestock losses in the tens of thousands. And as we've heard from the Minister, support has been activated across 24 local government areas in Victoria, as well as seeing interstate and international firefighting resources being deployed to combat those fires. Last month, Queensland was struck by ex-tropical cyclone Koji, bringing destructive winds, intense rainfall and flooding to already saturated regions from severe weather at the end of 2025. Livestock losses are reported in excess of 60,000, with extensive damage to fencing, roads and major disruption for hundreds of thousands of people in northern Australia. And assistance has been activated to support people in more than 46 local government areas, with many of those same communities impacted by events following the record-breaking rainfall in 2019, underscoring the compounding nature of modern disasters. From my time visiting disaster-impacted Queensland, from Queensland's Claremont to Cloncurry to Castlemaine and Harcourt in Victoria, the constant I have observed is the extraordinary dedication of everyday firefighters, Australians, emergency services personnel, volunteers, our defence forces, community organisations, and of course locally embedded staff from NEMA who have worked and continue to work tirelessly to protect lives and support those affected. While NEMA remains focused on supporting Australians during crises, it is clear the development of our systems and our governance processes internally in NEMA have not kept pace with our external capabilities. Recent Senate estimates proceedings highlighted shortcomings in our payroll arrangements, and it is appropriate that these matters were brought to light. Since December, the agency has undertaken a review of key payroll processes and systems, including the mechanisms available to staff to raise queries and seek clarification regarding their pay. The review confirmed that the current payroll system relies heavily on manual processes, and this reliance has contributed to delays in the payment of some entitlements. And this, obviously, our system design requires additional work for effective tracking, oversight and timely resolution. NEMA is working closely with the Department of Home Affairs to address these issues and to improve the accessibility, the reliability and the timeliness of our payroll services. We also recognise that the agency requires a fit-for-purpose model, which is why we are completing a functional review of our operating structures and also our governance arrangements. Our communities and our governments expect an organisation that can scale, adapt and deliver when it counts. This review will be sharpening our operating model as well as unifying and integrating our structures so we can continue to deliver for Australians today and into the future. These actions from the agency will strengthen governance, reduce risk and ensure staff are supported, consistent with public sector expectations. And this work is a priority of myself and the leadership team and will continue until it is resolved. We are committed to getting this right. In doing so, we expect that we'll foster an even more positive agency culture by reinforcing a safer, healthier and more respectful workplace. Thank you.
Thank you, Mr Moon. We'll proceed to questions and start with Senator Cadell.
Chair, if I may just respond, can I, Senator McAllister, thank, through you, Minister McBain and her office for keeping us informed as things were going through the season. Whilst I was emergency shadow, not currently, but it was great. We've been to some of the places you've met with Cloncurry in Western Queensland with Senator McDonald. That was also facilitated information, and the first fire bombings were happening 400 metres from my home, which was an interesting way to wake up to bushfire season. But thank you for the government and that consultation.
Sorry to hear that, Senator Cadell.
No, and thank you to everyone who was out there. Going to the substantive thing, and that you mentioned systems and governance, so let's stay there for a bit. Every time we come to an estimate, more people phone my office and tell us stories, and they are concerning. Mr Moon, have you or anyone in senior management advised staff that the agency is operating under significant financial constraint?
So, Senator, I absolutely recognise in the current operating environment all agencies across the Australian public sector are operating in a tough fiscal environment. It's especially evident in relation to the operations of the National Emergency Management Agency. And I think it's fair to say, if we reflect back on the 3.5 years since the inception of the agency that brought together the Emergency Management Australia and the National Recovery and Resilience Agency, we've experienced some 215 events, Senator. If we look at that annualised or averaged at 6 per month, Senator, and that has been a challenge for the agency. We are certainly looking at how we manage that internally. We seek to obviously deliver a balanced budget, which is the expectation across all agencies. But we need to understand that with the increased frequency of these events, the expectations that the agency will coordinate the Australian government's response to these crises, and importantly the work that we do on the ground with communities does put pressure on not only people but also the finances of the agency, Senator.
Have you advised the staff or any senior management advised the staff that's the situation?
We regularly speak to staff and they regularly speak to us about the pressures that they experience. And if I look at what we have done over the past, recognising, Senator, the pressures that it does place on the agency, we have instigated the functional review to actually look at a fit-for-purpose model into the future that will allow us to scale into these particular events. We've developed an operating model with the staff and getting feedback from the staff, and they have certainly fed back to us the pressures that they have looked at as well. We're developing an operating model that seeks to build those capabilities and take the pressure off staff during critical times. We have established an operational resource group at the highest levels to look at what are those functions the agency need to perform during a crisis, and what are those that we can deprioritise, and that they are active operational measures that we take. We also seek to, if I can, Senator, we also seek to cross-skill other members of the agency so that we can surge additional resources into areas that are particularly under pressure. And I think over the course of the last estimates, obviously the crisis coordination team, the recovery teams. But we're certainly communicating with our staff about the pressures and the steps that we as an agency are taking to manage those.
So 2 of the stories I've been told in the last 3 months, one is that staff put together to go and buy cups and mugs from an op shop because there was no funds for kitchen facilities left. Another one is that there was no tissues available in the building, so they brought in toilet rolls to hand around as tissues. A third one here is that someone who had the foresight to buy notebooks in advance, someone was complaining that they were able to get favours by trading off notebooks because there were other notebooks. They were angry of the stockpile this person had. Are we getting to that level in our fiscal management within NEMA?
Senator, I'm sorry that I have to hear that. I really am. And that's not how we attempt to manage the finances within NEMA. Certainly we are looking, obviously, to ensure that we have a team that can meet the expectations not only of government but also the community, but also do it in a safe environment as well. And as I say, now that I'm aware of those issues, which I haven't been aware of, I will certainly engage with our property team and also with our finance team to ensure that our teams are adequately resourced to actually deliver on the important work that they have.
Okay. Now, on the background of this funding, did NEMA send 2 senior executive staff to attend an executive education course at Harvard, including course fees, travel and accommodation?
I would ask if I can, I would refer that question, if I can, to the Chief Operating Officer. Thanks, Senator.
Good morning, Senator. Sanandan Dasgupta, Acting Chief Operating Officer, NEMA. Senator, if you are looking at the allocation of resources, so we allocate resources, the funding envelope which we have been provided across groups and right up to the cost center manager level. So we basically allow the cost center managers to manage that funding envelope and determine the priorities along that line. So as an example, we cater for all those sort of, staffing, supplier expenses, everything is provided, at a holistic level to every cost center manager. And then it's up to the cost center managers how they sort of prioritize the resources. So that's how allocation sort of works in NEMA. In terms of the travel which you are referring to, I think I will get some details. I think it might be in the 24-25 financial year. And it's a matter, it might, I understand it might be a part of their performance development agreement, which would have triggered that sort of, that sort of training program.
Okay. Are either of those people who went still employed by NEMA or working within NEMA?
So if I can answer that, one of those staff members is on secondment to another agency and one has left the agency, Senator. So
while people are blowing their nose in toilet paper, 2 staff that leave the agency get to go to Harvard. Who made that decision that was you said this compartmentalised budget management? Was that you, Mr. Moon, or was that these people themselves that had that budget allocation?
Senator, that was part of their performance development agreement discussions, and I did make the decision on the basis of an allocated training and development budget that they would attend some higher education In both cases, it was at Harvard. One was particularly centred on crisis management and involved the foremost experts around the year. The other one was a development opportunity, leadership development, Senator.
Was there formal requirements to keep knowledge within the organisation from those trips? Was there written reports, briefings or internal capability uplift that came because of this?
I'd have to ask the Chief Operating Officer.
Thank you, Senator. So there is generally no written requirement in relation to every trip or a brief to be provided. However, in relation to the trainings which they attend or any overseas trip. However, the learnings from those trips are often, it's an expectation that they will pass it on and to the rest of the team members, and that's a capability uplift measure.
It concerns me that people are drinking out of op shop glasses while the organisation has enough money to fund. And I'd like to know on notice later on today, if we know what the cost of those 2 trips were, if we can, that we don't have a formal thing to enshrine that knowledge that is gained within the organisation. That is a concern for me. I understand people move on. I understand someone has been seconded and someone has moved on. But where I'm hearing stories of staff telling they're envious of a person who bought notepads. That was when I'm hearing that, and that concerns me that we're losing this knowledge so quickly. So part of your review, I'd love if you went and had a look at that, and I'm happy to rotate now if looking at the chair, looking at me. I have another batch for later. Thank you.
Yeah. Thank you. I've just got a couple of questions from me before I rotate the call. The bushfires in Victoria have devastated many communities across the state. What supports have been rolled out?
If I can, Chair, I would ask Dr Jill Charker as the leader of the Disaster Recovery and Resilience Group to answer that program question.
Thanks.
Yeah, thank you, Senator, for the question. Jill Charker, Deputy Coordinator General, Disaster Resilience and Recovery. As you note, Senator, from the 7th of January, Victoria had really extreme heat wave and then catastrophic fire conditions, unfortunately, with numerous fires that broke out across that state from that time. There has been a wide range of assistance provided and activated. That takes a number of forms. It includes emergency relief assistance, personal and financial counselling, concessional loans for primary producers, clean-up activities, counter-disaster operations, and restoration of essential public assets. So that goes particularly to things like roads and other public assets. Now, those forms of assistance have been made available in 23 local government areas or LGAs and then 1 alpine resort area. In addition to that, the Australian Government has also agreed to equally share or cost share a range of measures under the disaster recovery funding arrangements, and that totals at the moment $134.6 million. And those additional measures include emergency fodder support for primary producers, which obviously is critical to maintain livestock who are still with those primary producers, to support community recovery officers being engaged in affected areas and community recovery hubs being established and run. Council Support Fund, so this goes to funding directly for councils to support with clean-up and repairs to local public spaces like parks, footy ovals, etc. Importantly, primary producer grants, so grants of up to $75,000 to support primary producers with the costs of clean-up and other costs associated with reinstating their enterprises. A state-coordinated clean-up program, which was required to support bushfire-affected homeowners, businesses and community assets for clean-up. Case support to business owners, for support with case management to help them navigate supports that were available. The reconstruction of the Harcourt Cool Stores, which was a key asset in that community for storage of produce, apples, etc. in that area. Early recovery for public land and waterways. So this goes to rehabilitation and restoration efforts to support land management impacted by fires. Prolonged power outage payments for businesses. on-farm bushfire carcass disposal, and finally recovery water tank rebates programs. In addition to that, Senator, there are 2 Commonwealth-only disaster payments which were activated and remain open in relation to disaster support. One of those is the Australian Government Disaster Recovery Payment, as the Minister referred to in her opening comments, or AGDRP. That's been activated in specific localities in 16 LGAs. We're now well over 60 specific localities that it's active in. And the Disaster Recovery Allowance, which is an income support payment for people who've lost the ability to work due to the disaster event, that's been activated in 23 LGAs and 1 alpine resort as well. Thanks, Senator.
Thank you for that comprehensive response. I think there's a lot that goes into responding in emergencies that people probably aren't aware of, and the needs of the communities are so diverse as well. A quick question about the AGDRP. I'm going to use acronyms.
Yeah.
But what happens for members of the community who are still hoping to receive that package hoping for that to be announced in their suburb?
Yeah, absolutely. So as I mentioned, Senator, it is currently available in 66 localities in 16 LGAs, but that figure goes up regularly, and I'll walk you through the process to answer your question. It is the Minister for Emergency Management who's responsible for that payment. It's legislated under the Social Security Act. It is a payment that is available for people who've been seriously injured because of the event, or who have lost their homes, or whose homes have been directly and seriously damaged because of the event, or they're the immediate family members of someone who's missing or has passed away as a result of the event. The process that we go through to activate, or for the Minister more accurately to activate AGDRP in a particular locality is, first of all, the Minister has to make a determination the event is a major disaster, so clearly that's the case. She needs to determine that the event has had such a significant impact on individuals that additional Australian Government assistance is required. So, in other words, assistance that goes beyond what the state has already activated is still required to support short-term recovery needs. She needs to have regard to the context of the community in forming a determination about the number of individuals who are affected. And in order to do that, we give the Minister advice on impact. We rely on a range of sources of impact information to advise the Minister so she can form a view on whether to activate. Sources of information that we rely on include rapid damage assessment data from the state, where that's available. There can be a lag with that because, as you'll appreciate, in an active fire zone, sometimes the state authorities themselves can't access that area for safety reasons for a time. We also, though, rely on reports from councils of impacted homes. So councils can contact us directly with information they have about impacted homes. If available and where we can validate it, aerial imagery we will rely on as well, and related to that, photographic imagery if it can be geo-identified and time-stamped so we have a sense of its veracity. In the Vic Fires event, we have turned around recommendations to the Minister to activate AGDRP in specific localities within 24 hours of receiving council advice of impacted homes. We are continuing to monitor all impacts continually, and so that 66 localities currently activated, they've been activated in rolling progressive activations as recently as in the last couple of days.
Thank you for that. That sounds like a very quick turnaround time.
Yeah.
Final question from me, and it's on Queensland. The state has been hit with a monsoon, a tropical cyclone and other flooding events since December 24, and I note they're on high alert again. What support has NEMA been providing to the Queensland Government and impacted communities?
Yeah, thanks, Senator. Look, as you've noted, really significant number of events, starting with flooding, adding the former cyclone Koji into that, and then with continuation of severe weather, has had significant impacts for a number of locations in Queensland, and that continues to the current time. We have, again, worked with Queensland to activate the disaster recovery funding arrangements. They are initially, they were activated in relation to counter-disaster operations, which go to helping local governments and state agencies to undertake activities that alleviate personal hardship and distress. Also activated are costs associated with reconstruction of essential public assets. Those arrangements are activated currently in 46 local government areas, which gives you obviously a sense of the scale of this event. Personal hardship assistance has also been activated in 6 LGAs and a number of other defined localities in other LGAs. That includes things like funding for emergency hardship for people who've got essential needs for food, clothing, emergency accommodation, etc. Concessional loans for primary producers, freight subsidies are in place. And similarly, concessional loans for small businesses are in place in 20 LGAs. In addition to that, the Australian Government has agreed to cost share a number of additional measures to the tune of $66.56 million to date. That includes an emergency fodder support package, again clearly needed urgently. It was activated quickly. Primary producer grants for farmers, a specific piece of funding to support the recovery and renewal of the Cloncurry Airport, which is a key regional airstrip for access and transport of supplies in and out of the region. An additional primary producer support package, which went for additional holistic support, including financial and human counselling, feral pest and locust management, additional small business recovery grants, a mental health recovery package, noting how critical mental health considerations are in the aftermath of disaster events, and finally a community relief fund for a council to support extraordinary clean-up and make safe activities.
Thank you, Dr. Chuckett. I feel like I could ask you questions all morning about the response efforts, but certainly grateful for all the work that you're doing to support communities. I'll rotate the call now and go to Senator McDonald.
Thank you very much, Chair. And if I could just follow on from some of those responses that you're giving. So this is a reflection of my age and my eyes. Dr.
Charker.
Charker,
Yep.
Thank you very much for supporting me at this time of need. Dr. Charker, Cloncurry Airport, how much money was that amount?
Yep, I'll just get that for you, Senator. It was $11.5 million.
So that was just for repairs. It's not for the larger amount that the Cloncurry Council's been asking for the last 18 months to upgrade the strip to allow for the heavier aircraft. Is that correct?
For critical repairs to the damaged airstrip and increased flood resilience.
All right. So just so that the Minister knows, this community has been on the what was previously known as the BBRF grant round. They've done all the work. They have provided quotes. They're incredibly shovel-ready. They keep being told that every time they provide additional information that they go to the bottom of the queue again. There's something very strange happening with that. This would have prevented this money having to be spent if the capital works could have been carried out, but it's not a matter for this agency. Dr. Charker, can I also ask you, with the infrastructure betterment monies that are spent, what split is that with the state government?
So if I perhaps talk in general terms, when a state requests betterment support financially for assistance with improving an essential public asset to be reconstructed or rebuilt to a stronger or more resilient version, that is typically cost shared 50-50 with the Commonwealth and the state.
Okay. Has that always been the case, that it's been 50-50?
That's the usual case. There's been exceptions in the past, but that's the typical case, Senator.
Okay, thank you.
If I may add, Senator, and can I thank you for your advocacy for your communities. There is also, as a result of the disaster recovery funding arrangements, the change in the policy settings back in 2018, where states are able to retain efficiencies from delivery of their normal road reconstruction program as well. Those efficiencies are now being invested in betterment projects around Queensland, and the funding split on those is potentially for the Commonwealth up to 75% of the program, depending on the cost-sharing arrangements for that Category B. So there's a slight nuance there, but certainly there are two streams of funding, Senator. Sorry, Joe.
Terrific, thank you. Well, if I could turn to you, Mr Moon, and I am incredibly grateful for your leadership in this, the disaster responses, particularly with your background in Queensland. It's something that you understand very well, and I'm always heartened to know that you're on the job. I do want to consider, though, and I've got a bunch of questions that I'll put on notice around detail, but I want to consider, in 2019, when we had those horrific floods in North Queensland and lost 500,000 head of livestock, and the mental health impact on that community had the potential to have been extraordinary. But the federal government at that point made prioritised payments and structures that meant that that community not just survived, it got back on its feet and ran. I think the bit that is sometimes lost in discussions about disaster recovery is that these are the communities that may not be they may not look like the big dollar spinners, but the cattle they produce go into all the jobs in the last manufacturing industry of abattoirs in Australia, the butchers, the export dollars, the everything else. And so that's why this disaster recovery money is so important. And I want to know, after the 2019 floods and that exceptional response, has there been any work done on measuring why that was so important and why it is of value to continue replicating that standard?
So in terms of a formal evaluation of those particular programs, I'd have to take that on notice, Senator, but certainly we have learnt, and not only at a Commonwealth level but also a state level, important lessons out of that particular event and the efficacy of a range of programs. And quite rightly, you referred to those indirect impacts that impact other or affect other industries, and sort of probably one of the key lessons Minister McBain and I heard when we were on the ground just north of Julia Creek with a range of graziers, and they were more focused on the impact that their loss of their ability to trade, having lost much livestock and not being able to get to town on their roads, was going to have on the town and the small businesses attached to the town, and then by extension the schools, medical, those sorts of things. And that's why certainly in the design of the program and the learnings from 2019, obviously there needed to be put in place a range of support mechanisms to support those businesses in town, and that was the disaster relief, disaster recovery allowance for those people not directly impacted. But certainly we heard it loud and clear from the graziers that we met in Richmond, in Julia Creek itself and then north of Julia Creek, around the importance and the value and the benefit and the confidence it gives the industry that their back is covered and that they do have a path for recovery. And I've been tracking now, I've been looking at the rollout of some of those $75,000 grants at the moment, Senator, and on the surface it looks as though there hasn't been an enormous take-up. But I think one of the important lessons we learnt, and certainly the conversation I had with Mayor Wharton yesterday, is it's way too wet for graziers to actually get out on their country, assess the damage and get a contractor out or do their own work there. So those lessons certainly have been learnt. We've also broadened the eligibility for primary producers. Back in 2019, it was really very narrow, and we had graziers who, because of drought, because of their own personal circumstances, were running other businesses, trucking businesses, quarrying, a whole range of issues there, and they weren't eligible for the grants there. So as a result of the learning of 2019, that eligibility has certainly been expanded, so there's a catch-all there. And I think importantly, and I was have been speaking to, as has Dr Charker, with Queensland in recent days, and also local mayors and Cattle Australia, there will be more requests for assistance in the pipeline, and we'll wait and consider them as we would usually do.
Terrific. Well, thank you for that update. Specifically, I want to turn to the $75,000 Category D payment. One of the things that happened in 2019 was that those payments were made proactively and allowed graziers to acquit them. That was an enormous mental health relief program, and it meant that businesses like the helicopters and others that were on the ground in that immediate disaster response were able to be paid, as well as just that headspace of, I will get through this. We discovered that in the floods last year, some of those communities that were affected by both, like Winton, discovered that we had reverted back from that proactive $75,000 payment back to you must acquit the $5,000, driving your truck in, putting in invoices, lodging it again. And that had caused enormous distress when people realised that the government was no longer going to support them in the same way. I know that the government's increased that to $10,000 this time, but it is still a message that you're going to have to get on the computer and you're going to have to struggle through incredibly poor internet access and do this tough at a time when people are like, and you know this, but if I can just paint a picture for everybody else in the room, covered in sandfly bites, are glassy-eyed with the distress of seeing the stock, whether it be your children's horses, your much-loved workhorses, and the thousands of head of stock that you've lost, and the idea that the bank debt remains. You know, these are very low-margin businesses. $75,000 is not a lot of money to the government to ensure that that mental health package that the government's providing, which cannot be delivered because there's no mental health or very few mental health people in those regions, I just don't think we can put a price on the value of doing the proactive $75,000 so that as the floodwaters recede, as people walk out of the doors and confront again what has happened to their home, to their business, to their community, that they feel confident that they have a future. I don't think there's anything more that I can advocate more strongly for. I know you understand this, Mr Moon. I understand that this is not the way government normally does business, but we have a precedent from 2019. It worked. It saved lives. It absolutely saved lives, and there are men and women who are still standing because of that. I think we can do that again, and I don't understand why the government has regressed back to this heavy paperwork compliance period, which we've already heard this morning about the financial pressures that NEMA is under. You know, the compliance of having to do the paperwork over and over and over for these people rather than do it once. You know, just the efficiency of the department. So thank you for your patience, Chair. That is more my advice to you, but I am begging, Minister, that this must be reverted to that payment because there will be lives lost and mental health impacts that are immeasurable and faceless and deep if we cannot get this right. And of course, $75,000 with CPI is now worth 2/3 of what it was worth in 2019. So it's actually less valuable than it was then, but just at least the message of that. And I've run out of time to talk to you about the restocking grants, but I would ask that you turn your minds to those as well.
Senator, once again, thank you for your advocacy and the powerful picture you have painted for us. We have approach the Queensland Government, the various agencies, the Department of Primary Industries or Agriculture, whatever it is now, Queensland Reconstruction Authority, Q-Rider, who deliver the grants on the ground, and also importantly, we had at that meeting Cattle Australia to start to work through exactly what are the arrangements in place, what did we learn from 2019. I'm more than happy and I will commit to assembling that group together, and I'll certainly pass that message on, Senator.
Thank you very much. Thank you, Chair.
Thank you, Senator. Senator Cadell.
Just on your point, that what she said about mental health is so great. There's a strange analogy here. We were up there saying where the minister was, looking at some of the Brahmins, and they've got to stay on their feet and keep active, otherwise they lie down and give up. And it's so many of the farmers are similar. We've got to keep them going, otherwise they'll do similar. So thank you for that. Going back now just on, thank you for your question on notice regarding the NAC stuff from last time. I've got the answer there. Can I ask, without substance of any what the referral's about, is there a process that goes through internally as to what meets a bar to make a referral within NAC, or is that your judgment call alone? How does that process work?
Senator, thanks for the question. We do have an internal process. As part of our integrity team, we have a dedicated investigative capability who will make an assessment of a particular issue with all the information that is available at a particular point in time. We also, that's an internal capability, Senator. We also have an external capability as well. We use Deloitte to assist us with specialist investigative capabilities on occasion. An initial assessment of any complaint that is raised or any issue is then made, and it is basically, and it can involve engagement with the National Anti-Corruption Commission in terms of the thresholds for severe and systemic conduct, and then advice is provided to me in terms of has it reached that threshold, who we've engaged with, what's the nature of the allegations, and then I'll make a determination on the referral, Senator.
Okay, is that a documented or formal policy, or that's how is that managed within?
Thanks, Senator. So yes, so we do it through a very sort of, so we go through the policy, we discuss it with NAC as well, and then finally we prepare a decision minute, which is sensitive, and then we go through that process.
No problem, but the process is a documented policy?
Yeah, it's a documented, yeah.
Okay. So as part of that process, do you look at potential alternatives? That threshold point you look at internal change of procedures, you look at other things internally before we reach that process, or does that happen concurrently? What's the process there?
There will be outcomes of an investigation which are essentially an observations and lessons learnt process.
Yep.
That will inform our governance arrangements, our internal policies and procedures. And I think one of these learnings from the very early days within NEMA was the value of having an external investigative capability, Senator, given the scope and the scale of many of the grant programs that we currently manage.
Okay. Going back, and just a pitch patch, because I know time we're going to be all over the spot, going a bit on culture again. Last time we raised that the NEMA's Leaders Survey shows only 49% of respondents believe SES work as a team. You've spoken before about transitional and setup and bringing in and that sort of thing. That is still a concern that slightly less than half, I'll give you that. Is that improving? Are you seeing, even in estimates, different personnel every time acting CEOs? What is happening in the SES level? What's happening at that higher level?
So Senator, bearing in mind we are a young agency, and I accept your proposition. We are maturing as an agency. I have made in a number of estimates appearances, an observation that certainly the operational environment in which we work puts pressure on all staff, but we don't use that as an excuse. It's just a recognition of what's driving particular behaviours, what drives and informs the leadership required for this particular agency. And so we have a number of initiatives in play, not only to develop the capability of our senior leadership team, and they are all committed to this, but our SES teams and across the agency more broadly. It's going to be a journey, Senator, and as I say, our efforts are always on having a fit-for-purpose organisation where the leaders have the capability but also embody the values and the cultural aspects that we need in this agency.
Okay. And I will be a bit all over because trying to get stuff done on time. When we talk about things, one of the people that came to our office said that under someone not here to defend, under the COO previously, money was allocated on a semi-ad hoc basis to fix shortcomings. Specifically, the allegation, I have no truth about this, $7 million taken from the National Emergency Messaging Service, the education program to fund other operational goals short term. Are you aware of things like that happening? Are we moving money from one budget to another? Not you, definitely not you, it's someone else. Are we aware of the COO moving money around to different things to keep the lights on in different programs?
Look, we manage the budget holistically there, and I might ask the acting chief operating officer to get into this in more detail. But there are short-term pressures that do arise, and for example, Senator, you know, over the last 3 estimates, we've spent a fair degree of time talking about the payroll situation, and getting an understanding on that. And I made the decision that we needed to understand the true scale and scope of that because that was not clear to us. And so there will be short-term funding pressures where we do have to allocate resources that are part of our overall departmental budget to actually address some of those because they are agency priorities. I might just have Samantha talk about the allocation of funds.
Thanks, Coordinator General. So, in terms of allocation of resources, so we have a funding envelope. We go through, look at how many people are there and how supplier committed spends. So we look at all the costs, allocate it across groups. Then we work with the groups and the cost center managers to divvy it up right at the right to the cost center level. That's how internal budget works, and we have allocated a balanced budget. Then what happens is every month they go through and what the actuals are and what the forecasts are. And often when Coordinator General was referring to the pressures, the forecast often keeps changing based on the high-risk weather events. As an example, we have taken this payroll review where we had to bring in, KPMG coordinator to undertake and team from Home Affairs to assist us. So obviously, it is a pressure. Then we look at all our costs and see how we can manage the fiscal pressures. So that's how we manage the internal budget, and it is on a monthly basis. We look at it. What are our priorities? In certain instances, we might decide that we will not go ahead with a certain supplier forecast costs because that can be undertaken through another panel arrangement from another agency. Okay. So that's how we manage, because our main aim is to make sure we support the communities, we support staff during, after, and the disasters.
Okay. Keeping up with my WhatsApp messages, which are increasing the more questions I ask, can we expand the question on notice regarding the costs around Harvard to any other costs for trips to Oxford as well, if there was some there, which is an interesting one? And when we're talking about HR uplift and the changes we're doing in HR and things we're going forward, specifically, someone's come forward and said when they questioned about their payroll issues, which you addressed in some such, they were told that it is just the icing on top because it was their overtime and extra allowance by your HR department, that they shouldn't be complaining because they got paid, but the extra money was just the icing on top. That's not an attitude of a HR department that I would like to be looking after my people. Is that condoned by you?
Absolutely not, Senator. We are absolutely committed as a leadership group and as an agency to remunerating our people in a timely and a fair manner. No, it certainly isn't. And certainly in relation to the functions that our people team perform as part of this payroll review, we're actually expanding the capacity of that team to actually address some of those outstanding matters, Senator.
Okay. Looking at the time, Minister, if I can ask you a question. The Colvin report was done handed in 18 months ago. When can we expect a government response to the Colvin report? And is that imminent? Is that close, given the importance of having it done in the first place?
I'll take the specific question about timing on notice, Senator, but I would make the observation that since receiving the report, there's been quite significant reform consistent with the observations made by Mr Colvin in that review.
Okay. I'm happy if you want to go somewhere else, or I can keep going.
No, thank you.
Senator, can we just turn around back to Mr Dasgupta to finish the question in relation to funding from
additional information, I might say, yes.
Thank you.
Thanks, Coordinator General. Senator, I took a view from a departmental budget perspective.
Really?
So I would like to elaborate from an administered budget perspective. So there are two components of the budget. So when we are talking of CUPs and those sort of stuff, these are departmental budget. But if I'm looking at administered budget, we cannot move the administered budget until and unless there is a specific decision through either like a movement of funds or reallocation through Department of Finance through the proper, as per the budget process operational rules. As an example, if I am looking at NMS, and we are looking at your communications campaign, which is an administered funding, we cannot touch it. So I'm looking at departmental versus administered. So that's the administered sort. I wanted to clarify that we don't have that prerogative.
So just to follow up, so the education and communication campaign around NMS is unchanged from what it was, the budget allocation in the program?
Yep.
Okay.
So this has been allocated in the current PAYS document. You will see that.
Okay, thank you.
Thank you, Senator Cadell. Senator Cox.
Thank you very much. Just wondering if you might be able to give us or inform the committee of the projects that are being funded under the DRF rounds 1 and 2 that are directly supporting First Nations communities?
Yeah, thanks, Senator, for the question. As you'd be aware, the Disaster Ready Fund, or DRF, is the Australian Government's flagship disaster resilience and risk reduction initiative, and it commits up to $200 million per year from the Commonwealth Government side for those projects, and it started from 1 July 2023, so $1 billion over 5 years. We have actually recently concluded the outcomes of round 3 of the Disaster Ready Fund, but in relation to funding for First Nations specifically, across all rounds 1, 2 and 3 of the DRF, a total of $290.7 million in Australian government funding has been committed under those 3 rounds to 199 projects, which have self-identified as providing benefits to First Nations people. The breakdown of that is under round 1. There were 76 projects awarded, which related to more than $95 million from the Australian Government in funding. In round 2, 104 projects were funded, more than $137 million. And then in round 3, the recent round, 19 projects which were awarded more than $57 million in Australian Government funding.
That's great. Thanks, Dr. Chaka. Can you maybe just give us a bit of a status update on some of those projects, like the positive impacts that they're having, particularly on First Nations communities?
Yeah, happy to. Senator, I can give you probably three examples to go to your question. One of them was a project which was funded $11,873,520, of which the majority of that was Australian government funding. That funding was awarded to the Jabalbina Yalanji Aboriginal Corporation in Queensland to deliver a microgrid in Wujal Wujal in far north Queensland. So that funding is being used to deliver a solar and battery microgrid that will provide community-wide backup power when the ergon network connection is lost during disaster events, which obviously a critical issue for connectivity. The project currently in pre-construction. It is estimated to complete 12 December 2027. Second example, Senator, is funding of $135,269, which was awarded to the Torres Strait Island Regional Council. That was to deliver secure power access for 5 remote islands in the Torres Strait. The funding's being used to install 5 backup generators at Paruma, Dawan, Erab, Boigu and the Maubag Islands to provide emergency backup for the fuel pumps, which are operated by the Torres Strait Council, again in the event of power failure at the standalone central power stations on each island. So again, critical asset in that community. This project is in the construction delivery phase at the moment, estimated to complete May this year, end of May, 31 May this year. And finally, Senator, an amount of $381,600, all of which is Australian government funding, has been awarded to the Napranum Aboriginal Shire Council. That's to deliver the Napranum multi-purpose place of refuge, the detailed design for that place of refuge. So the funding's being used to develop, as I said, detailed designs for a multi-purpose place of refuge for extreme hazard events such as bushfires, coastal hazards, cyclones, heat waves and storms. And this project is currently in the planning and design phase, estimated to conclude end of May this calendar year. Thanks, Senator.
Thank you, Dr. Chaka, and thanks to Nima for some really important work in First Nations communities. Thank you. Thanks, Chair.
Thank you. That concludes the questions we have for you this morning. Thank you for your time, and you are now released with the committee's thanks. We'll take a very brief suspension while we welcome the Department of Home Affairs, Cross-Portfolio, Corporate and General Matters to the table. Okay, thank you very much. I welcome Senator the Honourable Murray Watt, representing the Minister for Home Affairs. I also call officers from the Department of Home Affairs in relation to cross-portfolio, corporate and general matters. Minister, would you like to make an opening statement?
No, thanks, but good to see you all.
Music to our ears this early in the day. Ms Foster, I understand you provided your opening statement to the committee, and I'll table that, but also invite you to speak to your opening statement as well.
Thank you, Chair. Since we last met, Australia has been shocked to its core by the devastating terrorist attack against Australia's Jewish community at Bondi. Our thoughts remain with the families, friends and communities impacted so horrifically by this attack. Home Affairs staff have worked tirelessly since 14 December to respond to the tragedy. They've engaged with the Jewish community to understand its needs. They have prioritised visas for families and loved ones. They've organised immediate financial assistance to facilitate medical treatment, family reunion and other essential needs. They supported the finalisation of the government's response to Ms Siegel's report and commenced the rollout of anti-Semitism training recommended in that report. In close collaboration with colleagues in Attorney General's Department and others, they were integral to the successful package of the Combating Anti-Semitism, Hate and Extremism bills on criminal and migration laws and on firearms and custom laws. And of course, they're now working hard to support the Royal Commission on Anti-Semitism and Social Cohesion. I want to acknowledge also the work of Australian Federal Police and Western Australian colleagues in response to the failed terrorist attack against the 26th January Invasion Day rally. Again, our thoughts are with our First Nations colleagues and all who joined that rally who have a right to protest without risking their lives. Much else has been achieved across Home Affairs since we last appeared in early December, but today is not the day to detail these achievements, with our focus rightly on the terrorist attacks described above. But those staff who have continued to progress outcomes as diverse as countering violent extremism programs, cybersecurity, expedited access to the US for Australian citizens, enhanced citizenship processing, combating migrant worker exploitation, illicit tobacco and prohibited drugs, should be in no doubt that their efforts are seen and greatly appreciated. Thank you, Chair.
Thank you, Secretary. We'll proceed to questions and begin with Senator Duniam.
Thank you, Chair. Thanks, Secretary, for your opening statement there. If I can just start with a line that was in the Special Envoy on Anti-Semitism's plan, which referenced, in particular, public servants having access to training to recognise and address anti-Semitism in public settings. That's part of Gillian Siegel's plan. I just wonder, has the department put in place any settings or is in receipt of formal training arrangements for officers of the department when it comes to anti-Semitism?
Yes, we have and we are, Senator. And so in immediately before the Christmas period, we commenced anti-Semitism training with a group of our decision makers, visa decision makers. There were two components to that training, an online self-paced module and then a 90-minute session facilitated by an expert from the Sydney Jewish Museum. And that was obviously targeting a group of people who are making decisions where anti-Semitism could be a factor in their decision-making. We then, over the course of a couple of weeks in January, rolled out the same training to a pilot group of our senior executive service officers with the same format, the online sort of self-paced introductory module and then a 90-minute session with the facilitator.
And so both the online module and the session with the individual, the facilitator, were works provided by the Sydney Holocaust Museum. Is that who you said?
It's the Sydney Jewish Museum.
Sydney Jewish
so
Museum.
we've worked very closely with Ms. Siegel in the development of that training. She has been both very keen to assist us in the design of that, and also very helpful in the segment that we're doing with the Sydney Jewish Museum. We and they are using that as a chance to give feedback. So at the end of each session of the SES groups, and I think also of the decision makers, people were asked to provide any feedback on what was resonating, what did or didn't make sense to them, how it was assisting them to understand the implications, the impact of anti-Semitism in their work, and then we have watched the facilitator adapt that presentation in response to the feedback.
So you said there were two groups. There was in the lead up to Christmas, post those terrible events on the 14th, and then another group in January. How many, did you say decision makers in the visa area? Is that the, yes?
I did, Senator.
Okay, and how many officers from that area participated in that training?
Thanks, Senator. Claire Sharp, Head of Immigration. So prior to Christmas, we had 48 officers from Immigration Group participate in the training, who were those, a sample of our visa decision makers and some team leaders, so more junior levels in our organisation.
A sample of. So how did you decide on the 48 that would participate in the training?
We picked decision makers. We picked visa decision makers who were available at the time, and some team leaders, because often you can understand in a more complex visa case, it's the team leaders who particularly need to have a good understanding of balancing more complex cases.
And of the 48, how many were team leaders?
I'd need to take that on notice.
Okay, and obviously the other element was availability, understood, given it was probably short notice. How many visa decision makers are there in the department?
I'd need to take the precise number on notice, but it's in the order of around 3,000. So I think it's important to emphasise what we're doing at the moment is a pilot. We're in a design phase, working with, as Ms Foster has said, the Sydney Jewish Museum and the Special Envoy, so that we get the package right and we can bring it to scale. So hence why we're selecting different levels of the organisation and different skill sets to test out the training packages on.
Sure. And can I ask, that number 48, did that relate to both rounds of the training? So
No.
48 is the pre-Christmas
That's right.
and the January session?
So over the course of January, and as at the 6th of February, we've had 81 senior executive service officers complete the pilot training. That includes a couple of officers from the APSC and PMNC, but the vast majority are Home Affairs.
Right, okay. And none of those were included in the 48 from
No.
so that's in addition to. Okay, and are further rounds of the training planned?
Yes, that's right. What we're aiming to hit is about 200 staff in total. So the 48, the 81 plus another group over February to complete the pilot, so that we get that range of perspectives and job roles interacting with the training, and we're confident in the packages before we commence the full rollout.
So given the plan was received by government, I think it was in July last year, were efforts made on receipt of that plan which made these suggestions to initiate this training or seek it out, or because obviously pre-Christmas is a difficult time to do anything, or was it something that was commenced after Bondi?
No, Senator, we had been speaking with Ms Siegel for some time about the training. As you'll understand from Ms Sharp's evidence, it took us a little while to work out how we could approach the challenge of such a large workforce, and our desire and Ms Siegel's desire to have the training be really meaningful and impactful. So typically with a workforce of our size, if you want to put everyone through something, you do an online package that that is easier to administer, but may not have the sort of impact that we wanted it to have in this case. Clearly, we expedited that first round immediately after the Bondi attacks, but we had been working to that point for months.
Months, okay. And when do you intend to have a program in place that can be rolled out across your entire workforce as required?
We're working with the Special Envoy and the Sydney Jewish Museum on that. As the second module of the training does involve a facilitator, and as I've alluded to, we have a large workforce. So the exact timing will be partly driven by capacity on their end to start delivering at scale, but we're certainly working to do it as expeditiously as we can.
Do you think this calendar year you plan to have it all done?
Oh, absolutely, yeah, Senator. I would say, you know, it will take us a little while to evaluate and plan how to roll it out, a little while to develop the contractual arrangements, because at the moment the Sydney Jewish Museum is doing this on a pro bono basis in order for us to establish an appropriate package. And so we'll have a little bit of time, but we will not waste any time. We will do those processes very quickly, and then we'll start the broader rollout.
Sure. Then two questions I'll wrap into one. Has any officer refused to participate in the training? And is training going to be mandatory, or is it a voluntary exercise for officers of the department?
So, Senator, no one has refused to do the training, in part because we have approached people to opt in to it at this stage. One of the things that I'm very conscious of is that for different folks coming from different perspectives in the organisation, for example, for our Jewish community, the training could be quite triggering. And so I'm trying to be really sensitive about how we approach the question of who does it and when they do it. So when I did the pilot with our SES group, if I think about Ms Sharp's figures, that would be about half the SES group who opted into the very first pilot. So I'm not anticipating a problem with willingness, but I am going to be really sensitive about how I roll it out to all staff.
Okay, and so just on a final clarification, so no intention to make it mandatory training?
I haven't yet made that decision, Senator, because I'm trying to work through how I can achieve my joint goal of having all staff who are, for example, in senior leadership positions or making decisions where this is important, complete the training without putting people into situations that are uncomfortable or traumatic for them. And the other thing that's on my mind, and this is getting a bit more esoteric in terms of training philosophy, is that there is a particular reaction that you get to mandatory training that causes a resistance. If I can get the outcome that I want without triggering that reaction, then I will do so.
Yes. Thank you. Thanks, Chair.
Senator Shoebridge.
Thanks, Chair, and nice to see you, Secretary.
Thank you, Senator.
I asked, I think through you, your department, on the 4th of November 2024, we're talking, a question about the breakdown of people seeking asylum who've been transferred to Australia from offshore detention. That question is now 1 year and 3 months. It's been waiting 1 year and 3 months for an answer. It's SE 24358. How do we wait 1 year and 3 months for an answer just about some basic data of people who have been transferred out of this country?
Senator, Mr Hickey may be able to help me with the status of that question.
Morning, Senator. Brian Hickey, Acting Deputy Secretary Executive. The team is just getting that information for you, but I understand that is with the Minister's office at the moment, Senator.
And when was it sent to the Minister's office?
I'll get that information for you, Senator.
All right, so we can expect an answer?
Yes, Senator.
All right. A year ago now, I asked questions about Secure Journeys and MTC, Management Training Corporation, that global jailing bottom feeder that this government has given multi-billion-dollar contracts to jail people in the country. I was going to ask some questions about that today, but then I was shocked to see that we still have questions unanswered from February 2025. This included about ABF's awareness about the solitary confinement of Carlos Vega by MTC US, questions about the department's knowledge of multi-$100 million settlements for bribery that MTC had to pay before entering into the contract. A year ago, I asked these questions. Why no answer?
Senator, if you have the numbers handy, we'll be able to check them quickly.
25091 from the 24th of February. That was about, the awareness of the department and ABF about the unlawful solitary confinement of Carlos Vega in the United States. A25010. Sorry. We'll come into that one next. A25089, about whether or not the department knew about the $712 million in damages that MTC had to pay because of major fraud, bribery, kickbacks and misrepresentations and concealments. Why are we waiting more than a year to find out whether or not your department did due diligence about the notorious corruption of this entity before you entered into a contract? Why does that take more than a year?
So, Senator, again, we'll check the specifics of those questions, but I think of the group from February 2025, all but 3 have been progressed by the department.
Are they with the Minister then?
They're either with the Minister or they're lodged, Senator.
All right. Well, I have more than 3 awaiting answers, but would it be possible to get an answer on that today?
We're checking as we speak, Senator.
Thank you. And then there are a series, I said more than a year, it was 24 February, so it's slightly less than a year. Also on the 24th of February, I asked a series of questions of your department about the Dural Caravan incident, which included when the department knew matters, any calls to the national hotline, when the department knew that the allegations about explosives were true or false, and indeed also to you, Minister, about your personal knowledge of matters. Almost a year now, we still don't have an answer. Is there an explanation?
Senator,
I'll give you the numbers.
Thank you.
A25010, A25011, A25012, A25013, A25014.
So, Senator, we will check those last group, but I can tell you that all 4 of the first nominated are with the Minister's office. The first was sent on the 6th of December 2024, and I'm just checking the dates that the others were sent.
Well, once you clarify that, the department's actions, and perhaps you could explain the 10 months it took to get those answers. Perhaps then, Minister, once we have that, if the issue is it's been sitting with the Minister who is refusing to provide the accountability, we might address that through both you, Minister, and the department once we find out what's happened.
Happy to do that. I mean, as I've pointed out before, there has been an absolute explosion in the number of questions on notice asked in this parliament and the previous parliament compared to previous years. I think it was 1,700 questions on notice were asked at the last estimates session. So, I think you'll find that the data shows that this minister and this department has responded to well over 90% of the questions of notice that they've been asked. But senators need to take some responsibility also for the sheer number of questions that are being asked.
Minister, these were questions about one of our federal security agencies' knowledge of a high profile. It ended up being a hoax terror incident that created enormous unease and indeed led to some knee-jerk legal reforms in New South Wales. These were questions that relate to the department's knowledge about notorious $700 million bribery settlement payments that had to be made by a US prison corporation that the department then entered into a multi-billion-dollar contract with. These are matters of significant public interest and they deserve timely answers.
Well, with respect, Senator, every senator thinks that their questions on notice are important and are significant, and I'm sure that they are. But the sheer number of questions on notice that are being asked of ministers and departments takes time to resolve, in addition to the other very important work that this department does.
But we'll come to some of the other outcomes for the department in a bit. These are matters of significant public interest. There's an obligation under responsible government to provide these answers, and just simply saying there's a lot of questions is not an adequate answer.
No, what's different is the explosion in the number of questions that has occurred this parliament and the previous parliament. I remember this because when I was in opposition, we were much more responsible about the number of questions on notice that we asked. So, for example, the figures I've got are about the oppositions, but the same principle applies to Greens and crossbench questions as well. In February 2022, when we were in opposition, 104 questions on notice were asked at the estimate session for Home Affairs. By 2023, it had jumped to 622. February last year, 967. So if senators are going to be, frankly, over the top with the sheer number of questions on notice that they're asking, that's going to take some time to answer them all.
And Minister, you well know that multiple civil organisations, the Centre for Public Integrity and a variety of other civil organisations have analysed your government's lack of transparency in FOIs, in answers to questions on notice, in responses to orders to produce documents, and across the board, your government is failing on transparency, not according to my metrics, but according to the metrics from incredibly credible organisations like the Centre for Public Integrity.
And with the respect to those organisations who I know attempt to prosecute arguments about transparency, with respect to those organisations, it is never acknowledged by them, by you, by opposition senators that the number of questions on notice has exploded, that the number of orders to produce documents has exploded. So government officials do everything they can to respond to those matters in a timely fashion, but if senators collectively are going to jam up the system with ridiculous numbers of, No, but why was it possible for the Labor opposition to ask 104 questions on notice and this opposition asks 967, nearly 10 times the number? I mean, you clearly don't have the capacity to read them all, the answers, because you're too busy doing the numbers on each other. So how about you be a bit more responsible?
Well, these are about these, Minister, these, I'm asking you questions, not about the opposition.
Sorry, Senator Shoebridge. This seems like an appropriate juncture. We are past our 10:30 mark for morning tea. So I'm going to call a morning tea break now and we will resume at 10:46. Excellent. All right, we will resume with cross-portfolio. Senator Scarr.
Thank you very much, Chair and Secretary. Good to see you, Minister. Secretary, can I just first thank your staff who are involved in the huge task in bringing together that combating anti-Semitism bill, the initial omnibus bill, and then had to engage in the task of splitting it out and dealing with amendments, including requests from various parties. It was a huge effort, huge amount of material. So I just want to place on the record my appreciation for their efforts, especially during that time of the year. If I could do that.
And thank you also for your comments while the bill was being debated. It meant a lot to the folks working on it to see that kind of recognition across Parliament.
Well, it's meant because it was quality material that was produced. I've just got one area of questions in cross-portfolio. The Prime Minister on 30 December 2025 cited actual experts and current experts who advised against a Royal Commission following the deadly terrorist attack in Bondi. I just want to ask you, Secretary, whether or not you or anyone in your department actually provided any advice to the Prime Minister prior to his making those comments on 30 December 2025 as to whether or not a Royal Commission should be convened.
So, Senator, there is a sort of straightforward answer, which is no, I did not personally provide formal advice to the Prime Minister on that topic. We did have a number of discussions, both between my minister and me. Obviously, there were discussions within broader groups of ministers and officials. But the nature of that advice is not something that I would normally comment on publicly.
No, I appreciate that, but when the Prime Minister was referring to actual experts and current experts, from your perspective, he wasn't referring to you?
So, Senator, I wouldn't presume to say what was in the Prime Minister's mind, who he was thinking of when he said that. The sort of question of the provision of advice to the Prime Minister is really one for Prime Minister and Cabinet.
Sure. Can I ask then, was the Department of Home Affairs or were you asked to give advice with respect to whether or not a Royal Commission should be established or not established prior to the Prime Minister making those comments on 30 December 2025?
So, Senator, I don't think I have anything to add to my first answer, which was there were a number of discussions around the topic.
Okay. And who was involved in those discussions?
I've said, Senator, that I had discussions with my minister and that there were discussions between ministers and officials.
Okay. Anyone else in your department, or were you the one who was really the one who was having discussions?
It would primarily have been me, Senator. If any of my officials have anything to add, I'll invite them to come to the table, but okay. I don't believe so.
All right. Okay. Thank you. Thank you.
Thank you, Senator Scarr. Senator McCallum.
Thank you very much. I'm just wanting to check that I'm in the right part of the agency to be asking this question about border enforcement and illegal fishing boats.
So, Senator, we will cover that in outcome 3 towards the end. I think it's scheduled for late afternoon.
I will come back for that. May I ask you another question then? I want to ask you about your enterprise bargaining agreements and the arrangements in place, the process in place for allowing employees to request not to work on public holidays.
Certainly, Senator. I'll get my Chief Operating Officer to come up and help us with this.
My question is, when somebody, I want to ask first, under the department's EBA, are people able to swap public holidays for other days?
So Senator Charlotte Tressler, Chief Operating Officer, yes, we do allow staff members to swap public holidays, and I have our Chief People Officer who can explain a bit more about how that works if you would like to hear that.
Good morning, Senator. Tiffany Blight, First Assistant Secretary People. So yes, as Ms Charlotte Tressler said, we absolutely allow people under our enterprise agreement to swap out and do different arrangements on those public holidays.
Do they have to provide a form that says it's for cultural reasons or religious reasons, or just because they'd prefer to work that day?
That's correct. They don't have to provide a reason.
You don't have to. Is there any policy settings that would allow or prevent employees from saying, I want to roll up the 10 and a half or 11, however many public holidays we're up to, into a group and have 2 weeks off in July, for example?
I might have to look into that, but my understanding is they can just make arrangements for the particular day.
Right. I'm particularly interested to find out how many employees have chosen to work on public holidays over the last 12 months. I wonder if you'd be able to provide me with that data.
I don't have that full data with me, but certainly I can take that on notice. But I do know for the Australia Day holiday, we had 35 staff with arrangements in place.
Right. Do you know if you've had requests to work Anzac Day this year?
I imagine we would have had those, but I will have to get the number and take that on notice.
Okay.
Noting that it's a Saturday this year, as we discussed yesterday.
Well, as we did, Minister, thank you. I guess where I'm going with this is particularly Anzac Day is a day that's gazetted by the government in order for Australians to mark a significant day in our history. And I'm curious as to, if you choose not to mark Anzac Day, why then you get to have another day off? Because that is the day. I don't expect you to answer that, sorry. That's obviously would be an opinion that you don't need to answer, but that's where I'm getting at. I appreciate that you may not be Christian and you may not want to celebrate Christmas Day or Easter, but I do think as days of national significance, then why does the government then just not gazette it if people don't want to take it? I want to know what protocols are in place for supervision for tasks and reporting. Imagine if you're in a part of the agency where the phone doesn't ring, or how do you manage staff, what they do on those days?
So, Senator, you're talking about staff who choose to work on a public holiday?
Yes.
So it depends very much on the nature of the work being undertaken. So if you are a visa decision maker, then you will work to a broad metric of how many decisions are made of a particular type or complexity. And so there is an inbuilt supervision measure for those kinds of work. But broadly speaking, as you can imagine, with a workforce that works across the country in dispersed ways, does some working from home, some in the office, for people to be working on a public holiday is not a particularly novel thing for us to manage, and so the standard management practices which teams have in place would cater for that circumstance as well.
Okay. Do you encourage employees to work from home on those days? Is the office open?
So, Senator, our offices are always accessible. There will clearly be issues that we will always take into account, like workplace health and safety. But again, because we have this dispersed workforce where teams can be spread amongst multiple cities, it's not the kind of environment that I grew up in where everyone went to the same place every day and sat with the same team. It's sort of the management arrangements are fundamentally different now.
I understand that. So you are quite happy if on not a Saturday but on another day, if people were choosing to work on a public holiday, that they can go to the office and sit there in solitary splendour?
Senator, for me that would be not different to them choosing to work on a weekend and choosing to go into the office. clearly some of our staff need to work in an office because of the security requirements of what they do, but we tend not to be prescriptive.
Terrific. All right. Well, on notice, if you could provide me with that data of how many staff over the last, well, let's say 2 years, just to get a scale, and how many have requested the forthcoming public holidays.
We will do, Senator.
And the policies on if you can roll up all your public holidays into one batch and that sort of thing. Thank you. Thanks, Chair.
Thank you, Senator. Senator Roberts.
Thank you, Chair, and thank you for being here again. My questions are to illicit tobacco and e-cigarette Commissioner.
Senator, the illicit tobacco e-cigarette Commissioner appears in outcome 3, which is scheduled, I think, around mid-afternoon.
Outcome 3?
Yes, Senator.
Okay, thank you. Thanks, Chair.
Is that your questions, Senator?
Yes, it is.
Excellent. Senator Mackenzie.
Thank you so much. Good to see you, Ms Foster. I have some questions about the National Firearms Reform and the National Firearms Agreement, and I've been told outcome 1 is appropriate.
So I'm not sure that we have moved to outcome 1 yet. Let me just check with the Chair.
Wait, Chair, we're just confirming we're still in cross-portfolio, aren't we?
Sorry, yes.
Well, this has cross-portfolio aspects. It's about, obviously...
Nice try.
The government's...
Outcome 1 is the next...
Been disappointed.
Outcome 1 is
the
the next
government's
outcome.
response to the terrorist attack in Bondi with respect to changes to firearm regulation, which doesn't just include Home Affairs, obviously AFP, etc. So we'll have a hit off, and
so
I have a raft of other areas, the gun buyback scheme, etc., and the register, which I understand will be later on in the program. But this is more, this suite of questions is more cross-portfolio. Following the Bondi terrorist attack, at what stage did Home Affairs first provide advice to the government to implement changes to our firearm regulations?
That's clearly an outcome 1 question. And honestly, outcome 1 is the next outcome. So you won't have to wait long to be able to get into this issue in detail. If you've got any other cross-portfolio questions, you could knock them off quickly and we'd be into outcome 1.
So, yep, sure.
And Senator, what we, I think, agreed with the committee is that we would handle all questions relating to Bondi in outcome 1, no matter where they fell, so that you could get
Sorry,
a
I missed
coherent
that at the start.
picture rather than having to
segment.
Yep.
Thank you. Appreciate it.
All right.
So are we done? Thank you. Senator Dunningham.
Thanks, Chair. Thank you very much. If I could go back to matters corporate.
How novel.
Yeah, I thought I'd give it a stab. The changes to the makeup of the department, which have been the subject of some commentary recently, the machinery of government changes, I just wonder if I can understand the rationale that was in place when the AFP, the ACIC and ASIO were moved out of Home Affairs. I mean, is that... I'm not sure if you were Secretary at the time, Ms Foster, but...
I wasn't, Senator. I mean, I can say broadly that that was a decision of government and that the department typically role is to implement that decision when it's made by government, and so the rationale is typically one for the government rather than for officials.
What I can...
Yes.
We traversed this extensively at the time, Senator Dunningham, and I recognise you weren't on the committee at the time, but you'd obviously be able to get chapter and verse on the rationale for that from those estimates transcripts. What I will say is that, you know, the security environment Australia faces is constantly changing. The government bases its decisions, whether it be on machinery of government operations or other policies and programs based on the security environment we face at the time. Those transcripts would take you through the rationale at the time. We've also since traversed the decision post the recent election to bring some of those agencies back into Home Affairs. In shorthand, again, the answer is that we respond to the security challenges we face at the time. you would be familiar that even on your side of politics, there's been different views at different times about where these agencies should sit. The former Attorney General, George Brandis, he supported the decision the government made to move agencies out of Home Affairs. Other figures from the Liberal Party have supported the change to move them in. But from the government's perspective, it's really about responding to the security environment we face at the time.
Sure. And so why don't we skip to the reversion, the bringing back in, which I acknowledge you say was traversed probably at some length in a previous estimates hearing. So you talk about security advice and information at the time. I mean, was there an analysis of perhaps a risk-benefit or similar analysis undertaken at the time the decision was made by government to bring those agencies back in?
I think what I said was that we responded to the security environment at the time. I don't think I said that we responded to security advice, so I'm not suggesting that advice was provided about that. As Ms Foster mentions, these are decisions of government, as in ministers. The government made an assessment after the most recent election about what was the most appropriate machinery of government arrangements in this space and acted accordingly.
So was any advice received about what was the best approach with regard to the makeup of these agencies?
I would need to take that on notice. Again, I suspect we've provided answers to that in the past, but again, I acknowledge you weren't a member of the committee at that point in time.
Yeah, okay. All right.
The other thing, Senator Dunham, Ms Foster's just reminded me, machinery of government arrangements are really the province of Prime Minister and Cabinet because they're obviously a Prime Minister's decisions. It may be that I think that those issues have been raised in PM&C estimates previously as well.
Sure, that's fine. I can pick them up there at another time. If I can go to the Office of Social Cohesion, please, and its establishment. And so what date did that office commence operation?
Senator, I'll just get Mr Hickey to come and help me with the data.
Sorry, Senator, I'll get that for you shortly.
No, that's fine.
While he's looking, I'll chance my arm and say I think it was somewhere between 12 and 18 months ago.
Okay. While we're looking for that, what does the office actually do?
So, Senator, if I could step back from that question a little and then get to the specific answer. The inputs that go in to any approach to social cohesion are extremely broad and not contained clearly just to Home Affairs. But even across Home Affairs, there are a number of our functions that contribute to that. Part of the reason that I set up the Office of Social Cohesion in the way that I did was to recognise that what I needed was an entity that would coordinate those activities across the organisation, because it can be anything from activities prosecuted by our Office for Multicultural Affairs through to programs run by our Countering Violent Extremism team. I made the point that it's obviously not confined to Department of Home Affairs, and so the officer's role is to coordinate the activities of the various areas in Home Affairs, but also to engage with other Commonwealth departments, with state and territory governments, with local governments and with community, because each of those components will play a role in contributing to social cohesion. So, for example, one of the things that the Office for Social Cohesion supports is a Secretary's steering group across the Commonwealth, where we have, I think, 9 secretaries who come together to discuss how we can use the programs in their portfolios to contribute to the broader goal of social cohesion. That could be anything from what the education department is doing in terms of curriculum, what the sports, what the Department of Infrastructure and everything is doing in community sports programs and everything in between. And then, as I said, they're engaging with their state and territory counterparts who all have similar programs and activities to look for opportunities for us to work together to leverage each other's programs. And then, of course, there's the community angle. And so I can think of one example where the office has worked with a community that was engaged in a friction internally, worked with them to help provide some tools and mechanisms to have some respectful conversations about the issue and try and come to a resolution. So it's everything from supporting the policy work of secretaries in Commonwealth departments through to engaging at a community level.
Sure. And did we have that date?
Sorry, Senator, it's the 4th of September 2024.
4th September 2024. Okay. Can I ask then, how many staff were allocated to that office back at that time in September 2024, and how many are there today?
It's about the same, Senator, so I think it's about 15.
Oh. Go around? Sure, okay. Around 15, did you say?
And again, a very deliberate choice on my part not to have the work of each of the components done in that area, but to have them as the coordinating mechanism.
Okay. Given I'm at time, I'll come back to next chapter on this. Thank you.
Thank you for your assistance, Senator Dunny. And Senator Shoebridge.
Thanks, Chair. I have some questions about the ANAO performance audit of major government entities, which was delivered on, I think, the 5th of February this year. It has scathing findings about Home Affairs. Have you read the report, Secretary?
I think I read it, Senator or Mr Hickey. Sorry?
On Thursday, Senator. It was handed out on Thursday, yes, Senator.
Beg your pardon?
No, Senator. I understand it was handed down on Thursday and it's not yet come to me.
All right. Well, I'd urge you to have a good, hard look at it because the results for Home Affairs, only one department has a worse record of not meeting its performance results, which is Veteran Affairs. Did you get a briefing, Secretary, at all on just the sheer number of failures that the Audit Office has found for Home Affairs in this audit report?
So, Senator, Mr Hickey's just reminding me that we traversed at length with Senator Scarr in December the outcomes against our performance reporting, and I won't rehash that evidence now so I don't waste the committee's time, but in essence there are a number of reasons why some of those targets were not met. Right. In some cases they were genuine failures to meet the target, in some they were technical reasons, and in others it was the way in which the target was framed, which didn't actually reflect the reality of the outcome. And so that's all in Hansard from December.
Well, of course, I'm asking you about the ANAO report and their conclusions, which are from February of this year. So,
yes, Senator, but they're drawing on the report.
Well, that may well be the case, but I'm putting to you the ANAO conclusions and their assessment. And with all due respect to Senator Scarr, I give, I don't know about you, but I give significant weight to the ANAO's conclusions. 42% of Home Affairs performance targets were not met. Another 13% were only partially met. Second worst performance from any government department of the major government entities reviewed. Your answer, Secretary, is that, the targets were wrong. Is that right?
No, Senator, you've paraphrased incorrectly what I said. We are working very closely with the audit. We are one of a number of entities going through a rolling audit program on a new way of approaching performance targets. There is significant complexity, as you know, in our portfolio, both in terms of scale and scope. And it's been very much a journey for us as we've worked with ANAO to develop the targets and to report against them. As I said to Senator Scarr in December, I'm not concerned about actual performance. I can see where we need to lift our performance against specific things, and I can see where we need to change the way we're approaching targets, and we are on track to do both of those things.
You're not concerned about actual performance?
Senator, I said I don't believe that the findings are reflective of our actual performance, and I traversed that at length in December.
Well, here's what the here's what the Audit Office found as at February, just a week ago. In relation to Home Affairs, sources of information and methodologies that do not support reliable and verifiable reporting of results. There were instances of methodologies not being followed or being changed, key terms and definitions not being identified or inconsistently applied, poor record keeping and incomplete or inaccurate populations underpinning results. You're not concerned by your performance, even though they're findings from the Audit Office?
Senator, all of those issues were traversed in December because the audit report in February is drawing on the annual report which was released late last year. And I was very clear as I covered this with Senator Scarr in December that we have areas where we need to improve the way in which we are capturing data. In some cases, the kind of requirement that ANO has is not something that we could reasonably do, and so we are working with them on what would be a more appropriate target so that we can meet their technical requirements and have a meaningful, measurable target. The point I was making to you is not that I don't take the findings of the ANAO very seriously in terms of how we go about the measuring of our performance. The distinction I'm making is that when I dig underneath each of those things, the actual performance in most cases is doing fine. I just need to make sure that we continue to work with them to get the technical parameters right.
It's a remarkable statement to say that everything's fine when you're the second worst performing department, and when on critical measures like ensuring 90% of high-risk detention-related recommendations identified through internal and external scrutiny are actually completed, and you failed to meet that. You failed to meet a target where the number of critical incidents per 1,000 detainees in immigration detention remains comparable or decreases. You failed to meet that. You failed to meet targets to ensure that error rates for visa and citizenship decisions are subject to quality management activities and don't exceed benchmarks. And yet you sit there and say to this committee, and through us to the Australian people, you've got no concerns about performance.
Senator, again, you're paraphrasing me. We traversed in December many of the questions that you've just raised, and in one of those cases where you were just talking about incidents in detention, if you look at the transcript, you'll see that I did absolutely express my concern about us not meeting that target and talked about the significant effort that we've been making to ensure that we do. What I'm saying is that overall, I am confident that the department is performing strongly.
Failed to meet targets on on even maintaining capacity in detention centres, failing to meet targets on providing basic health facilities in Nauru. How do you explain that? Failing to meet the targets for basic health facilities on Nauru.
Senator,
you didn't. I have a message from my team. You didn't address any of this in December. How is it that you're failing? You're implementing a policy to pump more and more vulnerable people into Nauru, and you're failing to meet even basic targets on health delivery in Nauru.
So, Senator,
we should be fine with that too?
It is incorrect to say I didn't cover the issues in December. We did absolutely cover the issue of detention, which is the one you had raised in your earlier question. If you would like me to cover the issues
my earlier question was about onshore detention.
Could I please finish?
Not about your offshore cruelty.
Senator Shoebridge, we will let the Secretary conclude her response before we interrupt.
If you would like me to go to that specific performance measure, Senator, if that wasn't covered in December, then I'll ask the relevant officers to do that in the relevant outcome.
Thank you.
Well, I'd like you to answer all the questions about a February audit report and not hide behind questioning that you received from another senator.
Senator,
and that's a reasonable expectation, and we'll come back to this until we get some answers.
Thank you, Senator Shoebridge. Senator Duniam.
Thank you, Chair. So back to this matter of the Office of Social Cohesion, roughly 15 staff. I just wonder, have you got a list of key achievements that have been brought about as a result of the work of the Office of Social Cohesion in that time of its existence?
Senator, I can give you some of the achievements they've done since establishment in September 2024. They've done a range of programs, as Ms Foster said, across different stakeholder groups. The Libraries as Community Cohesion Hubs project, which was in partnership with the Australian Library and Information Association, I think around 215 libraries. The establishment and expansion of the Australian Resilient Democracy Network, that was formalised through an MOU with the Australian National University. A significant youth engagement program through a civic engagement youth advisory group and a social cohesion youth reference group. As Ms Foster has already said, the Secretary Steering Group on Social Cohesion. They've sponsored 2 GovHack challenges in 2025. One was on bridging social divides to bring people together to strengthen social connections, and one on connecting new citizens to Australian democracy. They've also worked closely with the SBS television station on a series called Examining and Understanding Hate. That's a series of podcasts and short videos. They're just some of the work that's the office has undertaken, and as Ms Foster said, a number of other achievements working across different communities and engagements at the local level.
Okay, so how do you measure the success of the office and indeed those projects it sponsors and organises?
So, Senator, I think, as I said at the start of your last set of questions, social cohesion is an enormous subject which touches on many aspects of our society and many aspects of public policy and programs. And so our early efforts, and I think that was right, that's about 18 months of operation. I think what we've seen is a range of activities trying to pull out the things that will make most difference. The next phase will clearly be us needing to evaluate and feed that into our future work plan, and we're in the process of developing that at the moment.
Thank you very much. I've got some questions I'll put on notice for corporate. Thank you.
Thank you for your assistance, Senator Duniam. Senator Shoebridge.
Thanks, Chair. The audit report says that Home Affairs failed to meet the target of 80% of policy advice provided to government was assessed by stakeholders as being high quality. So we know you didn't meet the target where 80% of policy advice had to be assessed by government stakeholders as being high quality. So we just get a fail there. But what was the percentage of advice, policy advice provided to government stakeholders that was assessed as being high quality? Was it 1%, 5%, 50%?
So, Senator, this was a subject that we talked about at length in December, and I can summarise that discussion for you. There were 3 elements to that metric. We needed to meet all 3 to achieve the target. We were short by a very small amount on one of the 3, and that related to impact. And in terms of the impact, the finding was not that the advice was not impactful, it was that we didn't have an effective way of measuring that impact. And so we've worked with the ANAO to make sure we have a more effective measurement for that.
What was the percentage? The target was 80%. What was the percentage that was met?
The percentage was 52.94%. 52.94%, Senator.
Well, you see, that answer from Mr Hickey throws a very different light on your answer, doesn't it, Secretary? The target was 50%, was 80%, and barely half of the policy advice provided to government was assessed by stakeholders as being of high quality.
So,
those 2 answers don't fit well together, do they, Secretary?
Well, Senator, I'm trying to explain to you the complexity that lies behind the simple target, and
why almost half of your government stakeholders said your advice wasn't up to scratch.
That's not correct, Senator. That's the headline metric that you're reading out. But when you go underneath that, we had set the target as achieving a score of at least 3 out of 4 across 3 separate quality criteria. And we met those in both influential and informed, and we failed by a small amount in impactful. And as I said, we need to make sure that we've got a better way of evaluating impact in order to meet that criteria. And so there is much more meaning in what lies underneath the top line metric than there is in the metric itself.
Oh, you see, Secretary, in some ways I admire your effort to put this spin on it. But when the target is 80% of policy advice being assessed by stakeholders as high quality, and the actual outcome is 52.9%, all the spin in the world is not going to square that circle.
We've got a point of order.
I think we're all used to the disrespectful way that Senator Shoebridge treats public servants in estimates hearings, but I would ask him to refrain from being openly disrespectful to public servants. He can ask his questions without the sneering disrespect of the last question.
Well, I utterly reject the minister's position, and it's his usual. Usual. Murray Watt behaviour.
Do you mind? I think the minister is referring to comments you made about the
spin.
Yes, and I do think that it's inappropriate to refer to witnesses' answers in that way. I think you can refrain from asking questions that refer to witnesses' answers in that way.
And just on the point of order, Chair, if I may, I asked a number of questions to Secretary Foster in relation to this particular issue in December. We had a courteous discussion with respect to the complexity of assessing the key performance indicator, and Senator Shoebridge might care to have a look at the transcript in that regard.
Correct, thank you. And I remind senators that it is incumbent upon all of us to treat witnesses with dignity, courtesy, fairness and respect. Thank you. Senator Shoebridge.
Thanks, Chair. The failure to meet the targets for providing health services on Nauru, the failure to address quality failures identified through monthly performance management reporting on health services. Given the government is sending more and more incredibly vulnerable people to Nauru, how do you explain that failure to deal with health services to such a vulnerable population who have nowhere else to go?
So, Senator, there are a couple of areas that are relevant to your question. In respect of Target 80, which was found unable to be determined, this is an example of where we actually achieved what we intended to, but we didn't include timeframes in the action plans, and therefore it didn't meet auditing standards. And so I said before, right at the start of your questioning, that it is actually necessary to understand what's behind the top line to understand how performance actually worked. So 100% of quality failures were subject to an abatement within 2 months as required by the target, and in every one of these instances there was an action plan in place to address it. What we have learned is a valuable lesson here, that we need to include timeframes for completion of remedial activities so that they can be monitored. So that was the reason for that particular target being unable to be determined. The second one you referred to was Target 81, uplifting Nauru's regional processing capability. This was an ambitious range of initiatives in partnership with government of another country, and they focused heavily on the activities undertaken by the government of Nauru rather than the capability uplift initiatives that we undertook. So in short, this would be one of the targets where we need to focus on the things that we can do and influence, and we're working with the ANAO on that.
So I assume the purpose of Home Affairs activity, and heaven knows how many $100 million of Australian taxpayers' money, was to uplift capability in Nauru, but you're proposing to change it. So there's not actually about whether or not the capability was delivered in Nauru, but it's whether or not activities in Australia and activities within Home Affairs designed to achieve that outcome meet targets. So we're going to actually step away from actual services, actual delivery, to a kind of bureaucratic assessment of what the effectiveness of Home Affairs internal reporting? Is that what's proposed?
So,
get rid of a meaningful target.
Meaningful targets are those that we can actually impact, which is what we're working with the Audit Office on. And I should say that they have been enormously helpful in their support to us in working through how to get these targets better focused. Clearly, our intent is to lift capability in Nauru, but Nauru, as we often say, is a sovereign nation, and we will continue to work with them on that capability uplift.
And what capability uplift that Australian taxpayers paid for and that you intended Nauru to deliver, what was the capability that wasn't delivered?
So, Senator, I think we're getting very much into the detail of issues that we'd normally cover in the relevant outcome. But Mr Hickey's just reminded me that, in fact, we have just done our review of our performance in the first 2 quarters of this financial year, and that we are indeed on track to meet that target this year.
The new target that you've worked with, or this existing target?
And it's an amended target, Senator.
Yeah, well, yeah. So it's not actually about capability uplift in Nauru, it's about some internal bureaucratic targets. So having changed the target from a meaningful outcome, you're now going to hit it. Is that the situation?
So, Senator, as I said, we're working with the ANAO to make sure that the targets are actually measurable and meaningful for the Department of Home Affairs activities, and we'll continue to do that with them.
Thank you, Secretary. Thank you, Senator Shoebridge. Senator Duniam.
Thanks, Chair, and I misled you all before I have a couple more questions. I apologise. So, I wonder if we can just go to these very basic issues of the ASL across the department. Do you have that number with you?
I do, but I will
excellent.
get my
Sure.
coup back up to help.
That'd be great. And a breakdown by APS and executive level. Yes. Yes, that's very good. I'm going to try and... I'm going to be as quick as possible. I reckon I'll take most of these on notice. I'll explain in that lunch break.
I'm sure I'll get to witness.
Chair, while we're finding the answer to Senator Dunningham's question, before we finish out cross-portfolio, we have some status reports on the quants that Senator Shoebridge asked about, so I could do that before you move to outcome one.
Yeah, thank you.
Thank you. Senator SE 20... Oh, sorry.
So, Charlotte, do you want to go to the ASL?
Yeah, so sorry, Senator,
Hello.
what information would you like on our ASL?
Yes, breakdown, I guess, by division across the department. If you want to provide it on notice, it might be easiest.
Yeah, I might need to. I don't have a divisional breakdown. I've got
Okay.
totals for the department.
Sure, okay. Do you have the ASL for the National Security Division?
Not with me, but we might be able to get that before we go to the next outcome.
So just to be clear, Senator, we have a national security group, and then it has a number of divisions in
Okay,
it.
why don't we go group and then perhaps by division under that? Again, I presume the same answer applies. Okay, this could be very quick.
Great.
And similarly, within that group, how many vacancies currently exist as well? What's the ASL allocation under the role of FAS counter-terrorism policy and violent extremism? And is there a breakdown of those allocations by branch? And how many vacancies within that section, whatever nomenclature we're applying to this? Also, and again, perhaps on notice, what's the ASL of the National Security and Resilience Division? That, I presume, is separate to the one we were just talking about.
Mr Hansford, as Head of National Security, has two groups within them. They have a number of divisions, and Resilience is one of those divisions in the two
Within
groups.
that, okay, understood. All right, so those...
And so we'll get all of those
Yes,
figures for you
perfect.
on notice.
Okay, all right. Look, and the rest here I'm going to put on notice, I think, Chair, yes. Beg your pardon?
No, don't worry about it.
Okay.
I'm just
Thanks,
making
Chair.
a joke at your expense.
It was a
it's fine.
useful exercise.
Thank you. All right, now you've got some updates for Senator Shoebridge on his ones.
Thank you, Chair. In relation to SE 24358, that is currently with the Minister's Office. AE 25010, that is currently with the Minister's Office. AE 25011, again currently with the Minister's Office.
Sorry, Mr Hickey, so we don't have to go back and run through all the numbers again. Can we start again with when they went to the Minister's Office? Can you include that as we go through?
Yes, certainly, Senator. So for the first one, SE 24358 went to the Minister's Office on the 6th of December 2024. AE
Sorry, 6th of December 2024.
Correct, Senator. Sorry, I think we might have said 3rd of December, so just correcting that to the 6th of December.
6th of December 2024.
AE 25010 went to the Minister's Office on the 3rd of July 2025. AE 25011 went to the Minister's Office on the 3rd of July 2025. AE 25012 went to the Minister's Office on the 3rd of July 2025. It was returned and is currently with the Department for some revisions. AE 25013 went to the Minister's Office on the 3rd of July 2025. Is currently back with the Department for some revisions as well. AE 25014 was first provided to the Minister's Office on the 3rd of July 2025. Is currently back with the Department for revision. AE 25089, currently with the Minister's Office. It was provided to the Minister's Office on the 19th of March 2025. AE 25091, again with the Minister's Office, and was provided to them on the 19th of March 2025.
And Senator, of the 3 that are back with the department for revision, I will make sure that we expedite those answers for you.
Thank you, Secretary. Minister, one of those matters seeking information on asylum seekers who have been transferred to regional processing countries has been sitting in the Minister's Office for a year and 3 months. How on earth do you explain that it looks like deliberate, intentional refusal to do the Minister's job and provide accountability to this Minister? 1 year and 3 months sitting on the Minister's desk.
Well, I don't have the background to that to be able to answer you.
Well, will you seek an explanation from the Minister for it sitting on the Minister's desk?
That question on notice.
And I'd ask the same about matters that have been a matter that's been sitting on the Minister's desk. I think it's 089 for almost a year. The department's done its bit, given it to the Minister on the 19th of March 2025, and again, sitting on the Minister's desk for almost a year. How do you explain that?
Again, I'm happy to take that on notice.
And Minister, a series of questions about critical information that Home Affairs and the Minister knew about the Dural Caravan explosives event, sitting on the Minister's desk, failing to just move it off the desk and send it to the Secretariat for this committee since July of 2025, a matter of significant public interest. How do you explain failing to provide any of those answers that have been given to the Minister by the department since July 2025?
Well, again, I'm happy to take that on notice. I would again make the point that this Minister, this department and this Minister's Office have cleared and answered an unprecedented number of questions on notice asked in this Parliament. I gave you the figures before. The special estimates that were held in December, nearly 2,000 questions on notice were asked, 1,965. I don't think that number has even come close in any other estimates hearing. It's nearly double the other highest number of questions on notice, and despite that, 1,749 of those 1965 questions have been answered. So, as I say, this department, this Minister, this Minister's Office do everything they can to respond as quickly as possible to questions on notice, but senators have a responsibility to think about whether the questions they're asking are actually necessary, because the more questions that are asked, the longer it's going to take to answer them.
Minister, you can make those assertions about everything possible, but I point out the fact that the department has put an answer on the Minister's desk in relation to asylum seekers being transferred to regional processing countries. They put it on the Minister's desk on the 6th of December 2024. You can't possibly say it even comes close to everything possible to provide answers to the committee. Well, 1 year, 3 months, and I can't tell you how many days.
I've taken that question on notice, but to remind you, budget estimates 24-25, 1,048 questions asked, 1,042 answered. Special budget estimates 24-25, 676 asked, 666 answered, and so it goes on, with over 90% of questions on notice being answered, over 90% of unprecedented numbers of questions on notice that were never asked in previous parliaments, along with unprecedented numbers of OPDs, along with unprecedented numbers of FOIs, and of course at the same time that people are critical of ministers and departments not answering questions on notice, they're also critical of departments and ministers not doing other things. The more time we spend on, in some cases, frivolous, not necessarily the ones you're talking about, in some cases frivolous questions on notice, such as requests for pictures of IKEA furniture purchases for department offices, or how many desks there are in departments and agencies, or requesting publicly available information about when agency heads were appointed and when their tenure ends, if people keep jamming up the system with those sorts of questions on notice, then it is going to take longer to answer ones that you might consider to be significant.
Well, Minister, it's obviously a political choice if you want to answer things about IKEA desks or about what this government knew about the Dural incident, about what this government knows about the asylum seekers being transferred to third countries and the matters of significant public interest, that answers which have been sitting on your minister's desk for months or more than a year. And I'd ask you to provide timely responses if you can.
Well, we always do.
Well, clearly not.
Senator Shoebridge.
In 90% of the time.
That concludes the questions we have for cross-portfolio, corporate and general matters. You are released. We'll take a very short suspension while we welcome officials for outcome 1. Okay, we resume with outcome 1. We'll proceed directly to questions and we'll begin with Senator Mackenzie.
Thank you so much, Chair. Going back to the Bondi attack, at what stage did Home Affairs first provide advice to the government to implement changes to our firearm regulations?
Hi, Senator. Hamish Hansford, Head of National Security. The first time that we provided advice to the government was the 15th of December.
What time?
I have to take the specific time on notice.
Morning or afternoon?
Morning, because we were having a discussion on that day with the Department of the Prime Minister and Cabinet, who were compiling a range of information to support the Prime Minister at National Cabinet, and there was an ongoing discussion throughout the day. I'm confident it started in the morning but continued into the afternoon.
Until we got to National Cabinet. And was that verbal or a written brief?
It started verbally, Senator, and a number of discussions with the Department of the Prime Minister and Cabinet, and then there was a written document that we commented on.
Yep. A written document were you the author of, or was PM&C?
PM&C was the author of, but we contributed to the ideas in the document.
And who else had input into that brief? PM&C, Home Affairs?
Well, I can speak to Home Affairs' input into the information.
Well, you could probably speak to who else had input into it.
I think PM&C should speak to who had input into the document they prepared for the Prime Minister.
Well, I don't have PM&C in front of me right now, I have you. Who else had input into the brief?
So, Senator, Mr Hansford can't speak on behalf of PM&C. We can talk to you about our input, but really PM&C knows who it coordinated with and where it sought input.
So did the AFP have input?
Senator, the AFP will be appearing later today.
Was the changes to regulations a suggestion from Home Affairs, or was there a request to work something up?
So, Senator, the department has been working on firearms policy issues, including through a firearms policy working group for some time. So we came to the discussion with the Department of the Prime Minister and Cabinet with a range of different options, which included regulation.
So this was one of the things you had in the bottom drawer?
Well, it's one of the things that we have been working on from a policy perspective for some time.
Right. On the evening of Sunday the 14th, the Prime Minister gave a press conference with the Acting Deputy Commissioner of the AFP and the Director General of ASIO. There was no mention of changes to firearm regulations. Focus was appropriately on tackling anti-Semitism. at his 7:22 a.m. morning press conference, the Prime Minister did not mention firearm regulation reforms. A journalist at that press conference raised the need for a gun crackdown, and the Prime Minister, in response to that, said, and I quote, "We'll look at whatever is necessary," but did not commit to or suggest that firearm regulatory changes were going to be considered. But by 2 p.m, as you know, holding the press conference following the National Cabinet meeting, there was obviously then an announcement about tougher gun laws. So did someone from the Prime Minister's office, following a question from the journalist at the 7:30 a.m. press conference, suggest that we needed to be looking at firearm regulations in preparation for National Cabinet?
So, Senator, I think Mr Hansford has already outlined the process by which Prime Minister and Cabinet sought out input to prepare information for.
I'm worried about the timing, Ms Foster. I understand the process. He's been very helpful with the process. I'm interested in the timing and where that request was generated from. Was it...
Senator, I think as Mr Hansford said, he doesn't have the precise timings of the conversations he had. We can take that on notice and look at that vis-a-vis the announcements over the course of that day.
Well, as I understand the evidence, there was something, a policy being worked on in the, separately over time. And it would seem to me, from the evidence that's been presented, that this was helpfully offered in response to a question, what can we do on firearm reforms, following the press conference.
So, Senator, I'll let Mr Hansford refresh himself, but the broad question we had in that immediate aftermath was, what can and should we be doing? And as you know, there were a range of different proposals,
I appreciate
including
that,
the firearms.
but I'm very much interested in how this got on the agenda. Mr Hansford?
So I think from our perspective, the trigger was a request from the Department of the Prime Minister and Cabinet for
Okay, thank you. And then you were able to say, we've been working on this. Yep, got it. Thank you. So PM&C, not the AFP was my second question. So that's, thank you, you've confirmed that. Okay, just in terms of going through the areas of reform that National Cabinet discussed, didn't agree to, and again the Police Ministers' Council's 2 subsequent meetings haven't agreed to anything other than to discuss options. Could you answer who proposed the limits on the number of guns being held by individuals? Was that PM&C, Home Affairs or the AFP? I'm going to run through each of the suggested areas of regulatory change.
So,
just the limit on the number of guns.
On the limit on the number of firearms, the first answer to your question is we had a discussion where we spoke about different policy ideas, including the limit on the number of firearms. In the background, my team had been pulling together policy options. I believe that the limit for a number of firearms was one of those options in our policy work.
Okay, so that's a Home Affairs. Limiting open-ended firearm licensing?
Senator, I think the answer for all of them is that we discussed with PM&C different options that were then put into a paper by PM&C that we commented on. So for every option, it's if you look to the origin of the idea, it was a collaborative effort between the 2 departments, and Prime Minister and Cabinet can talk to who else they spoke to.
Who did you speak to?
So I spoke to Deputy Secretary of the Department, Ellie Lawson, and I spoke to the Secretary of the Department, Stephen Kennedy.
Okay, so that's who you spoke to in PM&C. When you were putting forward these ideas very quickly prior to a National Cabinet meeting agenda, did you seek any feedback from anyone outside of Home Affairs?
No, I did not, Senator, because a lot of the information that I was being provided, I knew came from discussions and deliberations in our firearms policy working group, and Mr Engel can outline the participants in that working group that have been worked on for some time. So I came to the input based on a history of engagement and collaboration.
So just to be clear, the limits on the number of guns being held by individuals was a policy that Home Affairs had already been working on. The limiting open-ended firearms licensing arrangements was also something the Home Affairs Department was already working on. Limiting the types of guns that are legal, including modifications, was a policy that the Home Affairs Department was already working on. And Australian citizenship as a condition of holding a firearm licence was also a policy that Home Affairs was already working on. Is that your evidence to us today?
Senator, I will check the specifics for every single item there. What I'd say is we were working on firearms policy issues.
Yes, I understand that.
Whether or not it's inclusive of all of the list, I'll have to take on notice and check.
I will check with Mr Engel if I could, given he's closer to the work that the Firearm Policy Group is doing, because I want to be really clear about these 4 policy suggestions that were thrown on the table at a National Cabinet meeting, and I want to know if they were already part of a policy discussion and development process within Home Affairs, or whether they'd come from other places. Mr Engel, do you want me to run you through those 4 again?
No, that's all right, Senator. Alex Engel, Acting First Assistant Secretary, Criminal Justice Division. Along with what Mr Hansford said, we were working on a number of things over years, that is, in the FWPWG, very long acronym, but that's the main state and territory forum we have with the state and territory registries on firearms policy. We probably have to take on notice to run through the list of every single one of those to check back through the records of what we developed over that time
Mr
period.
Engel, I'm very well versed with the policy working group's work. I find it incredible that you would have to check on what you actually put up to be part of a National Cabinet, these 4 very significant changes, that you can't remember if they were part of your ongoing discussions in that working group, or whether, rightfully, that they were a response in the moment of a terrorist attack.
Senator, can I just clarify that Mr Engel's team developed a paper that they gave to me to prepare myself for discussions with the Department of the Prime Minister and Cabinet. So it's fair to say that each of the different ideas were discussed and then eventually ended up in a paper to support the National Cabinet discussions. And so I think the answer for every one of those issues was it was developed together with the Department of the Prime Minister and Cabinet. Obviously, we had input on every single one of those measures.
Yeah, no, I appreciate it. I'll have more further questions. Thank you.
Chair, can I just add one thing? Sure. To be clear, Senator Mackenzie was engaging in a little bit of rewriting of history around the National Cabinet meeting that was held on the 15th of December. It is clear from the communique that was released from that meeting, and I'm quoting, First Ministers agreed to strengthen gun laws across the nation and have commissioned their police ministers and attorneys general to develop options, including those number of points. But I know we've seen some states trying to wriggle out of commitments that were made at that National Cabinet meeting, and Senator Mackenzie used words along the lines that there was no decision made at that National Cabinet meeting, and clearly
Options
there was.
papers coming back.
But an agreement was reached to strengthen gun laws.
develop options. And I've got the police
And First Ministers also reiterated their
communiques.
commitment.
I'm very happy to go through them.
We're not inviting conversation.
Opportunity.
Also, the
ready to
statement
rotate
says that First Ministers also reiterated their commitment to the permanent national firearms amnesty to reduce the number of unregistered firearms in the community. And of course, we've seen some states not follow through on that.
Thank you, Minister. Senator Roberts.
Thank you, Chair. Thank you for appearing again today. Good morning.
Good morning.
Nice, bright, lively welcome. Thanks, Senator Watt. What is the risk, these are Department of Home Affairs questions, what is the risk to Australians of a terrorist attack on Australian soil since the Bondi atrocity at the hands of Islamic terrorists of Middle Eastern extraction and the failed bombing attempt by homegrown white supremacists?
So, Senator, you're absolutely right that that is a question for the Home Affairs portfolio, but the threat assessments are actually done by ASIO, and you'll have Director General Burgess appearing later today.
I'm going to ask him similar questions. Isn't it pertinent that you should know as well?
Senator, that's a specific role assigned to the Australian Security Intelligence Organisation.
Do you interact with ASIO, AFP and coordinate activities?
We do, Senator, but in terms of actually formulating that assessment, that's a role that belongs with them.
I'm not asking you whether or not you formulate the role. Thank you for explaining ASIO does that. I thought they did that. What I'm asking is, do you know it? I'm going to ask you questions about your department's response based on the level of threat.
So, Senator, I'm hesitating because an amount of the assessment work is classified in nature, and so I'll need to take on notice before I answer any questions about my state of knowledge, what the classification level of the material that I have
I just want to
of.
know whether or not your department knows what the level of risk is right now. What's the rating?
So Senator, that's the question I'm being cautious of, because when agencies make assessments about threat, then that can often be drawn from classified sources. But I think, it is public, it's on the public record that the Director General raised the threat level for terrorism to probable on the 5th of August 2024. That's the national terrorism threat level, which, as he explains, means a more than 50% chance of that occurring.
I'll ask him this question as well. Thank you for that answer. My understanding is that the risk level, the rating, has to be increased immediately after an attack. Has it been increased? What I'm getting to, Secretary, is what are you doing differently now compared with before Bondi?
So, Senator, I think that, again, publicly, the Director General has affirmed that the national terrorism threat level remains at probable, that he did not, on the basis of information available to him, change that at the time. In terms of what we collectively have done since Bondi, you'll see a very significant range of activities, obviously some of which you participated in the debates on the bills which were passed a couple of weeks ago.
How safe are we now living in Australia? How safe are we now living in Australia?
Senator, I can only give you my previous answer, which is it is the Director General of ASIO who makes assessments of Australia's national terrorism threat level, and he will be appearing later today, but I've given you the publicly stated information to date. Mr. Hansford's just reminded me in terms of, another very significant action since Bondi is the allocation of $102 million investment in security for Jewish institutions, places of worship, educational facilities.
Do you do anything to educate everyday Australians, the citizens of Australia, as to what we can do to enhance our safety?
So, Senator, we, as in the Commonwealth, has a range of actions, including information on the National Security website and a range of information that can help people be informed about security issues in Australia. We also play a leadership role, and I co-chair the Australia-New Zealand Counter-Terrorism Committee that has met post-Bondi a number of times to talk about how do we prepare, knowing what we know about Bondi from the law enforcement and policy community across Australia. We've had discussions around how law enforcement and policy agencies can respond and learn from what's happened in Bondi, cognisant of the inquiries that are underway.
Doesn't sound very concrete to me. What about things like tightening up immigration standards, who we let into the country?
Well, Senator Roberts, we recently passed some laws to strengthen the Minister's powers to cancel visas of people promoting hate, and your party voted against those laws.
That's because of other things, Minister.
Sorry?
That's because of other things that we did not like in the bill. Would you...
But you voted against what you're asking for.
We voted against the other provisions of your bill.
Which were to make it easier to ban association with neo-Nazis. Was it that bit, or that you didn't like, or what were the...
Minister, we could talk for hours about the specifics
but the problem,
your bill.
The problem for One Nation is that you always...
This is time for you to answer my questions, not for me to answer your questions.
The problem with One Nation is that you call for things to happen and then you vote against them. You've done that now on
We do not vote against tight immigration.
You voted against same job, same pay when you
Minister,
call for
will you increase the immigration
vetting
vetting standards?
Cheaper medicines when you want things done for poorer Australians. Like, at some point, Australians are going to see through One Nation and see that you make promises that you don't keep when you come to Canberra. And you did it again recently by calling for hate preachers to be banned and restricted, and then voting against laws that would do that. You called for migration screening, and then you voted against it. So I'll leave it to Australians to, see through what One Nation does rather than what One Nation says.
Minister, do you think Australians are fools and not seeing what you're doing right now? We've asked for tighter immigration standards. Will you answer the question? Will you provide tighter immigration standards to keep people, terrorists out?
We just did that and you voted against it.
That's because of other things in your bill.
But we did what you were asking for, and you voted against it.
Correct, because of the other things.
Just like you always vote against the things that you say need to be done. And we're on to you. We're on to you.
Well, we're happy to leave it in the hands of the Australian people.
And the Australian people, over time, will be on to you.
Will you call out ideologies that promote terrorism?
We've done that, and we just
took a long while for you to call out.
We've done that, and we've gone more than just call it out. We've passed laws. We just passed laws. We don't just call things out. We pass laws to restrict hate speech and hate preachers. You vote against those laws.
Minister, there was only one party calling out ideological Islam. That was us, until the Bondi attack, and all of a sudden we got more.
That's not true. There's a long series of statements from the Prime Minister. There is a long series of statements from the Prime Minister and ministers in this government who have condemned some of the hate speech that we've seen in the community, whether it be from Islamic preachers or white supremacists. There is a long series of those statements, but we don't just call things out. when we come to Canberra, we pass laws to restrict that kind of activity. So I invite you to work with the government to restrict that kind of activity rather than just pretend that you care about these issues.
Thank you, Senator Robertson. I need to rotate the call.
Secretary, do you have adequate resources to do what needs to be done?
Senator, the Department of Home Affairs has a very substantial budget and staffing level, and I am able to deploy those resources to the government's priorities.
Thank you.
Thank you, Senator Roberts. Senator Shoebridge.
Thanks, Chair. The Secretary, obviously through you, the Minister has now been given a significant role in working out which groups should be prescribed and made criminal and which groups the membership of which should be made serious criminal offences. Are you able to explain the different legal tests that are set out in the legislation that could lead to the Minister prescribing groups? And I'm asking this having asked the Attorney-General about one particular provision which ropes in 7 different state and territory laws. And the Attorney-General's department said that actually that applies 7 different standards for conduct in the different jurisdictions.
They said a bit more than that.
Well, I could tender the entire transcript, but they said that the Victorian provisions apply on their terms primarily in Victoria. The New South Wales provisions apply on their terms primarily in New South Wales. Some of them have modest application outside of their states where the conduct impacts on that state or territory, but effectively 7 different tests. First of all, do you share the Attorney-General's assessment that there are the different applications and different tests depending on where you live in the country?
So, Senator, you're right to identify that the legislation is the responsibility of Attorney-General's department, and they are the ones who are appropriate to make comment to you, as they have done. Within that legislation, Home Affairs is responsible for the listings regime, and Mr Hansford would be very happy to take you through how that applies in response to your first question.
Certainly. So if you wanted me to take you, Senator, through how the legislation works in terms of listing a prohibited hate group?
Yeah. Yes, indeed. But if we could for the moment concentrate on the Minister's role in that and what the thresholds for the Minister, and if you could address that in the course of that, the 7 different tests.
Sure. Well, the first trigger, though, has to come from the Director-General of Security, who can provide the Minister written advice recommending that an organisation should be considered for specification as a prohibited hate group. The Minister can't act unless he or she is in receipt of that advice, and there's a number of different tests for the Director-General of Security there, which relate to their heads of security in the ASIO Act. Then the Minister, as the...
because it's quite long and complex, Mr Hansford, maybe we can do it in chunks. Can the Minister request that advice from ASIO? Is there any restraint on the Minister requesting such advice from ASIO?
The legislation provides that the Minister can't act unless the Director-General of Security provides that written advice. There's nothing in the legislation about the Minister requesting.
So the Minister may request the advice and get the advice from ASIO, or ASIO of their own motion may provide the advice. Is that the case?
That's my understanding, yes, Senator. Right.
So that's the trigger, if you like, for the Minister's powers to decide whether or not to make an organisation illegal and make membership of an organisation illegal.
Well, the Minister can't act unless he or she is in receipt of that advice from the Director-General, yes, sir.
All right. And then the Minister then needs to turn to the provisions in the bill to determine whether or not the conduct is such, in the Minister's mind, that would justify the listing, the prescription. What are the considerations, the different considerations the Minister could have regard to or must have regard to?
So the Minister, as the AFP Minister, must be satisfied on reasonable grounds that the organisation has engaged in, prepared or planned to engage in, or assisted the engagement in conduct constituting a hate crime, or has advocated engaging in conduct constituting a hate crime other than advocacy offences in the Criminal Code, and specifying the organisation as a prohibited hate group is reasonably necessary to protect the Australian community or a part of the Australian community from social, economic, psychological or physical harm or the promotion of violence. And then the Act goes through the definition of a hate crime, and as you've pointed out, there are links to other offences. And then the AFP Minister must obtain the Attorney-General's agreement in writing and then arrange for the Leader of the Opposition to be briefed, and then the Governor-General can consider making a regulation.
All right. Now, on the definition of hate crime, it's contained in 114A3, which references a number of federal provisions which apply uniformly across the country. But it then references conduct that would constitute an offence against a provision of a state or territory, and it lists those provisions in subsection 3. They are provisions in New South Wales Crimes Act, Victorian Crimes Act, Queensland Criminal Code, WA Criminal Code, the South Australia Racial Vilification Act and the ACT Criminal Code. If we, rather than go through each of them, we'll use the Victorian examples. There's a number of thresholds in Victoria, including severe ridicule. Now, if you're in WA and is the Minister able to judge someone's conduct in WA against the provisions of the Victorian Crimes Act, Section 195N?
Thanks, Senator. Brooke Hart again, General Counsel. These provisions were put in by the Attorney-General's Department, so they are best placed to discuss them. But it is my understanding that it would depend on the territorial application of the state offence as to whether or not a Victorian offence could apply to WA conduct.
So the same conduct in WA directed against individuals in WA wouldn't meet the test. Sorry, I'll start again. The Victorian provision has extraterritoriality application only to the extent that the conduct outside of Victoria specifically identifies groups or individuals in Victoria. But otherwise, it's about conduct in Victoria amongst Victorians. That would therefore mean that somebody could undertake certain conduct in Victoria, which might trigger the definition of a hate crime. But if the exact same conduct was undertaken in WA, it would not trigger a hate crime because it doesn't meet, for example, the severe ridicule test in Victoria. That's the result, isn't it?
Senator, Ms Hartigan was clear at the start of her answer that this element of the legislation was developed by and is the responsibility of Attorney-General's Department. So detailed questions of that nature really must go to Attorney-General's Department.
You see, I would agree with that answer if it wasn't for the fact that it's your minister who needs to interpret this to determine whether or not an entity should be criminalised. And so if your department doesn't know these answers, then how can your department brief the minister?
I don't think anyone has said that they don't know the answers. That's your characterisation of this. What we're saying is that questions regarding particular departments and their responsibility should go to those departments.
No, this is the Home Affairs Minister's responsibility to understand whether or not the hate crime offences have been breached. And I know it's difficult and I know it's complex, but whether or not Palestinian groups get made unlawful, whether or not people are facing 15 years in jail, the community is asking these questions. And if the department responsible for managing it can't answer it, well, is there any wonder there's such fear about how these provisions are going to be applied across the country?
Senator, we would get legal advice on the application of the provisions of the legislation. The decision about whether or not something constitutes a hate crime is not is something on which we would have a legal interpretation to put before the minister.
Thank you, Senator Shoebridge. Senator Duniam.
Thanks, Chair. If I can just go to, and it might sort of relate to some of the questions that Senator Roberts was asking about the road, the events leading to Bondi. I mean, is it the government's view that radical Islamism was the main driver leading to those events that occurred in Bondi last year?
So, Senator, because there is an ongoing police investigation into those events, we are not able to comment in any way about motivation or the facts around that, so as not to prejudice the conduct of that process.
Sorry, I cut you off. No. You're okay. Look, then how has the government determined its response, including in the legislation that we passed as a parliament 2 weeks ago now, if we don't reflect on what might have been contributing factors or causes or driving factors?
I mean, you've seen many ministers, including the Prime Minister, say that the government's response was based on what appears to be the motivation of the alleged offenders and the method that they used. And so I think in a general sense, what I can say is that all the evidence publicly would suggest that hateful ideology promoted by Islamic State would seem to be the motivation. Again, I'm being a little bit careful about what I say in criminal proceedings, and that the method then was the use of firearms, and that's why the government based its response on both limbs, and why we would have liked unanimous support for that from the Parliament.
Indeed.
And clearly, Senator, the target of the TAC, it made it clear that anti-Semitism needed to be a very big part of the response.
Yes, indeed, I accept that. I mean, does the department acknowledge that there are some serious problems and risks associated with Islamist extremism in this country? It's a separate issue to Bondi, but in general terms, that is something the department recognises as a serious problem in Australia?
It is, Senator, and as I was explaining to Senator Roberts before, we obviously receive not only the public assessments that ASIO makes about threats to security in Australia, but a range of classified intelligence reporting. All of that informs our understanding of the risks posed by extremist ideologies, but I think it is very clear publicly that extremist ideologies are of concern of a very serious nature.
There's been a lot of reflection, obviously, though the department have been busy with the preparation of the legislation in partnership with AGD, but on reflection, were there any elements missing from the response or settings of Home Affairs or its agencies that we can talk about here in the lead up to Bondi?
So, Senator, clearly that is very much the focus of the Royal Commission, and to the extent that as the Royal Commission goes through the events leading up to the attack, there may well be either evidence or reflections. And I think the Prime Minister has said, when you look back, you will always find things that you could have done more of or differently. What we did do, Senator, in response to the raising of the threat level in 24 was to renew the counter-terrorism in 25, sorry, was to renew the counter-terrorism. Wasn't the assessment in 24? Sorry. So in response to the changed threat level in 24, in early 25, we issued a new counter-terrorism strategy which went to the heart of the issues which the Director-General had highlighted in his threat assessment in 24. And I won't try and paraphrase that in his absence, but he has been very clear that the threat of lone wolf actors was increasing, and that online radicalisation, rapid online radicalisation, the increasing engagement of youth in that, extremism, all of those factors were contributing to the raising of that threat level, and all of those were addressed in the new strategy that we released in early 25.
So, and noting your earlier point about the Royal Commission will traverse this fairly extensively, has there been any work in preparation for that? Because, of course, we don't have to wait for a Royal Commission for an agency to have a look inward and say, this could be changed. Has any of that work been undertaken? I'm assuming it has.
So, Senator, I guess I want to put that in part of a continuum. We are always looking at new intelligence, new information, and thinking about whether the programs or the policies we have in place are fit for purpose. And Mr Hansford can talk to you a little bit about the process that we go through with states and territories around, for example, our countering violent extremism programs. Clearly, post-Bondi, all of us have been thinking about where could we strengthen, where could we tighten, and that work will continue to be undertaken as we prepare ourselves to work through that with the Royal Commission.
Sure, and so I suppose that is really the nub of my question. Post 14 December and those terrible events, what specific bodies of work, I accept that there is always continual reflection and efforts to improve, has there been any specific body of work undertaken, initiated by the department or its agencies about areas of improvement, for example?
So, Senator, I think my sort of headline response to that would be it's very early days as we start to look at that. We are doing that work in the context of preparing ourselves for the Royal Commission.
So work has been initiated and it is linked to preparation for the Royal Commission, that those two are inextricably linked. There's been no other internal effort.
So, Senator, I convened the Australia-New Zealand Counter-Terrorism Committee in the week of the 5th of January, having convened them on the 15th of December to look at the Bondi incident immediately after, and asked the very question, knowing what we know now about the Bondi incident, what does that mean in terms of the priorities of that group's work, and that the group is all law enforcement across Australia and New Zealand and all the policy representatives responsible for counter-terrorism. And so we're doing a range of work to both our work program through the ANZ CTC, but equally we've commenced our triennial review of our arrangements, which was planned before the Bondi incident, but we have implemented that work after the Bondi incident, and that's very much the focus of how we're looking at Bondi, saying, are the arrangements fit for purpose? Is our work program fit for purpose? And we did, late last year, actually have an offsite with all of the ANZ CTC to say, given the threat environment and the change that we're seeing, are we postured in the right way, particularly looking at online radicalisation and particularly looking at the $106.2 million that was allocated in the CT strategy in January of 2025 and its implementation across jurisdictions. So a range of work that both had preceded Bondi but then has occurred since.
And I wouldn't, Senator, want to leave the impression that we are only doing this work because of the Royal Commission.
No.
The point I'm trying to make is that that is now the channel through which we will prosecute those ideas, policies, etc.
No assumption made here. Thank you.
Thank you. Senator Pocock.
Thank you very much, Chair, and thank you for your time this afternoon. Given the firearms regulations changes in the Combating Anti-Semitism, Hate and Extremism Bill 2026 were incredibly rushed, I have some questions about implementations of changes envisaged in that legislation. And I understand and have been watching questions from Senators Mackenzie and others earlier that gun buybacks are predominantly for the states and territories, and those are sort of currently under discussion. But I'm interested in what approach the government is taking on the compensation of firearms. Are you looking at sort of fair market value, or are you looking at just setting a price for, say, rimfires, centrefires, shotguns? What's the approach there?
Senator, we are looking at a range of options for compensation, and we have been talking with states and territories about the parameters of compensation, including through 5 senior official group meetings that have met since the Bondi incident. And we are working through that level of detail in support of the Cabinet, in support of what might then be presented to National Cabinet.
Sure. I think the short answer is, Senator, we're still working through the options. There hasn't been a decision made yet.
Thanks. Could you share what options you're working through?
That goes, Senator, to the content of the options we're working up.
Sure.
So I think we can give evidence.
Why can't you share that?
Is that will form the basis of our advice to government.
But it's not yet.
But, Senator, it is essentially being worked up for advice to government, and we wouldn't normally discuss the content of advice to government in this forum.
So even before something goes to government, you can't discuss it if it may form advice to government?
But it is very distinctly...
Seems like a real catch-all.
No, it's very distinctly being prepared for government.
When will that be provided to government?
Well, we're providing a range of advice, both on the policy parameters and funding implications to government, and advice has been provided to the government and is continuing to be provided to government as recently as yesterday, I believe.
So you can't talk about anything then, because it's all advice to government, or what's the...
It's a long-standing practice in estimates that officials don't provide information about advice being provided to government.
Minister, you would have seen in the Robodebt Royal Commission, Commissioner Holmes was pretty scathing about this sort of approach from governments, where you just hide advice because you say, well, this is advice to government. She had some very strong recommendations to actually deal with this, and I just don't think this helps. This was rushed legislation, and now when we try and find details, we're just being told this is advice to government. Does this sort of cut it for Australians?
I don't think that anyone is hiding anything. The government is in the process of making a decision about this. It will consider the options that the department presents to it, and the department is doing that work now.
Okay. Are you considering fair market value as one of the options?
Senator, I think that's another way of
Also
asking us for what the
government.
content of our advice to government is, and unfortunately I can't provide that.
What's the government's position on compensation to businesses that will be affected by this legislation?
So, Senator, again, I'm not trying to be unhelpful, but that forms, the elements of the the buyback package are currently being worked up, negotiated with states, will be provided to government, and there will be a decision that will, of course, become public.
Can you tell me when that will be provided to government? Advice on compensation?
So, as Mr Hansford said, we are in pretty regular contact with our Minister about the progress of our negotiations, and he, of course, chairs the Police Ministers' Council, which also has been discussing these issues.
I'm sorry, I'm really not trying to be funny here, but that's just so unclear. Like, does this end at some point? Is there a date where you want to give the final advice, or why is this such a big secret?
Well, Senator, it's not a secret we are working with jurisdictions, but I can reflect that the Prime Minister in his media release on the 19th of December has put the date for us to work to for ambitious new gun reforms no later than March 2026, and for the reforms to be legislated by 1 July 26. So that's guiding our provision both of advice on the parameters of the gun buyback and the issues that we're working through. But you'll appreciate it is quite a complex issue that we're working through with states and territories.
Do you have a target on how many guns, firearms you think will be brought back through this scheme if states and territories sort of buy into it, or have you modelled that?
Yeah. So, Senator, that depends on the final agreement on the parameters of the gun buyback scheme, and we have done modelling for the options about how many firearms would be captured, dependent on who signs up to the gun buyback scheme and what it covers and the compensation parameters.
And so what's the range for that? Say you exclude New South Wales and, Queensland and Tasmania. What are you sort of looking at with other jurisdictions?
So, Senator, that's very much still under negotiation. And I think, again, it gets us, to be providing parameters that may not yet have gone to government and haven't been decided on, takes me fair and square into the advice to government problem again.
Okay, so the Parliament's passed laws, but we're not really allowed to know what the modelling is behind them, how this will potentially work or not work. You can't provide me any range of this is how many firearms we think that this will.
So the Parliament, Senator, has passed enabling legislation for the gun buyback scheme, which gives you the parameters and the date. The Parliament would have to also pass any fiscal implications as well as the next issue that the government might bring forward to the Parliament.
Okay. Will ammunition be included in the buyback scheme?
That's one of the issues that is being considered, Senator.
The legislation allows for it?
Senator. Yes, so the way that legislation set up the buyback scheme is that it obviously draws it directly back to why we would have it. Reforms post-Bondi the government's considering with the states and territories through National Cabinet, and then within that provide certain instruments and powers to the Minister about how he might make arrangements with the states and territories, and in that it will talk about the scope and range of the buyback. So the legislation allows for that flexibility, but none of that has been decided yet.
Okay. It's just I find it worrying that ammunition hasn't been part of this conversation at all from the government, and you'd have to think if all these firearms are bought back, if every firearm owner has, a couple of boxes of ammunition up to hundreds of rounds, like that doesn't just disappear. And so I'm concerned because it's been so rushed, so short on details, you've created so much anxiety amongst law-abiding firearm owners, and even the gun control groups are saying, hey, if we had more time, we could have done this better. So I'm just really hoping that this process results in a bit more clarity for everyone, and interested when will people become more clear about the path ahead?
So, Senator, in response to your first question about ammunition, I did indicate that that was one of the issues under consideration about which there has not yet been a decision. As soon as this advice is considered by our government and goes to National Cabinet, then it will be clear.
And does this require every state and territory to sign up, or will you proceed on a jurisdiction by jurisdiction basis on those agreements?
So that the legislation sets up for the gun buyback. The then decisions that the government takes and negotiates with states and territories is the next step, and then states and territories will either sign up or not sign up to the.
No, I understand that, but will the government proceed? Say, if you have, most of the jurisdictions sign up, will you just proceed with these?
So, Senator, that will be a decision for government at the time. At the moment, it would be speculative for us to answer that.
Okay. Can I just one final question? One of the actually, I might ask the minister. Minister, will the government proceed if you get most of the states and territories on board, or will you?
Well, as Ms Foster has said, that's a matter yet to be determined by the government.
That's what I'm asking you.
Yeah. Well, it's yet to be determined. We have not decided that yet, so I can't give you that answer.
Okay.
What I can say, and the Prime Minister has said, is that that buyback scheme and the other measures will be only as strong as the weakest state, and we would strongly encourage all states to be part of it. I've seen my home state of Queensland as recently as yesterday. The state government there has suggested that they won't be participating and they won't be picking up other aspects, and I've repeatedly encouraged the Queensland government to be part of this, because we want to work across the country to make Australians safe.
And maybe just finally, can I just get a clarifying point from, sorry Chair, officials? One of the concerns that came out in the brief consultation that I was able to do on this bill was around firearm owners that reload, and some of the lack of clarity in the details of the bill. There was concerns that people, going online, searching for reloading advice, different ways to do things, could get caught up in these laws. And can you give me a sort of really definitive answer that it does not cover people searching, reloading?
Yes, Senator, that's a straightforward answer. Ammunition is not included in the definitions in the bill that go to the online material that would be used to illicit manufacturing. So, we understand people repack their own ammunition. That's legal in state and territory laws. So that's not in the bill. In the Act.
Thank you very much. Thank you, Chair.
Thank you, Senator Pocock. Senator Daniel.
Thank you, Chair. If I could pick up where I left off a little earlier, was the department asked by any member of government for advice on what sort of inquiry should be held into the Bondi events?
So, Senator, this question came up in the cross-portfolio section in the context of the Royal Commission, and my answer was that I had a number of discussions with my minister as different options were being canvassed, and as the Richardson Review was being established. There were also discussions amongst ministers and officials collectively. Obviously, in this forum, we wouldn't go to the nature of that advice.
Yes, and not seeking to do so. So you talked about it in the context, in your answer to me just then, of a Royal Commission. So just to be clear, though, the multiple interactions you had were about a range of different inquiries that might
about
occur.
What inquiry might be established, how that would work, how we could effectively engage with it.
Okay, and specifically in that, were you asked about whether a National Royal Commission should be established?
So, Senator, again, before I think I said that I would not characterise those discussions as the seeking of and the provision of formal advice.
Sure.
They were, we were all operating at pace in response to a horrific event. And so
the discussions were more about what the possibilities might be, what the pros and cons of those were.
Okay. That makes sense to me. Was there any request from anyone, any member of government about whether the Richardson Review would be sufficient to identify all of the key issues associated with the events at Bondi?
Again, Senator, we had discussions both sort of at a portfolio level and more broadly across government about the parameters of the Richardson Review and its efficacy to establish what we needed to know and do in response to the Bondi attack.
Okay. And just on that interaction between the Richardson Review and the Royal Commission, are you able to summarise for me how the two bodies of work will actually interact?
I will, Senator, give it a red-hot go. That, of course, is the purview of Attorney General's Department as the organisation that manages and runs the Royal Commission and has managed and the integration of the Richardson Review. The way I answered you in that way is I'm conscious that Attorney General's Department has already appeared.
Yes.
And so to give you my understanding, the Richardson Review was obviously called first. The Royal Commission was then established, and the members of the Richardson Review, including Mr Richardson, have been appointed now to the Royal Commission and form part of the Royal Commission.
Okay, and so there will be that level of interaction, and I can ask of the Attorney-Generals what formal arrangements might exist. Was the department asked for any advice in relation to who could be a Royal Commissioner or plural Royal Commissioners?
No, Senator.
Is that because that's a matter for the Attorney-Generals and it has no interaction with this agency whatsoever? Okay.
Yeah, it's fair and square their territory to manage the establishment of a Royal Commission.
Okay, thank you very much. I just wonder then, bearing in mind that some of these questions might go to the issue that is under investigation, I want to ask, and if you can't answer, please let me know, but whether Naveed Akram or Sajid Akram were at the rally that occurred on the Sydney Opera House steps on the 9th of October 2023.
Senator, I think any questions about the Akrams and their activities could go to matters which could prejudice the criminal inquiry, and because I'm not running that, I won't know where those boundaries are. And
perhaps
so,
if you take it on notice might be the easiest, do you think?
Certainly, Senator. The other thing that I should say is that it's not the Department of Home Affairs' role to monitor who attends rallies.
Right. And I will ask your colleague, Mr Burgess, a little later on. Okay. If I can go to, I'll put some questions on notice and then we'll see how we go with those. The Counter-Terror Coordination Centre, if I can ask some questions there. What was the role of the centre in responding to the Bondi attack?
We'll get Mr Hansford to run you through the activities of the centre.
Senator, so the Counter-Terrorism Coordination Centre, effectively in its title, is coordinating information in relation to the incident, particularly when it relates to public talking points and understanding what's going on and providing advice to me as the Commonwealth Counter-Terrorism Coordinator and through me to the Minister for Home Affairs. On the day, the National Emergency Management Agency's National Situation Room effectively looks at all of the issues that are occurring. There was a phone call then into our Counter-Terrorism Coordination Centre duty officer, and that then established a range of different bodies of work. And my role during a crisis is effectively governed in the Australian Government crisis management framework, and there's a number of different responsibilities in relation to sharing information across the Commonwealth, as well as providing public information and talking points, which were circulated throughout the evening of the 14th of December through a hot issues brief, and then ultimately talking points early in the morning of the 15th of December. And then after that, for example, I coordinated activity with states and territories and heard from New South Wales Police on the 15th of December to inform state and territory law enforcement and policy organisations across Australia, and that all of that work was supported by the Counter-Terrorism Coordination Centre.
Okay, and so you mentioned there a range of actions following on that advice to the centre. So if I can just understand in a material sense, so staff of the centre, you talked about the duty officer, but staff at the centre or officers there are activated at that point. How many people typically are on hand at that point in time, and how are they activated?
Well, there's a duty officer who is contactable 24/7 and then can call in any number of staff that is needed for a response to an incident. We were conscious that on the evening of the 14th of December, the Prime Minister's already said publicly that there was a National Security Committee of Cabinet meeting called. So our first body of work is to understand what was happening, provide a hot issues brief, and to provide briefing for the National Security Committee of Cabinet meeting that the Prime Minister has publicly outlined that he held that meeting and then subsequently held a press conference that evening. So lots of different types of work, but understanding what's going on, reaching out to our New South Wales police counterparts, public engagement team, making sure that we had advice about the activation of the Australian Government Crisis Management Framework, understanding what we could say publicly, a whole range of different activities from the Commonwealth perspective, noting of course that New South Wales Police were the first responders, and that arrangement is outlined in our National Counter-Terrorism Plan as the first responders. And we're really looking at the Commonwealth action to coordinate effort and response. And it doesn't then operational activity obviously happens through those arrangements. This is really about what's happening from a Commonwealth perspective.
Yes, and so just on personnel at that point in time, as I say, we talked about the duty officer. How many other people are on hand at any given time, and what's the staffing of the unit more broadly?
So the staffing footprint, Ms Spencer will speak to the specifics, she's got those, but just to give you the arrangement, a duty officer will be on call and get a call, in this case from the National Situation Room. Sure. They will then activate the senior leadership and obviously activated me, the Secretary, and the relevant First Assistant Secretary of the Counter-Terrorism Coordination Centre, and we form a team to try and work out what's happened and how we respond on the evening. And then in relation to the staffing numbers.
So, Kira Spencer, Deputy Secretary, Law Enforcement and Domestic Security. For this year, the average staffing level for that division is around 67.
And so, Senator, the reason that we're not sort of saying 10 people get called in is because it's very much circumstance specific.
Of course.
We can call any number in. We can also draw on the rest of our organisation if they have particular expertise or whatever. And so it really does depend on what we need to do.
Yes, okay. And so you want to go around? Okay. Thank you. I'll be back.
He's very compliant. Senator Whitten.
I've got a couple of different lines of questioning, but my first one's about gun buybacks. I'd like to ask about the compensation to gun manufacturers and stores under the new firearms laws.
Senator Pocock has just asked a number of questions about the compensation for buybacks. Yeah.
So perhaps if I could tell Senator Whitten, just in broad terms, we're working on the parameters of the buyback scheme at the moment, but there is not yet a government position on how that will work. We're still working with states and territories, and so we're not in a position to give definitive answers about what levels of compensation there will be, who will be included, until we've finished that body of work.
Do you mind if I ask a couple of questions then, just on notice? don't have to respond, just so that the things I'm concerned about are part of your consideration when you're looking at it.
That would be really helpful, Senator. Thank you.
Okay. So in relation to the new firearm law and proposed gun buyback schemes, can you talk about, can you take into consideration gun stores and manufacturers and components manufacturers of firearms, ammunition, loss of business for those? I've had a meeting this morning with people that are going to be affected, and their general thoughts on the matter were, if the scheme was similar to the 96 Port Arthur gun buyback, that would have to be the minimum that they would be hoping for. Anything less than that, it's just going to send many, many businesses to the wall. It's also going to have an impact on gun stores that are used to transport guns safely around the country. So when you're selling them from one jurisdiction to another, I believe they rely on gun stores that have the specific storage capabilities and security. Mm-hmm. Now, if we start losing those out of the system, they're not sure where the guns would be stored at that point or how they would get transported. So I think there's a whole range of things, and I would encourage you to talk to people in the industry. There's a lot of voices that are against guns and the whole lot, but it's the unintended consequences. Another unintended consequence might be our sovereign capability in terms of businesses that are supporting the defence in their with their capabilities, and that might only be part of their business. So if they lose the one part of their business that is the domestic market, and they use that, the profits from that to do research and development for defence, that will have an impact on our sovereign capabilities. So it's another line that needs to be taken into consideration. I'd strongly advise or request that you speak to people in the industry that it will be affected by this.
Thank you, Senator, and I can assure you...
They'll articulate it far better than I can. Yep.
And thank you, Senator, and we are engaging with the industry.
I'll leave that one and I'll move on to the next one. In the October estimates, I spoke about the cost of deportations and what the average cost of deporting someone that had to be removed involuntarily. The reply I noticed was that the costs varied substantially depending on how they were deported and their requirements. I'd like to ask instead for the total budget that was spent on the engagement and removal of the 3,457 that were removed from detention in 24-25, and it doesn't matter if they were self-departed or were involuntarily removed. What was the total cost of engaging with and removing these people?
Senator, the migration issues are covered in Outcome 2, not Outcome 1.
Sorry?
But in order to assist, perhaps we could take that on notice for you and provide that to you in writing, unless you would like to come back when the relevant officials are here.
I'll come back in Outcome 2. Yeah, my apologies for that. And last one, hopefully this is the right outcome. It's to do with the ANSCO codes and the answers I got back to how many plumbers, electricians, plasterers, all the different trades that I asked for. Is that this outcome or is it Outcome 2?
Also Outcome 2.
I'll be back. Thank you very much, Chair.
See you in Outcome 2, Senator Whitten. Senator Shoebridge.
Thanks very much, Chair. Just earlier I was asking questions about how the department will go about assessing and what standards they're going to be assessing people against and organisations against before they outlaw and criminalise organisations and criminalise the membership of organisations. One obvious question was, will there be different standards for people's conduct in different states and territories around the Commonwealth as a result of that provision in the Act? And I think it's 114A3.
So, Senator, Ms Hartigan will take you through how the Act functions. There are sort of two parameters. One is the minister's role and what constitutes a hate crime, and then there is specific provisions around the states and territories.
Thanks, Senator. So we accept that there are differences between the state offences that are listed in sub 114A.3 sub 3. However, if you go back to sub 2, it says that the hate crime is also conduct that involves publicly inciting hatred of another person because of the race or national or ethnic origin of the target or target group, and that it satisfies the requirements of the state or territory offence. So there is a high threshold that needs to be met, which is the publicly inciting hatred of another person. Plus, there is also the reasonable person test in sub B, 3B.
Well, I'm not arguing about there's those threshold tests, but then my question was, are there different tests and different thresholds for conduct that will be assessed depending on where you live in the country? For example, there's subsection 3 references no Northern Territory provisions. So is there a different standard in the Northern Territory than there is in Victoria? It seems self-evidently that's the case, but I would like to hear clearly from you.
Yep.
And the department.
It would depend on the facts of the case, Senator. So this isn't the only limb of definition of hate crime. So for activities that occur in a territory, perhaps a Commonwealth offence could apply. It would just depend on the circumstances of each case. Well, it's true that we don't have full coverage in the state and territory offences in sub 3, but there are a range of other offences that might cover the conduct that's in question.
Are there other Commonwealth criminal provisions that apply different standards for conduct across the country depending on which state and territory you live in? Has this been tried before?
I think
to apply different standards across the country depending upon which state or territory you live in?
I think that's clearly beyond the scope of this department. That's clearly an Attorney General's department question.
So Ms Hartigan is trying to assist in this, even though the element of the legislation you're asking her about is developed and administered by Attorney General's department, that's
administered by the Attorney. What role does the Attorney General's department have in administering this?
They are responsible for the legislation, Senator.
But its application, the application of this will be assessed by the Home Affairs Department and the Home Affairs Minister, won't it?
Yes, and I
Which
think
is what I'm asking you questions about.
In the context of the prohibited listings, but the legislation obviously covers a lot more than that.
This section is about prohibited listings.
Yes.
And this is what I'm asking you questions about. And it's Home Affairs' job to interpret and apply this through the Minister, correct?
Correct.
Yes. So I'm asking you, are there different standards in different parts of the country depending on which state or territory you live in? Now, the initial answer he got was, well, that's a matter for the Attorney General. Given the Minister's going to have to be judging people's conduct, I would have thought this department would know the answer.
So, Senator, we understood your question to be broader. In the criminal code, are there other instances where this occurs, which is why we said that's a matter for the Attorney General's department?
Are there briefing sheets? Are there other materials that the department has developed to help guide this process when matters are brought to the attention of the department?
Senator, the process, we've set out the process here. The Minister not just takes into account the occurrence of a hate crime, but also he needs that they're satisfied that the activities and continued engagement in the activities would increase the risk of politically motivated violence or the promotion of communal violence. So the minister's threshold is different. It predicates on there being an offence, and that would be, as General Counsel has said, dependent on the facts of each individual case and the advice we get around that.
Yeah, well, that is interesting, but it doesn't address my question, which is whether or not there are fact sheets or guidance materials that the department has developed to try and make sense of incredibly complex legislative provisions that the minister may well be called on to interpret in the near future. Are there any guidance, any internal guidance, any internal fact sheets, any internal materials developed to seek to assist the department and decision makers?
Senator, as you're aware, the legislation is very new, so we're working through that process now internally.
So that means there aren't, but you're working on some? Is that how I'm to read that answer?
I think we are working on what we need to do to appropriately support officers to do their jobs and support the minister, and how that comes out is an issue we're working through at the moment.
There have been allegations that people calling for a free Palestine on university campuses causes psychological harm to other members on the campus, and repeated calls to ban protest and ban Free Palestine movement on university campuses because, amongst other things, it's alleged that it causes psychological harm to other students. Is that the kind of psychological harm that would meet the threshold for a listing?
Senator, the threshold for the listing is that the activities or continued engagement in the activities would or is likely to increase the risk of politically motivated violence. The harm element comes in.
Which includes psychological harm.
Senator, please let Ms Spencer finish her answer.
Sorry, two separate pieces. So that is, the Director General is satisfied that it would increase the risk of politically motivated violence. The second part is that the AFP Minister must be satisfied that specifying the organisation as a hate group is reasonably necessary to protect the community from a range of harms, including psychological or physical harm.
Now, part of the threshold is these state laws. Multiple of the state laws have internal defences in them, which allow an individual who's been charged in that to articulate reasons why their defence should be made out. Some of that goes to their knowledge, some of that goes to other matters. Given there's no obligation for procedural fairness, in fact it's expressly excluded, how would the minister assess the relevance of a defence if you never ask the defendant? How will that work in practice?
Senator, it would depend again on the facts of the case, but we would need to be showing to the minister whether or not the conduct would constitute an offence against a provision of a law of a state or territory, which would naturally also consider defences that attach to that offence in the state or territory.
But how can, given 90% of the time defences require the proactive production of evidence, mental state from the defendant, if you never ask the defendant, how can the defences work in practice?
Sorry, Senator, I've just been alerted to another provision actually in 114A.3, sub 4. So for the purposes of subsection 1 and again subparagraphs 2AI, II and 3I, if a defence applies in relation to conduct, that conduct is not conduct that would constitute an offence.
Correct.
So there is that express on the statute.
Correct. But in order to determine if a defence applies, the criminal law asks the defendant to provide material, to provide evidence, state of mind. Your law expressly excludes any reference ever asking the defendant. The defendant will never know that this is happening. You highlight the problem, not a solution, Ms Hartigan.
Thank you, Senator Shubert. I'm going to rotate the call after this response.
I think, Senator, we would just go back to what the thresholds are for establishing a hate crime, which is whether or not the conduct was about publicly inciting hatred of another person because of their race or national or ethnic origin of the target or target group, and that would in all of the circumstances cause a reasonable person who is a target or a member of the target group to be intimidated, to fear harassment or violence, or to fear for their safety. And that's the threshold that we'd be looking at in this.
And it's also conduct, and it's also conduct, and it's also conduct.
I'm going to rotate the call. Thank you very much. Senator Dunning.
Thank you, Chair. Just briefly back to the counter-terror coordination centres. The 67 personnel, are they all employed at this point in time, or does that include vacancies that exist within that number?
So ASL is average staffing level taken over a financial year.
Right. And so what is budgeted capacity in terms of FTE or headcount, however you want to put it?
So we are budgeted for that number?
That is what you're budgeted for. Are the 67 occupied?
I would have to take that on notice that specific vacancies we have at different times.
Yeah, sure.
And Senator, a vacancy could be, a short-term issue while someone else is acting in another role, or it could be while we're seeking to fill. So we'll try and get you some granularity around that answer.
I suspect if there's an answer that doesn't say, oh, there are 20 vacancies, which I assume there's not, then there'll be nothing to see here. That's fine. If I could go to the matter of ISIS brides, please, the group known as. Has there been any change in position around the government's view on repatriation of this cohort of people post the events of Bondi?
No.
Has any advice been sought by the government in relation to this cohort as a result of any events that occurred at Bondi?
I'll leave it for the officials to answer that, but just to reinforce, so the government's position is that we are not providing assistance and not repatriating individuals in the Syrian IDP camps. So, and just confirming that position has not changed since Bondi, the Bondi incident.
Sure. And so was any advice sought? I think you were passing to the officials.
So, Senator, there has been discussion about the cohort since December, but Minister Watt's answer is very clear to us as officials that the government's position on not repatriating that group, not providing any assistance beyond the legislative obligations on a public servant, that has not been in question.
Okay, so that is that the government, of course, says that there are legal obligations to fulfil here, so that then enables what I guess we call self-managed returns. If these individuals are able to get themselves from where they are to Australia, that is something that is allowed to happen. There's been no revision to that policy, is what you're saying.
So that is a right of any Australian citizen. As you may be aware, Senator, we have a fairly robust system of managing what we call Australians of interest overseas, which Mr Hansford can take you through, which contains a number of provisions which allow us, working in collaboration with colleagues, to manage the security implications of that, of anyone who is categorised in that definition.
Sure. And just on that Australians of interest system, has there been any change or review of that system post the 14th of December last year?
No, Senator.
So the same system remains.
It may be worth putting that question to ASIO when they appear as well, because I'm guessing they would be more actively involved in that than the department itself.
Well, who runs that system? Yes.
So it is run by the department, but Minister Watt very rightly puts out that a lot of the operational input into that system comes from the Federal Police and from ASIO. And so there are a range of mechanisms by which we engage with them and with state and territory counterparts to respond to people who might return, who might seek to return, who are of interest to us.
So, but to be clear, it is a system managed by the Department of Home Affairs. Yes, there's operational elements managed by intelligence agencies, but the Home Affairs is saying no revision, no changes to the system post.
To the overarching framework that we manage, I think the point Minister Watt is making is that ASIO and the AFP may well have considered their elements of that and how they would respond.
I will certainly take up the Minister's invitation to ask them a little later on today. Can I ask then, has there been any further discussions between the Minister and the Department, or the Minister and a third party, or the Department and a third party around assisting any further individuals out of this cohort, beyond the 6, I gather it is, that we have here now back to Australia, or relating to the efforts of a third party to assist any of these individuals back to Australia?
Just to be clear, Senator, and again, I recognise you weren't a member of the committee at earlier times, but that group of 6 that returned to Australia was not the first group. In 2019, obviously, former government repatriated 2 groups of unaccompanied Australian minors, 8 minors, from a IDP camp in Syria. In October 2022, this government repatriated 4 Australian women and their 13 Australian children. And then there was the more recent group of 6 who were not repatriated and returned here of their own accord.
Yes.
So I just wanted to be clear about the...
No, aware of the history, yes, and obviously there's a distinction between a minor and an adult, a consenting
and also
adult.
A distinction between an organised repatriation and merely fulfilling legal obligations and then leaving it to the people concerned to make their own way back if they are able.
Yes. So it's an important distinction, which is why I asked about any discussions between third parties that may or may not be assisting. So if I can go back to that question, has there been any of those discussions between the Minister and any third party, the Department and any third party, in relation to any further self-managed returns of anyone from that cohort?
So, Senator, if I'm understanding the intent of your question, have we had any discussion, have we, the Department, and obviously I won't answer for the Minister, have we had any discussions with third party about providing assistance to this cohort? No.
And any discussion about this cohort with a third party? Not necessarily about providing assistance, because as the Ministers and yourself have both said, it's not about providing assistance, but about the return of anyone from this cohort.
So, Senator, I make a distinction between third party being, as I think you're intending it, someone outside government.
Indeed.
The answer is unquestionably no. But of course, the system I described before about ensuring that we respond to people who might wish to come back to Australia, that involves discussions within government.
Within government, yes. Yes, but not third parties, you're saying.
For example, the development of a plan with AFP and ASIO input should Mr Hansford choose to return to Australia as a person of interest, to make sure that appropriate safeguards are in place to protect community safety. So that's the nature of the discussion internal to government, and I think
that is a function that's quite distinct from the question you're asking me. Are we talking to third parties about their return? No.
Yes, well, we'll come back to that, I'm sure. Thanks.
That escalated quickly, Mr. Hand.
It's I'd just like to clarify that's a hypothetical.
Yes, I was going to say, if you're in that
the
role,
Secretary was referring
you're
to.
on our watch list or interest list.
Thank you, Senator Dunning. Senator Shoebridge.
Thank you, Chair. I didn't hear Senator Pocock's questions on firearms. Did they cover the firearms registry? I didn't think they did.
It was more about compensation.
Well, I have some questions about the National Firearms Registry. I think that was transferred from AG's to Home Affairs as a result of the changes in June, is that right?
It was, Senator.
Yep. Now, when I asked the Attorney-Generals about progress on the Firearms Registry in February last year, they said that they had a 4-year timeframe to implement it, and that they weren't expecting it to be up and running until years into the future. When I challenged them about how that could possibly be the case, given the relatively limited scope of a national firearms registry, I'm sure it's got some data challenges, but I asked how they could do that, and then they told me that it was, to quote Attorney-Generals, incredibly ambitious for them to plan to have it in place years into the future. I note that the commitment has been made by the government to have it up and running, I think, by the end of this year. And I support that commitment. It's a good commitment. But given what we heard from the Attorney-Generals just in February of last year, can you explain to me what's changed, what the resources is, what the tempo is that means it's going to be in place by the end of this year?
So, Senator, Mr Hansford would be very happy to run you through exactly how we're going about expediting that process. But to support colleagues from Attorney-General's Department, it is an extremely significant undertaking, bringing together what has been done often in a manual way, state by state, into a national register. What we are seeking to do is to take a staged approach to getting this functional as quickly as we can.
That's right. And just to clarify, Senator, we have the policy responsibility for the National Firearms Register, and it's being implemented by the Australian Criminal Intelligence Commission, so they might add some more information later today. But it is fair to say that the Minister for Home Affairs asked that the National Firearms Register, the Commonwealth elements, be expedited. This was then subject to a discussion and agreement at Police Ministers' Council in October last year, and the key Commonwealth elements of the National Firearms Register are being progressed by ACIC to enable them to complete that this calendar year, and they again can speak to their progress in relation to that. There is substantial funding that has been allocated both to ACIC but equally to states and territories to enable them to then connect into the National Firearms Register. Each state and territory is at various stages of their maturity, if you like, in terms of whether or not they have a digital system or a paper-based system, and so they're then working through, following the agreement from police ministers in October, how they might well expedite each of their different elements.
So what's Home Affairs' role? If the ACIC's job, is it their job to operationalise it, to hold the database and make it actually work?
That's correct, Senator.
What is your role?
So we have two roles. One is our policy role to provide advice to the government on firearms issues, but then we also have an operational role that Mr Engel manages in relation to permitting of firearms and different technical upgrades in relation to those systems. So there's two different elements.
All right. What's the permitting role?
Yes, Senator.
Permitting, what is the role in issuing permits that Home Affairs has?
Yeah, so we're predominantly a policy branch, but we do have an element which is firearms import applications that the Commonwealth does, and so we have a system for that. So the broad national discussion, obviously, to get agreement at National Cabinet all that time ago, and then we have a very direct role with our own specific system too.
All right, so you're import-export. Can I ask you, is the goal then, just to sort of speak in practical terms, is what the Commonwealth has committed to do is to have a piece of software, or maybe multiple pieces of software, and whatever hardware is needed to go with that, and common agreed parameters for data sets, and have that up and running by the end of this year. And then hopefully states and territories will be picking up their databases and implementing them into that. But what the Commonwealth is committing to is that central architecture.
That's broadly correct, Senator. But I would note that police ministers at the Police Ministers' Council also agreed to expedite the state and territory input to that central system.
I understand Home Affairs can't force the New South Wales Police Force to move their data, and that requires that political will, collective political will from state and territory governments around the country to make that happen. But to just get an understanding, by the end of this year, the Commonwealth has committed to having that core architecture in place, including, does that include agreed defined terms and data points, so as we have common data for firearms and firearm registry information around the country?
Yeah, so we already have agreement from the states and territories to national data standards, so that's some of the work that we've been doing. And then there's also a range of, I guess you would call them from the Commonwealth level because we don't own a lot of this legislation, some operational policy agreement as well, because states and territories may have to some may just need to change business processes, some may need to make minor tweaks to legislation
to permit the data to sit on a Commonwealth database.
Yeah, and it might be, and even the near real time, I think we've talked about before at previous, which is the information in there, we want it much quicker than maybe potentially paper-based that we have at the moment. So some states might require a dealer, for example, to input that information into a portal to their state registry in a quicker time frame, and then that feeds into the NFR. That's just one example of a operational policy that we needed to settle with them.
Yeah, and the database will have to allow for some heterogeneity at that point in terms of data entry.
Yeah, so the concept would be, and ACIC can talk to more of this, would be that the state registries are feeding information into that central architecture.
Who is responsible for the arm twisting negotiations, however you want to describe it, of states and territories to ensure they live up to the end of the bargain?
So that collaboration is led by the Minister for Home Affairs.
All right. Where are we up to in terms of commitments from state and territories in terms of timeliness of getting their data onto the national database? And it might be useful to go through the different jurisdictions because there's different levels of political support and resistance across the country.
So, Senator, as I said earlier, at the Police Ministers' Council, all police ministers agreed to expedite their process. How that is playing out operationally, Mr Engel might be able to give us some idea, but I don't think we have a schedule that says, you know, Tassie by here, WA by there, because we are still working through with them what they can do.
Well, if we can, so far as you can shed light on state by state, territory by territory, Mr Engel, where are we up to nationally?
Yeah, so I'd say ACIC will be able to better shed light because they're managing the overall project governance, for want of a better word, but we would say that from the end of 2026 we expect more mature states, for example New South Wales, they can onboard fairly quickly, but the ones that are moving from paper-based systems, they're the ones that we're dealing with. But we don't have, I wouldn't say we'd have an exact adoption date for each state and territory yet. That continues to be the work of the ACIC with them.
So what are the more mature states in terms of their data sets for firearms? You say New South Wales, which has an online database. What other states?
Yeah, so I can run through, but I would just put a caveat that ACIC would be better to make judgments on the stages of these registries, but just in a a broad sense.
Yes.
It's likely that New South Wales, South Australia, WA are probably slightly further ahead, but I just asterisk that with ACIC. But then we know that other jurisdictions have to build a registry from the beginning or replace paper-based, so that would be ACT, particularly potentially partly paper, partly digital, Tasmania, Northern Territory. And I'd also just add that running alongside the NFR, we required them to upgrade and improve registries right across the country. At the same time, states and territories, some of their registries might have been getting to end of life, so there was a broader conversation that they were having about replacement. So related to the NFR, but more broadly, they might be involved in procurement practices that might be beyond what they need for the NFR as well. So those two things interact.
And the one state you have mentioned in that is Queensland?
I'd
Where
let
does
ACIC
Queensland
judge probably exactly where they're up to.
I'm going to rotate the call.
But Senator, I would say at the Police Ministers' Council, there was broad support and agreement to expedite.
Right.
So,
Thank you, Senator Shoebridge. Senator Dunham.
I might just ask a question, not in the sequence I was asking before, but given there's a short period of time here. There was a report in the Nightly that a senior Home Affairs official who is currently serving as the Department's Deputy Counter-Terrorism Coordinator has been appointed to the Prime Minister's new National Security Advisor. Is that the case?
One of our First Assistant Secretaries has just been appointed as PM's National Security Advisor.
Yes. So has that individual taken up this role in the Prime Minister's office or not yet?
We're in a period of handover transition, Senator.
A hiatus, okay. And that role that is being left vacant by this individual, what's the process for, because that's quite a significant role, Deputy Counter-Terrorism Coordinator.
It certainly is. It also is the head of our Counter-Terrorism Coordination Centre. Mr Hansford and I have identified the officer who we are transferring in. It's an officer who's already at level.
Okay.
I'm not naming the person because we are, I think, yet to issue the staff notice that I cleared this morning.
Okay.
But that is imminent. In light of exactly what you said, Senator, we were not going to leave that position vacant.
Okay, so it'll be as soon as one individual vacates, there'll be someone to backfill in and we'll be as safe as we were yesterday.
You bet.
Excellent, okay. That's good news, and the readers of the Nightly will be happy that their article's been confirmed. So congratulations to the individual who's moving to the PMO. I just wanted to go back, and I may not have much time, the questions we were asking before about meetings with third parties, and I may have misheard or misunderstood what you said, but you said categorically that there were not meetings with third parties. The department did not meet with third parties with regard to the return, assisted or otherwise, of this cohort of people.
So Senator, my memory is your question was framed in the context of post-Bondi. So clearly on record is the fact that the Minister had two meetings and that there was a departmental official at each of those.
Yes, and so no meetings since then, though?
That's correct, Senator.
Okay. All right. And I will probably, when we come back, continue my line of questioning on that issue.
Certainly.
Thank you, Senator Dunham. We are a couple of minutes before lunch, but we might head there early. But before we do, I'll let the Australian Transaction Reports and Analysis Centre know that we are in a position to release you. So thank you very much for your time. We will return at 2:30 with outcome 1.
Some of them with stakeholders, some of them with other ministers, or a lot of departmental ones. So not unusual for me to be in such a meeting.
Sure. So it's normally by request, though. It's not just because there would be managers from DepSec down for certain line areas with expertise. Having the secretary at a meeting is probably not. While you attend them, it wouldn't be the norm.
Senator, I'm hard-pressed to actually say what the norm would be.
Fair enough.
It really is very case-dependent, and
yes.
sometimes I will, ask to be in a meeting because it's an issue I'm trying to manage in some other context. Sometimes the minister might ask, sometimes his office might decide that they would like me or a particular deputy or someone else there. And sometimes they'll, of course, just say, can we have a note taker?
Okay, all right. When you attended the meeting for which these are your handwritten notes that were provided.
They
on
are,
notice.
Senator.
Yes. When you attended that meeting, did you have an understanding of what that meeting was going to be about?
Well, I understood that Save the Children had obviously had a long-standing focus on the cohort of Australian women and children in Syria, so I assumed that they would be making representations on their behalf.
And did you have any discussion prior to the meeting with the Minister's office about what the intended aim of the meeting was, insofar as, because as you say, the government goes as far as its legal obligations to its citizens and no further, that's the government's position, what the point of the meeting would be, given this group are heavily committed to getting a certain outcome for these individuals?
Not to my recollection, Senator. I would make the point that it was now well over a year ago.
Yes, of course. But thankfully we have your notes from the meeting, so we might just turn to those and I'll deal with just to be clear though, the meeting at which your handwritten notes were taken, were they on the 13th of June, or what date were they from?
No, Senator. Mr. Hansford's just pulling up the timeline, but that particular meeting, from memory, was 9 October 2024.
Okay, so the meeting that had the official note taker was a year late, well, half,
13th
part
of
of the
June.
year, yes, okay. All right, well, we'll go back to your notes then. So the notes obviously talk about the situation on the ground there. I presume this is commentary being provided by the representatives of Save the Children. And just for clarity, are the same representatives that were in the meeting on the 13th of June 2025?
Senator, my understanding is that the notes from June 2025 indicate that Jamal Rifi was in attendance and he was not in attendance at the October meeting.
Okay, is that the only attendee at the June 2025 meeting? There were a number, I think. You had Jamal Rifi, you had Kamel Debussy and Matt Tinkler.
And so Mr. Tinkler and Mr. Debussy were at the October meeting.
Okay, all right. It references here in the notes, worked with Christina Kay. I presume that's former Senator Christina Keneally?
Senator, I would be speculating if I were to sort of try and interpret notes that, as I said, date back now well over a year.
They're your notes of a meeting at which you were present. They've, as you say, formed part of the public record now and were well documented. I assume we touched on them at the last estimates, and I remember seeing them on TV, as a matter of fact, after that point, so they've had a fair bit of attention. You're certain you don't recall whether the reference to Christina Kay at the beginning of these notes was Christina Keneally?
No, Senator. As I said, I would be speculating. I would have attended thousands of meetings since October 2024.
Okay. Then I presume we may be in the same space with reference to two other individuals, again on the first page, Penny and Claire. Would that be the Foreign Minister and the former Home Affairs Minister?
Again, Senator, I would be speculating at this distance.
So, yes. Well, then maybe we'll turn over the page. And there is on the second page, about a quarter of the way down, there are two initials, TB. Now, can I understand from you, are they the initials of the Minister?
It's a matter of fact, Senator, that they are the Minister's initials.
And so to that end, does the fact that you've inscribed those there mean from that point on they are the comments made by the Minister?
Senator, I am not going to speculate about what I might have meant in some handwritten notes over a year ago. The notes stand for themselves.
Well, that's the problem. They don't, Secretary. I mean, so I would understand you not wanting to speculate on handwritten notes by the Minister or Mr Hansford or anyone else, but they're yours and it's a well-documented meeting, and I can't go to any other source other than the person that wrote the notes to get as good an understanding as possible than you, and I'm trying to assist you in recalling when you wrote TB on the page, whether from that point on they were comments made by the Minister in that meeting.
So, Senator, I understand your question, but that would require me to remember, is that exactly how that meeting played out? Did I write some initials and not other initials? And I would be speculating after this passage of time.
You strike me as someone with a very, very good memory, Ms Foster. So look, I'll persist. Beyond that initial, and we don't know who this is attributed to, it says C' meant. I presume that is commitment?
Again, Senator, I'm not going to speculate about what the notes may or may not mean.
Do you retain all of your handwritten notes out of meetings?
Senator, I will often take notes to remind myself of an action, and then if there is no requirement to keep them and that action is done, I may not retain them.
So why did you retain these notes?
Senator, I don't know. I would be speculating about what decisions I made nearly 18 months ago.
So these have formed part of an answer to a question on notice. So somehow they are an official record held by the Department of Home Affairs, I can only assume, given it was provided in response to a question.
So the question was very directly, did you take a note? And I said I would need to check because I did not recall at the estimates hearing where I was asked whether I had. And when I checked my notebook, I had indeed taken a note and retained it, and therefore I provided it in response to the question.
Okay, which is excellent. I'm pleased you did, although, as you said, these notes normally remind you of things, and I know it's been 18 months. So we don't know whether C' meant means commitment, but that sentence says C meant to find a way. Further down then, KD, Mr Debussy, Kamel Debussy, I assume, is who that initial refers to. Would I be right in making that assumption?
Again, Senator, you're factually correct that those are the initials.
So is it your recollection of this meeting that the Save the Children representatives wanted to know how to assist the government in finding a way to achieve the outcome they themselves, Save the Children, were seeking to achieve, and that was to assist these women and children back to Australia?
So, Senator, when the questions were first posed about this meeting, I recall Minister Watt gave a summary based on his advice, which was that the outcome of the meeting was that no assistance would be provided to the women and children, and I said at the time that that was also my broad recollection of the meeting.
Okay, I have to share the call. We'll come back.
Thank you, Senator Duniam. Senator Shoebridge.
Thanks, Chair. Secretary, when was the Home Affairs Minister first briefed, if at all, about the ACRAMs as potential or actual terrorist threats or actors?
So, Senator, I've said in response to earlier questions, any detail about the ACRAMs could go to the criminal proceedings that are underway, and not knowing what may or may not be sensitive, I'm not in a position to answer questions about them.
I, for the life of me, can't work out how telling us when or if the Minister was briefed about them or one or other of them, and the dates on which that happened could have any impact on criminal proceedings. So I'm going to ask this question. When was the Minister first briefed, if at all, about the ACRAMs or either of them as potential or actual terrorism threats?
So, Senator, I have nothing to add to my further evidence. I do not know what might or might not prejudice the criminal proceedings, and therefore I'm not in a position to answer questions that might go to them.
Well, Secretary, you don't get to choose when to respond or not to respond. If you wish to take a public interest immunity claim, the Chair articulated how that happens at the beginning of the meeting. So again, I'm going to ask, when, if at all, was the Minister first briefed about the ACRAMs or either of them as potential or actual terrorism threats?
I'll take that on notice, Senator.
Was the Minister informed at any time that a former ASIO agent had Was the Minister informed at any time that an ASIO agent had deep concerns about the ideology and the potential or actual terrorism ideology of the ACRAMs, or either of them?
Senator, my response to the previous question applies to this also, and I will therefore also take that on notice.
What, if any, coordination occurred between Home Affairs and any of ASIO, AFP and the New South Wales Police regarding the ACRAMs or either of them between 2019 and 2025?
Senator, I'll take that on notice.
What role does Home Affairs play in monitoring individuals who travel to the Philippines and to potential ISIS hotspots or training centres in the Philippines? Do you have an ongoing role in monitoring such movements?
Senator, there is a process which involves a system of alerts which is managed by the Border Force.
All right. And
I would note, though, Senator, that the Philippines as a destination is not an unusual destination. As in, the Philippines as a total country is visited by many, many people.
yes, but of course if somebody has been brought to the attention of Home Affairs because they may have actual or potential terrorism links, would that ordinarily trigger some kind of notice if they went to the Philippines, given that there are parts of the Philippines where terrorist activities and training occur?
So, Senator, I think you're taking us back into territory of whether or not there was notice of the ACRAMs, and I've got nothing to add to my further answers on that.
I'm trying to understand going forward what, if any, checks are in place for Home Affairs if people have been identified by either Home Affairs or another government agency as having potential or actual extremist ideology, if there's any checks in place right now when they travel to the Philippines, given the evidence that's available about potential contact with ISIS and similar ideologies in the Philippines. I'm trying to work out what the situation now is. And it may be there isn't anything in place, but I think the public would like to know if there is something in place.
So, Senator, the Border Force Commissioner can outline to you the generic process which applies. I would make the point that in doing so we are making no comment on this particular case.
Mr Reynolds, I note the invitation from the Secretary, but I'd appreciate you answering my question.
Gav Reynolds, Australian Border Force Commissioner. Good afternoon, Senator. As the Secretary articulated, we use an alert system on the border. The alert system relates to individuals. If we receive any information about an individual that they're moving to conduct a criminal act or coming back into Australia to conduct a criminal act, then we will intervene on the border.
All right. So would it be usual if a security agency, whether it's the New South Wales Police, the Australian Federal Police or ASIO, had evidence that somebody in Australia was under investigation for potential terrorist links and terrorist ideology, would that ordinarily trigger them being on the alert list? Would you ordinarily expect that information to be provided to Border Force?
Senator, all alerts are unique. It will absolutely depend on the individual circumstances.
Well, indeed. But the fact that somebody is under investigation for potential or actual terrorism training or ideology in Australia, would that meet the threshold, the statutory threshold, for them to be put on the alert?
Senator, that's a hypothetical question. It will absolutely depend on the individual circumstances associated with the individual.
Well, what is the statutory threshold? What's the test? You manage it. You must know what the test is to get on the alert. What is the test?
Senator, as I have been articulating, it is unique. It is different for each individual.
The application may be different, but there must be a policy or a statutory test that's applied. What's the policy or statutory test that's applied before somebody goes on the alert list?
The alert will be determined by the Australian Border Force, the Department of Home Affairs, or another agency or a government department.
Against what criteria? What statutory criteria? You can't just randomly pick someone up because you don't like the colour of their clothes. Maybe you can, but you shouldn't be able to. I'm assuming there's some statutory test, some criteria that you apply before somebody goes on the alert list so that they're watched when they come and go out of the country. What are the criteria?
The criteria, Senator, is different for each individual circumstance.
No, the application may be different, but the criteria, the policy, the threshold under which people go is quite separate to the heterogeneous application of policy. There must be some statutory. If you don't know, that's okay. But there must be some statutory criteria or policy criteria before someone is put on the alert list. What is the statutory or policy criteria before someone is put on the alert list? And if you don't know, I mean, you're just the Commissioner. I understand there may be other people who do this, but if you don't know, say you don't know. But if you do know, tell us what it is.
Senator, the alert management system is a classified policy instruction. I will not be discussing it publicly.
Well, I'm asking you to provide an answer about what the criteria are. If you wish to take a public interest immunity claim in response to that, the Chair articulated at the beginning of this meeting how to take a public interest immunity claim. So I'm going to ask you again, what is the criteria which Border Force applies before somebody is put on the alert?
Senator, I will take your question on notice.
Good luck to the Royal Commission.
Unnecessary additional commentary, Senator Shoebridge. Senator Duniam.
Thank you, Chair. So if we can come back to these notes, Secretary, do you have them there with you, a copy of the notes from the question on notice?
I do, Senator.
You do. So if I could take you to what is the second page of those notes and where those initials I pointed out before, TB, can you read that first line, first dot point beyond the TB to me?
C apostrophe meant to, word crossed out, find a way.
And so does that jog your memory at all as to what that related to?
No, Senator.
Okay. What about the next line? Are there any elements there that in any way I can take you to? The next line starts with the word delay. If you read that sentence, do you know what delay we were talking about at that meeting?
Senator, I would be speculating.
Were there any action items out of this meeting?
Not to my recollection, Senator.
And so before you made the point that you keep notes with an action item, on the final page there is another reference to TB. Can you step through the first line there? I believe it says contact in depth, short for department. Was that an action item at all?
So, Senator, I said before that I often took notes when there was an action. You know, I made a note when I needed to follow up on an action. I will typically annotate that as an action, and I have not in this case.
So were any contact details provided to representatives of Save the Children at that meeting of any officer in the department?
Not to my recollection, Senator.
And do you know whether any follow-up work was undertaken or assistance provided to Save the Children by any representative of the department following that meeting?
Not to my knowledge, Senator.
So out of that meeting that you attended as Secretary, which we said is not unusual, but probably not the norm, who knows, there would be no record of any action item requested of departmental officials placed by you as a follow-up to attendance at that meeting?
That's correct, Senator. And as I said, I will usually annotate a note to make it clear that I have an action, and that has not been done.
Okay. Have you personally met with any representatives of Save the Children since that meeting?
So, Senator, the only two times I've met with, the only time I believe I've met with Save the Children is in that meeting.
That's the only time you've met with them?
That's correct, Senator.
Okay. Have you asked for any representatives to meet on your behalf from within the department?
No, I have not.
Since that time? No. Okay. Was there any request at that meeting to not publicise the events of that meeting, or the fact that the meeting was occurring, or the issues that the meeting was related to?
Not to my recollection, Senator.
Okay. The other meeting that we have the meeting notes of, which occurred on the 13th of June 2025, just with regard to those particular notes that were provided on notice from last estimate, the estimates before, were there any action items out of those notes?
Not to my knowledge, Senator.
And is there any different status between the notes taken by this note taker who was asked to leave the room and your notes coming out of a meeting in terms of records or documents in the department's possession?
I'm not sure I quite understand the question, Senator.
So your notes, your handwritten notes that were in a notebook that you were able to procure in answer to a question on notice, are they an official record of the department?
Senator, I'd have to seek advice on that from my experts in that relevant area, in terms of, exactly what constitutes an official record.
Yes.
But certainly, as you can see, they were handwritten notes, not transcribed into a formal record.
Yes. Just given they were provided, it seemed to indicate to me that there was a level of seriousness attached to them. I mean, these are a formal record. The other notes, so they are an official record of the department's meetings, these ones of the 13th of June 2025, is that?
Again, Senator, I would just like to check with my officials about what exactly is, but they are a record of the meeting that happened, as opposed to my handwritten notes, which could or could not be comprehensive.
Sure. I'm sure they're very comprehensive, but we'll never get to test that. I just wanted to seek some guidance in relation to the outcome in which I would ask about the NZYQ cohort. Is that outcome 2, or?
I think we typically do NZYQ in 3.
In 3,
because of the crossover between the immigration and the border force elements.
Sure.
But I'm just looking to make sure. Yes, that's correct.
Okay, so we'll wait until then for them. If I could ask about the Electronic Surveillance Act, is that something I can do here, or is that?
You could. We are still in outcome 1.
Well, how
and
about I
that's
leave
an
that for
outcome 1
outcome
issue.
2? Paul Scar, did you have any in this section?
Ms Foster, can I just, I've been listening very closely to your discussion of your daily...
Handing over the call?
It's just one follow-up question.
Sorry.
I've been listening very closely to your discussion with respect to your handwritten note, and you've used the word speculate, that you'd be speculating about the content of the handwritten note. Given it's a contemporaneous note, given you are the author of the note, you're not in a position to at the very least say it's likely, it's more likely than not on the balance of probabilities, that probably means X, Y, Z, as opposed to using this term speculate, which if you're reading someone else's handwritten note, sure, it'd be speculation, but it's your handwritten note. It wasn't 10 years ago. You're an extraordinarily intelligent secretary. You can't tell us what it's more likely than not when you said C''MENT, you're more likely than not meant commitment.
So, Senator, the reason I'm hesitating is twofold. The first is that unless I know something to be a fact, I'm very reluctant to put it forward. And with the passage of time, it's very difficult for me to recall
how that meeting played out, whether, for example, I took notes for a short period and then not, whether or not I put initials beside everyone who spoke or not. And that's why I'm using the word speculating, because I don't know for a fact the answer to the questions that I'm being asked.
Okay.
Done, Senator Scott?
Yep.
Thank you for your efficiency. Senator Mackenzie.
Thank you. Just returning to my questions on firearms, I just wanted to understand, had we got an update on those 4 areas, how they actually ended up on the National Cabinet agenda? The limits to the number of guns held by individuals, limiting open-ended firearm licensing, limiting the types of guns that are legal, and the Australian citizenship as a condition of holding a firearm licence.
Senator, I think we've said that in collaboration with PM&C, there was a paper developed that was provided.
I'm trying to work out who suggested what. I understand the collaboration and the paper's developed and it goes where it has to go and people do with it what they will. You said there's a policy.
I think what Mr Hansford is saying is we have no further information since your last bracket of questioning.
No worries. We'll go to PM&C. At the 7:22 press conference on Monday the 15th of December, the New South Wales Police Commissioner told journalists of the attackers the older man was deceased and I'm told he had a gun licence for approximately 10 years. That information was false, and the Commissioner on Tuesday the 16th corrected the record at a joint press conference with the Prime Minister, where he was able to correct the record that Sajid Akram hadn't held a firearm licence since 2015, that in fact he'd only held a firearm licence for 2 years. When the Prime Minister had the 2 p.m. announcement later that day, that government would review licences over a period of time and that you shouldn't be able to have a gun licence for life kind of thing, was the Prime Minister aware when he made those remarks that Mr Akram had only held a licence for 2 years? Or was the Prime Minister still under the belief that in fact he'd held it for over a decade?
We don't know that information, Senator.
It's clearly a question for Prime Minister's estimates, not this portfolio.
Okay, so my question is, did Home Affairs brief the Prime Minister about how long Mr Akram had held a firearms licence?
No, Senator.
Did Home Affairs know the detail that it wasn't a decade, it was only 2 years ago? Before, did you know before the Prime Minister's 2 o'clock press conference that Mr Akram only held a firearms licence for 2 years, not a decade?
Senator, from memory, we were following the press as it was coming out, but for us to recall exactly at what time we knew something, I think it's very difficult.
Well, on notice, Ms Foster, I would like the department to to actually let this committee know when the department was informed that the New South Wales Police Commissioner had got it wrong, and when the department informed PM&C or the Prime Minister's office or somebody in authority of that change.
So, Senator, as I said before, we were following this information in the media. We would not brief anyone on information that was public that was not our issue. So it was.
I appreciate you following the media.
If I could just finish, Senator.
Yeah, sure.
So the licence is, of course, issued by New South Wales Police. It was the New South Wales Police Commissioner who said something and corrected the record. I can't imagine a circumstance in which we would think we need to brief that. It's public and it's not our responsibility.
So I assume there is a level of information sharing between agencies across jurisdictions, particularly at a time like this. So I would be very surprised if the New South Wales Police Commissioner knew this and the federal department or agencies didn't, but I will pursue that with the AFP later. I wanted to understand, was the government's decision to end so-called open-ended firearms licence influenced by the incorrect information by the New South Wales Police that Mr Akram held a licence for approximately 10 years?
Senator, I don't know the answer.
Mr Hansford?
I think we were aware of some jurisdictions having open-ended firearms licensing independent from the particular situation that you're referring to. So I think there was a known policy issue and has been part of our policy deliberations. We'll just check if it then lines back to some of our consultations as well that I think we've taken on notice before.
Because it would... I would like to know when ending open-ended licensing arrangements became a formal policy position.
And yes, Senator, I think we've taken that on notice in the bracket of questions.
On the 15th of December, the New South Wales Police Commissioner disclosed that there were 2 improvised explosive devices found at the scene. They were taken by our rescue and bomb disposal unit. They were found to be active devices, so they were taken back and rendered safe by our police, who do a professional job. Is this an indication that if the attackers did not have firearms, they were equipped and planned to kill and harm innocent people using these explosive devices?
So, Senator, I'd make 2 points in response to that. That's a question which is properly addressed to either the Federal Police or to New South Wales Police.
Okay.
And secondly, my concern would be that it would go directly to evidence that might be given to a criminal proceeding.
I will follow up with the AFP later on today. Under the former coalition government, through the AG's department, there are ongoing engagements and consultations with the firearm industry in order to progress reforms under the NFA. Two key stakeholder engagement forums were the firearm industry stakeholder and the gun safety industry stakeholder consultative forums. In almost 4 years of the Albanese government, why has the government failed to convene meetings with these stakeholder groups? Well, Minister, I'm asking an opinion of government's decisions, so maybe...
Yeah, I'm just hesitating because I don't think I have that answer, so I can take it on notice for you.
Yep. I'd ask you for the why, and Ms Foster, can somebody at the table confirm that there has been no meetings of the firearm industry stakeholder group?
Senator, I can answer that one. So we've set this up after the import changes occurred to work through how we're going to operationalise those changes, so we're working closely with industry on that. Prior to this time, there was not a formal working group, but my team does engage regularly with the major firearms importers about how the permit application process and their role at the border occurs. So it's not that we haven't been meeting with them, I just wouldn't describe it as a formalised working group.
So since administration of the NFA transferred from AGs to Home Affairs, what firearm industry consultative forums, formally, not informal conversations or conversations that you might have with the industry generally, what formal consultative forums has Home Affairs established?
So in terms of, there's not, I think it's probably already mentioned, there's not like a ministerial forum that had currently existed. I know the Minister's commitment around that to do with the bill. We did have forums and stakeholder engagement, and we also do that alongside states and territories on the National Firearms Register, so that has been the key focus for the last couple of years. And then the National Firearms Agreement itself hasn't been open, I guess, if you want to frame it that way, for discussion. So the NFA has been the NFA until obviously the events and the National Cabinet decision here to take a look at it. So I guess we didn't have formalised discussions on the NFA per se, but we do meet with industry from time to time. We meet with other advocates and NGOs as well on firearms policy writ large.
What are the other advocates and NGOs that you meet with?
Yeah, I can probably...
On notice, if you could just
I'll take that on
provide
notice, mainly because some of the groupings that we meet with aren't comfortable necessarily identifying that they speak with us on firearms issues.
Yeah, I do.
And I think there's been 8 separate meetings on firearms issues in this calendar year, including one held by the Minister.
I just want to clarify, Minister, some of your evidence to Senator Pocock's earlier questions. When you said, I guess he was asking questions about the gun buyback, and on listening to your responses, are you saying that if all states and territories don't participate, that it won't be a national buyback scheme, or is the Commonwealth prepared to partner with certain states, depending on states' decisions to participate or not?
I think what I said was that we have yet to make that decision, but as the Prime Minister and others have said, this buyback scheme will only be as strong as its weakest link, and we would strongly encourage all states and territories to participate.
Well, I think Queensland, the Northern Territory, other states have made it very clear that they're not participating.
Yeah, and I'm very disappointed in that.
Why?
Because I think it's a good idea.
Shouldn't you be putting resources to getting illegal guns off the streets rather than attacking law-abiding firearm owners?
I think it's a good idea to keep Queenslanders and Northern Territory residents safe.
So the assumption of that comment, Minister, is that law-abiding firearm owners and the firearms we all own and house safely and use to participate in sport, to hunt feral animals, to represent our country, to enjoy our chosen sport on any given weekend, are a risk to Australian safety. Is that your evidence here today?
No, that's you putting words in my mouth.
It is actually what he said.
No, it's you putting words in my mouth.
We're buying guns from law-abiding firearm owners to keep Australians safe.
It's you putting words in my mouth, which I know is something you like to do. You know full well that the laws that we passed, which primarily concerned the importation of firearms, exempted a range of people such as sporting shooters, farmers, pest controllers, who you then went around telling that we were going to restrict their abilities when we weren't. And similarly, there is nothing in a national buyback that confiscates all guns from farmers, sporting shooters or pest controllers in the way that you like to pretend. I know that's your political agenda.
Well, I think there's actually an argument for how did you come up with the $1 billion? Ms Foster, you may be able to help the Minister here. The $1 billion that is budgeted for the National Firearm Buyback Scheme. How did we come at that number?
I might need some assistance from Mr Engel.
Yes.
Wanted to check, Senator, what you're referring to when you refer to that number, like in terms of we're still in development with government about that. Depending on the National Cabinet discussions with the states and territories, that'll obviously affect the cost of the scheme, depending on what National Cabinet agrees upon and how many states and territories choose to do firearms reforms, that will also affect, I guess,
so no submission's been made to ERC about this?
Senator, we wouldn't comment on...
I'm not asking for the details. Has a submission to ERC been made?
You know we wouldn't comment on that.
I'm not asking for the details. Has a submission been made? Have you put forward a request to the Treasurer for money?
You know we don't comment on that because it's a Cabinet matter.
This goes to refusing to admit that you have National Security Committee meetings, which is ridiculous.
Well, that's your opinion, but...
So no request has gone to fund, no request has gone to the Treasurer to fund the buyback. You're waiting for National Cabinet to come back with
That's your conclusion. I'm not commenting on that.
Well, because you refuse to comment on something so basic, Minister. I have other questions, so I'm happy to share the call.
Thank you. Senator Shoebridge.
Thanks, Chair. Secretary, at the end of June 2022, a member of Home Affairs, I think it was Deputy Secretary Ablong, travelled to the United Kingdom and attended a reception for the Defence and Security Media Advisory Committee in the UK. Are you aware of this?
No, I'm not, Senator. Personally, it predates my time in the department.
Well, who would be able to answer questions about attendance by members of Home Affairs to the UK to discuss the Defence and Security Media Advisory Committee in the UK?
So, Senator,
What year?
2022.
2020, from 4 years ago.
Senator, if you ask the questions...
Well, it's not 4 years ago, it's 3.5 years ago, but it's the 22nd of June 2022.
Senator, if you pose the questions, we'll see if there's an official who has the answers.
All right. Well, Deputy Secretary Ablong attended, and I think there's in the capacity, I think, as First Secretary, National Security, Department of Home Affairs. So who currently holds that position? Is that within your domain, Mr Hansford?
Could you repeat the title, Senator?
First Secretary, National Security, Department of Home Affairs.
Senator, First Secretary would indicate that that was an officer who was in the London Post.
Correct. Representing Home Affairs.
So
I'll read the title again. I'm more than happy for you to see the FOI, a copy of which I think I've given to the Secretariat, which identifies the title. First Secretary, National Security, Department of Home Affairs. So who would that, I assume it would have reported to your part of the organisation, Mr Hansford, given you're the head of national security?
So Senator, our staff on posting or operating in post have reported to different heads at any given time, and at the moment the reporting line is through to the Deputy Secretary Executive.
All right. Would we have the Deputy Secretary Executive in attendance?
We do, Senator. What I'm not sure about, and I'll invite Mr Hickey to come to the table, is whether or not that title will be the same now as it was in 2022, but we'll endeavour to answer your question if we have now a position called First Secretary National Security in London.
Well, my question isn't if you currently have First Secretary National Security in London. My question is, to whom would the First Secretary National Security for the Department of Home Affairs in London have been reporting to in June of 2022? And if whoever's representing that part of the department, if they could come forward to answer some questions.
So, Senator, we've had, as I said, a number of changes about the reporting lines. I don't know, and we'll have to take on notice. We'll see if we can find out where that position reported to in 2022.
Mr Hickey, do you currently have the equivalent of the First Secretary National Security Department of Home Affairs in London reporting through to you?
No, Senator.
Oh, so who does?
So Senator, we have a regional director in London, and the Home Affairs staff in post report to her.
All right, but London must report to somebody in Australia. So who in Australia do they report to?
London reports to Mr Hickey at the moment, Senator.
Right. So, Mr Hickey, when you said no, did you mean you don't have a direct report?
Correct, Senator.
But they report through the chain to you?
Yes, Senator.
All right. Do you know how long that arrangement, how long have you been in your current position?
Since mid-November 2025, Senator.
All right.
So, Senator, Mr Hickey is acting in this role.
All right. Do you know how long that arrangement has been in place? Where you're acting Deputy Secretary in what capacity, Mr Hickey?
Acting Deputy Secretary Executive, Senator.
All right. And is it the executive to whom the foreign missions report to?
The regional directors, Senator, so those senior officials in our posts report directly to me, yes, Senator.
Yes, so they report to you, but they report to you through the regional directors.
Sorry, Sam, the
That was Mr Hickey's evidence. The regional directors report to him, and the other staff in post
when I asked
report to them.
if the missions report to you, the answer is yes, they do, through the regional secretaries.
So I think the distinction, Mr Hickey,
is that right, Mr Hickey?
Senator, if I can just explain the distinction Mr Hickey was trying to make is the mission implies the whole of the Australian mission. He is specifying that it's actually the senior Home Affairs person in the mission who reports to him.
I'm only asking you about Home Affairs officials because I'm in Home Affairs Senate estimates. So the Home Affairs officials in missions around the world report through to you via regional representation model. Is that right, Mr Hickey?
Yes, Senator.
All right. And do you know if that arrangement was in place in June of 2022?
Senator, we're getting some answers to those questions. I don't have that information at hand.
Well, have you been provided with a copy of the documents from the FOI?
No,
if not, can you?
No, sorry, you hadn't asked them to be distributed, so I just...
Oh, I thought I did earlier.
No, sorry.
That's okay.
Yeah, so if you can get them. So just for clarification, the document won't be tabled because it's already publicly available, but distributing it so you know what the Senator Shivridge is speaking to.
Thank you, Senator.
There's a compilation of 3 documents, but the only one I'm going to be taking you to is the redacted email, which at the bottom of which has a little picture of Australia House and the word Australia House. Do you see that?
Yes, we can, Senator.
All right. And this is an email from the then First Secretary of National Security, dated 28th of June 2022, and it says, "Hi all, quick heads up that tomorrow evening X and I will attend the Defence and Security Media Advisory Committee's reception at Admiralty House. An overview of the DSMA is available here," and there's a link. And then it says this: "As you may be aware, HA," which I'm assuming is Home Affairs, "has been engaging with the DSMA Brigadier Jeffrey Dodds over the past year to inform work in Australia to stand up a similar role." Secretary, did you know that there's been this body of work in Home Affairs to stand up a similar role to the DSMA in the UK?
No, I didn't, Senator. That work was obviously taking place in the year before 2022.
The Defence and Security Media Advisory Committee issues what are called D notices in the UK, and D notices are censorship notices that prohibit media organisations or any entity publishing any information at risk of criminal penalty. They're effectively government silence notices. Mr Hickey, are you aware of any ongoing connection between Home Affairs and the Defence and Security Media Advisory Committee in the UK?
No, I'm not aware, Senator.
Well, Secretary, I'll ask through you because Mr Hickey may not be able to provide the answer on notice. What was the engagement between Home Affairs and DSMA leading up to and following the 28th of June 2022 email? And what steps had Home Affairs been taking, and what steps are they currently taking to set up a similar role, being a D-notice role in Australia?
Senator, I'll take the question of the historical elements on notice. I am unaware of any current work around D-notices.
Minister, have the issue of D-notices and your government wishing to get D-notices, which are censorship notices directed by the government to media and other outlets, are you aware of your government progressing this in any way?
No, I'm not.
Do you know if the minister's aware that his department has been seeking to stand up a similar role to the Defence and Security Media Advisory in the UK?
Well, I'll take that on notice, but as Ms Foster has pointed out, that is from a number of years ago, and I don't know whether that is was pursued or is being pursued, but I'm happy to take it on notice.
Can you, Secretary, provide dates of all of the occasions in which staff of Home Affairs met with the UK Defence and Security Media Advisory Committee, please?
I'll take that on notice, Senator.
Thank you.
Thank you, Senator Shoebridge. Got one clarifying question from...
Could I, while we're clarifying things, I've received some information since Senator Mackenzie's last questions and Senator Pocock's. I am informed that the national firearms buyback can proceed if certain states and territories don't sign up to it, but obviously those states and territories would not receive any Commonwealth financial support.
Thank you. Thank you for clarifying.
My clarifying question was just to make absolutely sure that questions relating to the electronic surveillance bill should be asked in outcome 2, not of the National Security Division. Is that right?
No, outcome 1, Senator.
It is outcome 1?
Yes.
Well, I will ask those questions if I can briefly. Are you right with that? Yes. Okay. I better read what they say now, Secretary. On that, so the 2019 Richardson Review did have in it a recommendation relating to the replacement of the existing electronic surveillance framework with an Act, and it was accepted by the former government, and there was a dedicated reform unit established and commitments made in 2022 with an exposure draft to be released by late 2022 and then final legislation in 2023. What progress has been made on that legislation and where is it at right now?
So, Senator, that legislative reform relates to 1,200 pages of legislation, and since the Richardson Review and response, the Department and the Attorney-General's Department, depending on where the function sat, has provided 10 submissions to the government since September 2022, including 400 pages worth of policy advice. There's been 14 meetings with ministers or their officers. Most recent meetings in Home Affairs were on 31 October 25, 14 December 25 and 31 January 26. Sorry, that's advice in those timeframes. We have issued drafting instructions for the electronic surveillance reform, most recently on the 28th of December. And since the 28th of December, there has been an ongoing discussion between OPC, the Office of Parliamentary Counsel, and the policy team.
Right, so that work is underway. So where is the legislation that was proposed to be released in 2023?
So this is the legislation that has been worked on for some years. As I said, it does relate to 1,200 pages of quite technical legislation, and I've given you a sense about where we're up to in the process.
Okay, so has it been a consistent effort on the way through, as in the resourcing allocated to the undertaking of this task from that point in time, post the 2019 Richardson Review, to where we're at now? Has it been a dedicated unit that have been working on this with the same staffing levels all the way through?
There's been a team working on this with varying levels of expenditure, which add up to, over that period of time from 2021, 22 right through to 25, 26, to about $11.3 million on expenditure in relation to that team. But we might make sure that we can give you an answer in relation to the volume of staff effort over time and a picture about what we've been doing.
But looking, Senator, at the figures, it would appear that there was a fairly consistent staff effort over those years.
Thank you for that. So when was the last stakeholder consultation on that? You've talked about meetings with ministers and a range of internal works. Was there any stakeholder consultation in relation to this?
Well, we are working with stakeholders internal to government. And so we are trying to formulate...
I mean outside of government, yes.
We are very much focused on drafting a proposal, and then the government will decide how they consult.
Okay, all right. So to that end, so no external consultation yet. You'll wait till you have the draft laws and then consult. The government will make a decision around consultation. That's fine. So you've issued drafting instructions. When do you expect an exposure draft to be released?
Well, we're working on the legislation, Senator. As I said, it's very, very complex given the volume, and we'll do that as diligently and as quickly as we reasonably can.
Is there a projected time frame, though? A year, this year, next year? Or is it a matter for government?
Senator, as Mr Hansford said, there's been a very significant amount of work done to date. Absent any particular challenges or things that we haven't anticipated, I would anticipate that we would be well progressed over the course of this year.
Okay. And so, Minister, is there a time frame the government wishes to have this legislation out for, an exposure draft at least out for consultation?
I'm not aware of anything beyond what Ms Foster has already said.
Okay. Thank you. My final question was in relation to the notes. Was any legal advice taken, internal, external, in making the decision to release those handwritten notes in answer to the question on notice?
No, Senator. It was very clear to me that when the Senate asks for something that I have, that's my obligation to provide it.
Oh,
if only everyone was, yes.
Spread the word, Secretary.
More of that, yes. Thank you. Thank you, Chair.
Before I go to Senator McKenzie for what will hopefully be our final block of questions in this outcome, indicating that to the officials in the room, I wish to advise that the committee is in a position to release the Australian Criminal Intelligence Commission, including the Australian Institute of Criminology. Thank you very much. Senator McKenzie.
Thank you. Yep, never mind. Just going back to the economic impact of the Firearm and Customs part of the Combating Anti-Semitism, Hate and Extremism Bill, was there an economic impact analysis done for that bill?
No, Senator.
No? Was there a RIS done?
No, Senator.
Is there a reason?
I think, Senator, we developed the proposed regulations and looked at how do we best respond to both the situation that's happened, but we've had for some time a range of different policy proposals that we had developed, and the regulatory impact statement, government did not ask us to develop one, and so we have not done one.
Okay. Is there a plan to understand the economic impact of the implementation of this bill?
We are certainly working, as I think we've indicated before, with stakeholders to work out the impact and to implement the reforms together with industry, and to work on how we do that in the best way possible. Obviously, when it relates to the gun buyback, we are doing very detailed analysis of the cost implications in relation to that.
Well, that's good, because you'll be able to help me with my next suite of question, and it is around compensation. When we've had buybacks in the past, whether it is in response to 96 or again in the early 2000s, buybacks were around fair market value for firearms, and that I would argue should be a pre-Bondi terrorist attack market value. Is the department developing up costings based on that as a methodology, rather than, for instance, the Western Australian model, which saw, the private property of law-abiding Australians devalued because of a government decision?
The department is working up options for the government, including costings.
Is one of the options costing according to fair market value, as per
Senator,
other Commonwealth buybacks, such as 1996 and 2003?
Senator Pocock, asked that question a couple of hours ago and was told that the officials were not in a position to say so because that related to advice to government and that work is ongoing.
So I think it's pretty fair, Minister, to ask, given Commonwealth buyback constitutionally has to be around fair. You can't go stealing from citizens, which if you didn't proceed with a fair market value costing for the firearms you're going to buy back, that's what this buyback would constitute. I think it's a pretty simple question for the officials to answer.
I'm happy to let them answer the question.
Senator, we have nothing to add to our further evidence, our previous evidence, sorry.
What about the businesses who right now have seen a flatlining of their turnover? Is the department aware of the economic impact being experienced by particularly dealers and importers as a result of these decisions?
So I think we've said, Senator, that in the at least 8 stakeholder meetings that we've had this calendar year, we are hearing a range of views from industry. We're taking those views into account in the advice that we're providing to government, including provision of costing advice.
But has industry made it clear the negative impact that these...
Some industry, Senator, have made
Mr. Engel,
those points.
You're the one meeting with industry. Why don't we ask you?
Ms Spencer does as well. But yes,
so has industry made that clear? Is the department clear about the negative economic impact that's being experienced right now?
Yes, Senator.
Yeah, thank you. And you are actively taking those views into account in the development of your advice to government?
Yes, Senator.
Okay. Shooting groups were excluded from the public hearing process, and yet anti-gun groups like the Alana and Madeline Foundation, which the Prime Minister is a patron of, were included. What was the rationale for talking to anti-gun groups and refusing to meet with the industry, which employs thousands of Australians, represents millions of law-abiding Australians and contributes over $7 billion to our economy nationally, not to mention a few Olympians?
Senator, I think the scheduling of the parliamentary hearing and who attended is a matter for that parliamentary committee. What I can say is we have met with a range of stakeholders, including some of the ones that you've mentioned.
So that isn't my question. I don't care to go to the details of PJSIS deliberations.
But that was your question. Why were they
No,
excluded
my
from
question
the
was
inquiry?
when a department drafts up legislation on advice from government or on request from government, they don't do that in a vacuum. They check the experts. They understand the impacts. Usually you would do an economic or a regulatory impact study. That wasn't done with respect to this legislation, probably on request from the government. I haven't heard otherwise. So who did the department consult outside of PJSIS submissions in the drafting of this legislation?
Senator, during the exposure draft stage of the legislation, I personally chaired a number of meetings with all the groups that you mentioned to provide...
So can you just run me through the list of the groups that... Thank you, Ms Spencer.
Certainly. And as Mr Engel said previously, there are some who are not comfortable with me listing individual organisation names, but I can give you a sense of the meetings that I did have during that period.
Thank you.
So on the 14th of January, I met with what I would term firearms industry representatives. That included Shooting Industry Foundation Australia and Sporting Shooters Association of Australia. On the same day, I met with firearms users. So similar grouping, Shooters Union Australia, Target Rifle Australia, National Rifle Association of Australia and others. And on the 15th, I met with public safety and firearms advocacy groups in a similar...
Sorry, when you say firearm advocacy, myself as a law-abiding firearm owner, I think they're on my team. Are they on my team?
Sorry, I'll try and find a better, I guess, firearm safety, public safety, medical groups.
Anti-gun?
No, I don't think that's unfair to wait. I mean, if you want to reduce this to pro-gun and anti-gun, I mean, that's pretty childish.
Oh, I don't think so, Minister, because...
We're talking about groups who believe that laws should be strengthened to protect Australians from being shot. That's what those groups are.
Wow.
They're not anti-gun.
So law-abiding firearm owners who are the ones impacted by this, who aren't Islamic terrorists,
I would argue that people who are shot by guns are also impacted by gun laws.
Why can't your government say that it was never about the gun? It is actually Islamic terrorists that shot those people on Bondi.
That's your view. That's your view. Our view, which we've stated over and over again,
is that it wasn't? It's not Islamic terrorism?
That's not what we said. What we've said, if you were here earlier, you would have heard me say that the government has consistently said that our response has been based on the motive for the shootings and the means with which it occurred.
What about the bombs in the car, Minister? What about the bombs in the car?
What about them?
So how are you going to deal with that threat?
Well, there were actually aspects of our laws, if you'd bothered to read them, that went to bomb making and importation of items regarding that as well. But you never made it past the front page that you signed for social media.
Because you were deflecting from the actual cause, and you still are.
No, we're not.
In every single comment you've made today,
have you seen the comments?
You are blaming law-abiding firearm owners, less guns,
That's your narrative.
more safety.
That's your narrative.
That's not true.
That's not. No,
the data
I've told you
doesn't. The data doesn't show that, Minister.
I've told you that our legislation, which you clearly didn't bother to read, exempted sporting shooters, farmers, pest controllers, a range of other groups. That didn't stop you going out there and telling those groups that they were going to be captured by the laws that they were exempted from. That's your call if you want to misrepresent the laws.
Wow.
What we've always said is that this
will go down well in Victoria for Jacinta Allen.
Well, some of us, like you, seem to be obsessed with fighting Victorian state elections. Some of us are actually here to do federal politics and change gun laws to protect Australians.
No, what you're doing is blaming law-abiding firearm owners for an Islamic terrorist attack.
We've never done that.
And you just did it.
And
2 weeks ago you did it.
You might care, Senator, to look at the remarks made by the brother of Peter Maher, one of the victims of this shooting, at the funeral, where he made the point,
that this is not actually
you don't want to listen to what he said, the brother of someone who was killed at Bondi, where he made the point, effectively, that the words were something like, an anti-Semite is an anti-Semite, and anti-Semite with a gun is what causes people to be killed. You should
These
reflect
Islamists
on
should
what
never
those
have had
people
a
say.
licence, and the Royal Commission will work out how they had it.
Sure.
But to blame and target law-abiding Australians as a result of a failure of law, firearm regulators in New South Wales and intelligence agencies.
Have you read the bill?
Sorry, can we can I just interrupt here?
I will move on, Chair.
You should read
Appreciate moving on.
Thank you.
We're already well behind in the schedule. And so if we could get back to the usual programming of asking questions and people answering questions, it'd be much appreciated. I'm keen for us to get on to outcome 2.
Thank you. Can we explain why it might be necessary to pay less than market value for firearms or the loss of business earnings?
Well, no one has said that. That's you making stuff up again. No one has said that.
So there's no circumstances where it would be necessary to pay less?
What we've said is that departmental officials are preparing advice for ministers about the compensation scheme that will apply. They're not in a position to explain that because it's advice to government. You're the person who's making up what may or may not happen.
Let's try not
just
to.
Like you made
let's
up
try and be above personal attacks, Minister, shall we? In the Act, the Minister must approve each state's buyback scheme. Does the Minister intend to approve schemes that do not pay fair market value? If that is a state's proposal to the Minister.
Again, I'm happy for the officials to answer, but I imagine that is something that advice is being prepared on.
Indeed, Senator.
Does the Minister intend to approve schemes that do not pay fair business compensation?
Senator, I won't. We are yet to provide the Minister with consolidated advice. To ask questions about his intent is premature.
I'm going to finish my questions. Will the government insist that states pay fair market value and that they include accessories, ammunition and business compensation?
Senator, that's all part of the same series of questions you've been asking. We've got nothing to add to our previous evidence.
What evidence has the government considered in the drafting of the Combating Anti-Semitism, Hate and Extremism, Firearms and Custom Laws Bill considered that firmly concludes by reducing the number of legally owned firearms, there will be a reduction or a subsequent reduction in an increase, in public safety? What evidence has been considered?
Well, I think that we have been consulting with our state and territory colleagues and other stakeholders, as Ms Spencer outlined. All of that information has gone into our provision of advice to the government.
So what data have you used that links reducing legally owned, stored and used firearms to increased public safety?
We'll take that on notice, Senator.
I'm looking forward to seeing that. In the bill, we've recategorised straight pull and button lever release firearms to category C and D. That's actually the strictest category, yet many jurisdictions still categorise those as A and B. Why has the government recategorised these firearms for import when they remain legal in many jurisdictions today?
Yes, Senator. So
yeah, thank you.
Correct. They, for import purposes, categorised as C and D. So therefore, under the import tests, there's a like an occupational test that goes with that. So in states and territories where police registries may certify you if you are, for example, a pest controller, an appropriate primary producer for those reasons. There's a few small sports shooter carve-outs as well. Then they're available through the import for new ones coming in of those firearms. I think some states have already, New South Wales has already moved in that direction. ACT's pointed to a willingness. WA, not fully exactly aligned, but covers some of those types of firearms as well. And then that broader question about the recategorisation of those firearms is under discussion for National Cabinet. So I think pending those discussions, that may be in all states and territories. Some states and territories may not obviously move in that direction, and that's something that we would consider and then provide advice to about that interaction.
So what happens to the concept of a national firearms agreement, over 25 years old now, when you don't have all states and territories agreeing to how it operates? Because if I look at the Police Minister's communique from Friday the 9th of Jan, it's quite clear that we're discussing proposal, we're progressing options, we're discussing options. There's no decisions being made here. When do you envisage decisions being made
So,
by
Senator,
these bodies?
we're still working through that process with states and territories. I think we spoke before about the timelines that the Prime Minister had given for returning to National Cabinet.
Mr Engel, given the complexities of what's allowed through the border and across state borders and the international border, how are you anticipating dealing with that issue?
So at this current time, we obviously apply the law how it is. So there will be those import tests around occupation. So that doesn't apply for, let's just say, stock that was imported before the commencement date of the changes, and it doesn't affect the domestic regimes in terms of, say, second-hand market or domestic manufacturer. The state laws will apply in that instance. Our role sort of ends at that import point and then who it can be released to. So at the moment, that is how we will apply it. Obviously, pending National Cabinet discussions, we would provide advice to government depending on where we land nationally.
Okay, thank you. I've just got very short last section of questions, Chair. When the government did its dirty deal with the Greens to establish the National Firearms Safety Council, I'm trying to understand what the membership of this council, because it sounds fabulous. Who doesn't want firearms safety? Who's on the National Firearms Safety Council?
Yeah, we're still preparing advice for government about how to construct that council. So the minister, I think, when we were debating the bill, made that commitment in the chamber that we would establish the council. We're still preparing advice for the minister on how to establish it.
So there is currently no formal members of this council?
Not at this point, Senator.
Is it going to be an independent entity or a unit within the department, or have secretarial support from the department?
We're still preparing advice, Senator, on the makeup.
When will it be up and running?
That will be a matter for government, Senator.
Have you prepared the advice? Is it sitting on the minister's desk, or is it still in the department?
We're still in the process of preparing the
Still in the
advice.
department. That's okay. That's fine. Is there a time frame to get it
Work as quickly as we can.
up?
I think
Is there a time? We always like to time frames.
We always like to provide
backwards.
advice as soon as we can to the minister's office.
Right.
I haven't got a time frame at this point in time, but we are actively working on it right now.
So in terms of membership, will firearm industry, recreational shooters be members of this council?
So, Senator, we'll have to put the options to government, and obviously the decision will be one for government. So I can't preempt that at this point.
Well, are we excluding certain people?
Senator, we are yet to finalise the advice, and so we're not in a position to give you definitive
ministers
answers.
don't always have to act on advice, so they could take their own initiative and make it an well-rounded,
Look how that turned
council. Minister. I will have lots of questions on notice.
Thank you. I'm sure the officials are grateful for you.
And I expect them to be answered, Minister Watt.
Well, as long as you don't clutter them up with questions about IKEA furniture and microwaves, you never know, we might be able to answer a few questions.
Pretty sure it's
Thank
on a
you.
time issue.
That means the committee is in a position to now release officials related to outcome 1, and we will call officials from outcome 2.
Thank you, Secretary.
We will take a very brief suspension while we do a bit of a changeover.
Paul, you're all right, yeah? You do all
Yeah.
2. We'll proceed directly to questions and begin with Senator Scarr.
Thank you very much, Chair. Secretary, I want to take you to the migration provisions that were introduced in the Combating Anti-Semitism, Hate and Extremism, Criminal and Migration Laws Bill 2026, which I strongly support and was pleased to see pass. Can you tell me, in relation to the amendments which strengthened the government's powers with respect to cancellation and refusal of visas, subsequent to the passage of that legislation, what actions has the department taken to operationalise those provisions? And in that regard, just to provide you context of the things I'm thinking about, there's the additional limbs, if I can put it that way, in terms of the character concern list, including endorsing statements which perhaps incite hatred, etc. And also there's the lawyer's point, very important point, about changing would to might, which changes the burden with respect to taking certain actions. So I'm very keen to know what steps the department's taken to operationalise the benefit of those strengthened powers.
Thanks, Senator. Claire Sharp, Head of Immigration. Senator, to date, what we have been focused on is getting our organising training for staff on how the new provisions work, and our own internal processes. We're also preparing correspondence to reach out to our state and territory law enforcement to make sure they're aware of the powers as well, because in practice, the way we become aware of people who might be engaged in the sort of conduct that might enliven the powers is often through the state and territory police, where they're also looking at people. So that's a key part of our preparation to put ourselves in the position to be able to efficiently use the new powers.
And that note is going from me to commissioners.
That's correct.
Imminently. So
okay.
I signed off on that content yesterday.
Have there been any additional resources mobilised to enable the department to have more people, if I can put it that bluntly, looking into the conduct of people who, especially on temporary visas, who might be doing things such as making one or more public statements or endorsing a statement publicly that involves the dissemination of ideas based on superiority over or hatred of other persons on the basis of race, colour or national ethnic origin? So do you actually have more people looking for people who are stepping over the line, who are here on temporary visas, as a tool to deal with people who perhaps don't share our values?
Senator, we're going to be using our existing team in the cancellation division. The purpose of the legislation is to make it easier, though, for that team. You know, we gave some evidence about this time to make it easier to exercise the powers. As we gave evidence about at the time, we already had some powers set at a higher evidentiary threshold. What we're hoping is that we can be faster to act, and while of course we must have good reasons and evidence, we don't need quite the same degree of it that we required before, all of which is to say, with the same team, we think we can work through cases more quickly.
Right, understood. Presumably there must have been people who have been brought to your attention in the past. I'm not going to ask you about specific individuals, but there presumably are people who maybe have been brought to your attention in the past and you were battling with the elevated evidential thresholds. Is the department going through a process of reconsidering matters to see whether or not they fall within the domain of the new provisions?
Senator Michael Thomas, Deputy Secretary. I'll move that over. Michael Thomas, Deputy Secretary, Immigration Compliance. Yes, Senator, we've been looking at previous cases as well where they may not have met the thresholds that we had to see if this new threshold may apply. So we're just looking generally at past cases where we're sort of aware that they didn't meet the threshold to see if the new powers might be applicable.
Okay. And in terms of people who are seeking visas, so there's the cancellation of visas for people who already have them, but then there's processes in place with respect to people who are seeking visas, and again the provisions have helpfully been strengthened. What how is that how are you operationalising the strengthening of those provisions? So clearly, just to give you an example, if someone applies for a visa and we have a process in place which identifies that they've liked, for example, ISIS-related material or neo-Nazi-related material, you now have the power for that red flag to be acted upon. So how are you operationalising those new powers?
Again, Senator, we're drawing on the existing architecture we already had for that. So already when a visa processing officer identifies some content of concern that goes to this kind of controversial views, to put it in a bucket, it's more
than controversial. We should make that clear for everyone listening.
It gets sent to what? The reason controversial is
a threat to our national interest.
That's right. Already those sorts of cases are elevated to our controversial visitors unit. Sorry, that's what the name was, where it will get considered by more experienced or sort of more specialist decision makers who will work through the case. We're going to be using the same architecture with the new powers as we already did, but again, the new grounds give us a wider variety of and more robust bases to make those decisions on.
Has any decision been made to expand the team, the number of ASL that are committed to actually undertaking these processes, given what's happened at Bondi?
So, Senator, we're always moving resources around depending on caseloads, etc. But as Ms Sharp said, because the threshold was high before, it took a lot more work to build the case. We are expecting with the different threshold that will mean that there'll be less effort involved in any individual case using the new provisions. And so we will monitor our staffing levels and our capacity to fully utilise this provision depending on how our experience goes with that team.
Okay, all right. I'll leave that subject there. We've limited time, so I'll quickly segue to the... There's no segue, actually. It's a hard shift. The Centre for Population released its population statement for 2025. Ms Sharp, have you noted the observations that were made in that statement in relation to immigration matters, and do you have any response to those?
Senator, I believe our team provided some of the data to Treasury, and I'm aware of that population statement.
Mr Willard's poised to come to the table. My first question was a fishing question to see if you were going to make any high-level observations. Mr Willard, do you have any high-level observations with respect to what was said in the population statement?
Senator, I think it would be easier if you were to ask Mr Willard specific questions.
Well, I am actually interested to know, I note that, Secretary, but I am actually interested to know if there was anything that stood out to Mr Willard from an immigration policy perspective.
Michael Willard, Deputy Secretary, Immigration Programs Group. Thank you, Senator. I don't have anything to add to Ms Sharp's response, but happy to take specific questions.
Okay, so it didn't I'll be brutally frank now. It didn't stand out to you that the Centre for Population within the Department of Treasury actually said that one of the difficulties they're having with respect to forecasting is uncertainty around departure rates for temporary visa holders. That didn't stand out to you?
I certainly noted that comment. I would note that when you do look at the latest NOM figures and you look at temporary departures in particular, there has been a growth in that rate of temporary departures. So I acknowledge the comment in the Centre for Population's document, but I would note the migrant departures overall increased by 13% and temporary departures are even higher.
I know the figures. I'm really looking at that uncertainty, which you acknowledge the Centre for Population actually states that it does present forecasting uncertainty, the issue with respect to departure rates of temporary visa holders, and they give at least two examples to support that observation, namely student visa appeal rates to the ART, and I'll move on to that shortly, but also onshore protection claims appeal rates. So you acknowledge that?
It was certainly the comments of the population the centre, yes.
Okay.
I guess, Senator, the reason we're not sort of highlighting it is because it is inherently true that departure rates are less within a government's control than arrival rates.
That's right, Ms Foster, but given the Centre for Population has produced, I think, 5 or 6 population statements, and this is the first time they've actually drawn out that point to such a degree, you would agree that it does warrant some further consideration, wouldn't you?
Yeah, absolutely, Senator, and as both Ms Sharp and Mr Willard have said, not only do we contribute to the report, but we look at it.
All right. Okay. Can I ask you, Mr Willard, what are the latest figures you've got on bridging visas on issue?
Certainly, Senator.
So just whilst you're looking for them, figures I've got, 30 June 2025, there were 369,627. Then last estimate you gave me, as at 31 October 2025, there were 402,000.
So, Senator, I have a figure for 31st of December 2025. The figures, all bridging visas, 412,578.
412,000?
578.
So it continues to increase?
It's actually, because we haven't had the intervening months, it's actually December is lower than November was. So it's coming down in that sense.
What's January looking like?
I haven't seen the January figures to date.
Do you have Secretary, have you got a target number or some sort of guide with respect to how many bridging visas we should have on issue? And I'm asking this question on the basis that 30 June 2019, there are 180,000 bridging visas on issue. Bridging visas are issued to provide a right to stay in the country while someone's immigration status is resolved. So it necessarily means the greater the number of bridging visa on issues, the greater the number of people in the country whose immigration visa status hasn't yet been resolved. So does the department have some goals or targets that we don't want to see the number of bridging visas above 450, or we need to get this down to 350? What's the plan across the whole of government to actually achieve that?
So, Senator, I think perhaps a better way of describing our efforts is what we are doing where we have particularly large cohorts of bridging visa holders to reduce that number. Ms Sharp can take you through that, because the way we use that the numbers and the way we use it will differ according to the part of the cycle or the circumstances we're in. And I think Mr Willard will phrase this much more eloquently than I, but we are in a process of normalising post the COVID bulge.
Yeah.
And so we just need to work hard on the areas where we can influence it and get back to that level.
I'm certainly aware of the post-COVID bulge. Others may choose to ignore it, but I'm certainly aware of it. But that's at this stage, Ms Sharp, I don't need you to do that, just because I've got very limited time. Number of temporary visas on issue, Mr Willard. So 31 October 2025, there were 2,925,000. What's your latest figure, presumably 31 December?
I have 30th of November for the number of temporary visa holders in Australia. It's 2.857 million, so 2,857,000.
Okay, thank you. In terms of, I want to move to onshore protection visas. So the last update that was tabled in the Senate was for November 2025. Do you have any more up-to-date figures? And I'm very keen, once you give me the headline figure, for you to break down where the numbers are different cohorts depending on where they are in the system. So as we did last time, if you've got those figures you can walk through.
I do have an update, but it is actually dated November 2025.
Oh, you don't have any?
Let me just... Yeah, so the update I have is for it to be able to break down that way is for November 2025.
Do you have the headline figure?
I have a headline figure, which is 77,114. That's for 31st of December 2025. And when I looked to November, that was 77,933, so a slight reduction.
So what's that number? So the number of... So
that's, I beg your pardon, that's bridging visa A, B and C visa holders in Australia.
Oh, okay.
But that's the only breakdown I have for December for that period. Mr Kiley might be able to assist you with a further figure.
Andrew Kiley, First Assistant Secretary, Migration, Citizenship and Humanitarian Policy Division. I've got breakdowns at 30 November, sort of across the caseload, if that would assist.
Yeah, so the aggregate figure that I'm looking for a breakdown of, as at 30 November 2025, was 102,660. So if you can break that down into where people are up to in the system, that would be helpful.
Yeah, so I've got an on-hand at primary stage, this is at 30 November, of 27,611.
So primary stage, what's that mean?
Still with the department, undergoing primary assessment.
Can we just, Senator, I'm just not sure we're answering your question. Are you interested in the number of protection visa applications on hand or the number of failed protection visa?
In the first instance, I was after the failed protection visas, which is why I was quoting the November figure. But Mr. Kiley, that figure you just gave, though, is the number on hand.
Yeah, sorry.
Is it?
So that's in addition to the 100,000.
Yeah, 27,611.
Yeah, and then there are 63,341 individuals who are at either merits or judicial review.
Sorry,
63,341.
And that's either ART or judicial review.
And they are, of course, part of the 102 failed.
Yeah, I understand.
And then the remainder of that 102,000 are those who have no ongoing matters.
Okay, so how many of those are unlawful non-citizens? 29,000, and then the balance, presumably, Mr. Thomas, are on bridging visas?
They are. So they're a combination of people awaiting ministerial intervention, or they're on a departure pathway, or awaiting another substantive visa.
Yeah. And how many of them are there?
I think the balance is about 10,000.
It's just the balance. Okay. Can I ask you, Mr. Thomas, and this has been bugging me, if you can cure my irritation, that would be your great benefit. And it is a question of... People refer to this figure, it's in fact been referred in this place before. When you table these reports, you table the total number of individuals that were not granted a final protection visa that were deported during the period, and the deportation rate, 13, in this report. Now, I know from previous evidence you've given that doesn't mean there's only 13 of these people have left during the course of a year. Why do you put 13 in that report? Why don't you actually put the total number of people who've actually gone through the process of non-voluntary deportation, if I can put it that way? They've gone into a detention centre and then left, or people who've left of their own volition, in order to give a better understanding to the Australian public as to what the department's doing.
I'll have to pass that question to my colleague, Senator, that they do the report over that side. Apologies.
Yeah. Senator,
okay.
My understanding is that the basis of that report draws on a Senate order that was made a number of years ago that set out certain types of categories that we had to report.
So maybe we need to amend the Senate order, because it doesn't make much sense. I think it actually misleads people.
And it undersells the work that we are doing to remove
It does,
people.
Secretary. It does. It does. Let me just see if I've got... one of the issues, this is the last question for this block. One of the questions raised by the Registrar of the Federal and Family Circuit Court last night, Dr. Pringle, or Mr. Pringle, Registrar Pringle, was when cases go to judicial review, so they're going before the courts, 80%, he estimated, of migration cases have a self-acting appellant, 80%. And in fact, 80% of them need a translator. He also spoke about the fact that there's been an exponential growth in the number of cases onshore protection cases which are ending up in judicial review. He went through the figures. They've gone up from, say, 2,500 to 4,000 to he's expecting 10 to 11,000 during the course of this financial review. What steps is the department taking practically to try and address this issue of self-acting appellants in the court system, which obviously slows down proceedings and clogs up the system? Does the department have any strategy in relation to dealing with that issue?
Mr. Cole, do you want to give an overview of the funding we provide to legal providers?
Yeah, so there have been two measures that have provided funding to legal providers to support individuals going through the protection visa process. So 2 years ago there was a measure where, if you just let me find the exact, there was approximately $50 million was provided to legal providers to support individuals going through primary and review stages, and again designed to ensure that people have that legal advice available to them.
But Mr. Keeley, there's and look, I'll finish it here, but and maybe take it on notice. As at last night, we're receiving evidence 80% of those 10 to 11,000 cases are a self-acting appellant.
So
80%.
Senator, we share his pain and your pain. It's an issue that we are actively looking at and at a range of measures to reduce the impact on the appeal process, on the courts, and on the efficiency of the process itself.
Okay, all right.
Thank you, Senator Scarr. Senator Shoebridge.
Thanks, Chair. Secretary, what visa is President Herzog on?
Senator, we don't comment on individual circumstances, individual cases. Obviously, President Herzog's visit is a very public one, but the kind of visa, I think, is a personal detail that we wouldn't provide.
This is a head of state who's been invited here by the Prime Minister. You're not seriously hiding behind privacy rationale to avoid telling the Australian public what visa Israeli President Herzog is on, are you?
So, Senator, there's a really important principle about not providing details on individuals that we have obviously processed through our visa system. I absolutely accept and I acknowledge that this is a very public visit, but that doesn't mean that the details surrounding it are ones that we should share.
Well, can you confirm that he's on a visa?
Senator, let me take your questions around his visa on notice so that I can ensure that there are no sensitivities.
No, taking the question... Now, you can't, as a government, have it both ways. Complain about the number of questions on notice and then take on notice a question like that. Is President Herzog on a visa?
Senator, I took the question on notice.
Let her finish her sentence.
Chair, I'm going to ask you...
Let her finish her sentence.
Chair, if I may, just take a point of order against the witness in this regard. In your opening address, you pointed out that witnesses need to answer questions that are within the capacity of the witnesses. It's in the government's own guidelines to witnesses. Your minister continues to object about the number of questions on notice, and I asked the Secretary whether or not President Herzog has a visa, and I saw staff nodding just to the right of her. And then we get this refrain that we get all the time from this Secretary, that she'll take it on notice, and how dare you question whether or not she takes it on notice. I'd ask you to direct the witness, if it's within their capacity, to answer the questions today, if for no other reason than to stop your minister continuing to complain about the number of questions that they take on notice.
How about you let Ms Foster finish her sentence?
So I think talking about the Secretary in a way that suggests that she's trying to be unhelpful to this committee, I think is unfair. I think the Secretary has taken your question on notice to see what she can provide to the committee. I think she's said already that there are some sensitivities around, but let's see what she can provide. Is that... feel free to finish answering, Secretary, if I've mischaracterised what you were saying. And it is absolutely within the officials' right to take questions on notice where... If they
cannot answer it here.
Yeah, or they feel like there is a public interest immunity claim that they need to make.
Correct.
So I think the Secretary is trying to assist here.
So, Senator, I'm trying to make a distinction between my concern about providing details on any individual, but I can say that every person who enters Australia comes in on a visa.
And I assume that we would have the same discussion about former Israeli Major General Doron Olmog, who has come out with President Herzog as part of the delegation. I'll ask you what visa he's on. You'll decline to answer it. But he, like everybody coming to this country, is on a visa. Would that be fair to say?
I will simply make a statement that everyone who comes into the country comes in on a visa, who is not an Australian
Secretary, has the department undertaken any due diligence about the multiple concerns about the previous conduct of former Major General Olmog, including those that went before a UK court that ended up with a warrant being issued against him for breaches of the Geneva Convention? Have you undertaken that due diligence in respect of former Major General Olmog?
Senator, we don't discuss details of individual cases.
Well, you see, Secretary, Olmog is accused of a series of war crimes. These matters were put before a UK magistrate court, and they result from his time as General Officer commanding the Israel Military Southern Command between December 2000 and July 2003. And they include the murder of 3 teenage boys killed as a result of injuries inflicted by flechette shells fired by an Israeli tank, and flechettes are pointed, fin-stabilised steel projectiles. In January 2002, Israeli bulldozers, under the command of then Major General Olmog, flattened 59 houses in the Rafah refugee camp in Gaza. Residents fled and couldn't take their possessions. Under his command, there was the mass murder committed on the 22nd of July 2002 when a 1-ton bomb was dropped on Gaza City to target one individual, but killed 14 civilians, including 8 children, and injured more than 150. And also under his command, the killing of Noha Shukri al-Makdam, who was 9 months into her pregnancy at the time of her death on the 3rd of March 2003. He's been accused of these crimes, and a warrant has issued against him from a UK magistrates court in relation to them. How on earth did he not fail the character test?
Senator, I have nothing to add to my previous evidence. We don't discuss details of individual cases.
Minister, your government celebrated the fact that they had new powers to cancel visas on character tests. There are already existing extensive powers to cancel visas if a person has been involved in conduct which amount to war crimes, crime against humanity, or where the attendance of a person in Australia might incite discord. How on earth has your minister permitted the grant of a visa to former Major General Olmog, and why on earth doesn't he cancel it?
Well, again, as Ms Foster has said, we don't discuss the details of individual cases.
Well, you see, hiding behind privacy provisions when the notorious behaviour of Major General Olmog, who's here only because a Labor minister refuses to cancel the visa, doesn't answer the concerns in the community. Minister, again, why doesn't your government cancel his visa? And why did you ever grant him a visa in the first place? Or is it one rule for one group of visitors and a different rule if somebody's a former member of the IDF?
I've answered your question.
Mm-hmm. Well, you see, Minister, the Migration Act also permits, indeed grants a broad power to the minister to cancel the visa of somebody if they're in the event that if the person were allowed to enter or remain in Australia, there is a risk that the person might incite discord in the Australian community. Sydney erupted into violence because your Prime Minister invited President Herzog to this city. It was predictable and certain.
That's an outrageous
Why won't you cancel President Herzog's visit?
I've answered your question.
His presence is also a threat to the good order of the Australian community, as evidenced by the appalling behaviour of your fellow Labor government and Premier Chris Minns in New South Wales, unleashing appalling violence on the community in Sydney. Clearly a threat to the good order of this country. Why won't you cancel President Herzog's visa? Because it is evident that his continued presence is a threat to the good order in Australia. Why won't you do it?
I've answered your question.
Senator Shoebridge, indicating I'm going to share the call.
I'm going on to something different.
Thank you. Can I talk about study visas? And Ms Sharp, were you watching the evidence from the ART last night, or was it brought to your attention?
I was indeed, Senator, as was Mr Willard and Mr Kiley, for that matter.
Oh, excellent. Wonderful. Did you find it entertaining? You don't have to answer that.
No. I found it interesting, of course.
The evidence was to the effect that as at 31 January 2025, there are 50,686 appeals against study visa decisions, refusals or cancellations made by the department. So I'll just repeat that figure, 50,686. And that is out of a total of 129,444 cases. So just the component of study visas represents now 39.15% of the workload of the ART. 2.5 years ago, it represented 3%, and there was only approximately 2,500. So there's been an absolute explosion in the number of these cases at the ART. Ms Bogart from the Attorney General's Department said that she had been engaged in discussions, the department had been engaged in discussions with the Department of Home Affairs in relation to the matter, and said that the department, or gave me, well, I'll put it to you, did you have discussions with the Attorney General's Department in relation to this issue of appeals against decisions in relation to study visas? The fact that the success rate, if I can put it that way, or the rate at which they're remitting back to the Department of Home Affairs is about 44%, and how that can be addressed or is being addressed.
Yes, Senator. We engage regularly with AGD, and the most recent discussion was between Ms Bogart and Mr Willard just very recently about that issue. Would you like to?
Senator, I spoke to Ms Bogart last week. Probably more significantly, there's also regular engagement on a more operational level between officers who manage the student visa program and the ART officers.
I think just going to the
So what's happened?
Yeah.
What have you done?
So, Senator, I think as you're well aware, the passage of the legislation last week will be of significant help, we think, to the ART in helping to make its way through that caseload. Separately, and to get to the point, obviously, of passage of legislation, we had been working closely with Attorney Generals for months to work out what could we do to address this growing backlog, which is essentially kind of Ms Foster referred to before about the impact of COVID. You know, we had a really significant number of students
It's not just COVID though, is it, Ms Sharp? I don't want to cut you off, but there seems to have been this phenomenon of failed student visa applicants discovering that there was a means by which they could appeal to the ART and potentially lengthen their stay in Australia. So,
well, certainly what I would say is immediately after the borders reopened globally, all Western countries experienced a large volume of international students seeking to come.
Sure.
Australia responded to that, like Canada and other countries, by really focusing in on ensuring students who were coming were genuine students.
Yep.
That saw in Australia us do things like lift the language requirement. Yep. It saw us be tougher on the evidentiary requirements, crack down on dodgy providers.
All sensible reforms.
But all with the result that more people were refused a visa.
Okay, and you're saying therefore they're appealing. There's a greater pool of people who've been denied, therefore there's a greater number of appeals.
And I guess I would add to that as that phenomena occurred, we started seeing that rate of appeal and then saying, well, we're going to need to look at what is happening at merits review.
Yeah.
As Ms Boggart, we really have been looking closely at that. One of the common reasons was at the time people were submitting their application to us and they could make a valid application at the time. They did not have a certificate of enrolment. Okay. That was a grounds for us to refuse the visa. Then they've got a visa refusal they can take to the ART. And when they go to merits review, they say, oh, I've now enrolled. Here's my certificate of enrolment. Yep. And off it comes back to us to start again.
Because merits review, they have to consider the matter de novo.
Yep.
So, okay.
One of the other very common things is that their English language improves in the year or two between the initial case. But I think what Ms Sharp is going on to is what we're trying to do to address this.
So a really important change we've made at the front end is to make it such that you cannot submit a valid application unless you're uploading a certificate of enrolment. Okay. So that really is quite significant in reducing the number of...
And something as simple as that, I'm not going. Hindsight's a wonderful thing, isn't it? But I guess that is effective in terms of stopping someone from making an appeal. Well, they can argue that the application...
Well, there never was an application.
There never was an application because the application was invalid?
Correct. It wasn't submitted, so we didn't have to refuse it, if you like.
So the Secretary referred to English language requirements. Can you apply a similar approach with respect to English language requirements? If someone can't upload a certificate that has English language at a certain level, that they can't make a valid application?
The current setting is that at the time of application they have an English language result which allows them to meet the threshold. The issue with that, of course, is we then have to refuse the application if they're not at that threshold.
So why can't you just make it invalid for them to lodge an application if they don't have a certificate that has an English language threshold of X?
It could be a consideration in terms of Schedule 1, so requirements that set out what's required at time of application. Typically we have to look at whether or not that's a requirement that can be entirely objective in terms of its application.
Okay, so you're saying maybe it's not entirely objective. Can you take that on notice? Because I'm also interested in terms of the other one which was raised last time we were here was in relation to financial capacity and whether or not if someone can lodge, it seems to me a very efficient way of dealing with the matter. If you simply don't meet the requirements, you can't lodge an application.
Broadly,
for the objective ones, right?
We seek to move what we can into Schedule 1 in terms of objectivity, for the point that you made, Senator. Things like financial requirements do sometimes require further assessment, which would make it difficult to be a Schedule 1 criteria.
So maybe they shouldn't. Can I move to another topic quickly? I'm going very quickly here to try and assist to catch up time. For the planning of the 2024-25 permanent migration program, there was a very useful, well-written discussion paper. Did you draft it, Mr. Willard? A very good discussion paper that was released with respect to the permanent migration program for 2024-25 that was seeking submissions.
It was a departmental product, Senator.
Oh, that's a humble response. It actually said, and I quote from it, to support the planning of the migration program, the department is conducting a consultation process to enable all Australians to have a say. We are committed to engaging with you to ensure that planning of the 2024-25 migration program considers real-world impacts. As part of our long-standing annual consultation process, we are pleased to invite public submissions to inform the planning of Australia's migration program for 2024-25. I asked a question, previous estimates as to seeking copies of submissions for the 25-26 program, and the answer to the question on notice advised me that no formal submissions were sought. Why was it a good thing to give all Australians a say with respect to the permanent migration program for the 24-25 year, but someone decided that we shouldn't give all Australians a say with respect to the 25-26 migration program?
Senator, I'd make the point that ultimately planning of the migration program is something that government considers. When we give advice in terms of the migration program, we do draw on our extensive stakeholder consultation with a very wide range of groups. Through our outreach officers, we do thousands of consultations.
Mr. Willard, sorry, I've got limited time. I don't want to be rude, but there was obviously a policy decision made that, well, I didn't do that for effect. There was obviously a policy decision that was made that you would not publish a discussion paper for the 25-26 permanent migration program, and you would not enable all Australians to have a say with respect to the 25-26 program. Who made that decision, and what is the basis for that decision?
In terms of the basis for the decision, Senator, a huge range of consultation occurring contemporaneously with the planning process. I'd have to take on notice who made the decision.
Was it a decision that was made by the Minister and communicated to the department?
I'd have to take on notice to give you a correct answer.
What's the approach you're going to take for next year's permanent migration program? Are you going to take the approach you took in 24-25 of enabling all Australians to have a say with respect to a matter of great interest, as we're seeing in the current debate, to all Australians with respect to, in particular, the rate of migration, or are you not going to call for formal submissions?
Senator, ultimately that will be a question for government, but we're noting your interest, and we will find out the...
So, Minister, can I ask you, I know it's not your portfolio, Minister, has any decision been made as to whether or not the department or the government will revert to the process that was taken in 24-25 of providing all Australians with an opportunity to make a submission with respect to the permanent migration program for the 26-27 year?
I'm not aware of any decision being made.
Okay, but can you take that on notice as well? Thank you. I also, I note in the answer to the question on notice you took last time, you said no formal submissions had been made. Had any submissions been made? And if so, you can take it on notice. Can you provide me with copies of the submissions that were made?
Senator, I'll take it on notice. In doing so, we need to consider the circumstance in which the submission was made.
Okay. I want to move quickly on to another topic. The proposed increase in registration fees for registered migration agents. This has had some has had some currency in terms of current debate. Who can answer that? Ms. Thomas, is that you? You hitting registered migration agents with additional fees? So, Mr. Thomas, the argument is that there's a number of arguments that have been raised, in particular by the Migration Institute of Australia. One is that when you compare registration fees against other professions, registered migration, the new registered migration agent fees, registration fees, are higher than that which applies to other professions. The other point is that we actually want more people with migration matters of concern to go and see a qualified registered migration agent to get proper advice, and hopefully that assists in terms of dealing with backlogs. How do you respond to those two matters which have been raised by, amongst others, the Migration Institute of Australia?
I guess in a general sense, Senator, we have been engaging with stakeholders on this as we've been working through the proposal and what it could look like. So this is in relation to updating the instrument around the costs. I think what you've said are considerations that have been raised directly with us and taken into account as we sort of look through what those costs could and should look like.
Has a final decision been made?
Not yet, Senator. The work's still underway with a decision yet to be finalised.
Okay. All right. Another issue which they raise is this phenomenon of fake migration agents. So this is people who hold themselves out to be migration agents. There's lots of people in vulnerable positions. They can charge great amounts of money. What's the department doing to crack down on people holding themselves out as migration agents when they're not?
So we are doing some work in our field compliance space to look at sort of unregistered and unauthorised providers of immigration assistance to try and identify instances where we think people are being exploited through that mechanism and looking at using our powers to either use our civil penalties or taking them through to a prosecution pathway.
Could you just take on notice that area and provide as much information as you can in terms of your success in cracking down on people? I deal with lots of vulnerable people and they tell me about paying thousands of dollars to people, and I see the results of their investment, and it's just terribly confronting. Last question. I've just got, oh, sorry.
I was just going to say, if you do see that, please do refer those particular instances to us.
Yeah, I will.
A really quick point. We're also promoting the use of registered migration agents and encourage people to use them and how to use them. And we have a campaign that goes overseas.
Excellent. I agree. You can use my endorsement in that campaign if you want. Lastly, in the migration strategy that was released, and I raised this before, Mr Willard, so I am empathetic, but I'm going to ask the question anyway. We discussed the target for the processing time for skills in demand visas and specialist skills pathway visas, and the target in the migration strategy was a median issue standard time of 21 days for new skills in demand visas, 7 days for specialist skills pathway visas. I'm wondering if you can give us an update as to where we're up to in terms of those figures.
Senator, I can. We are not at those timeframes. We're continuing to work in respect to processing of those caseloads. We have made progress in terms of the number we're finalising versus the number that are being lodged. So we are catching up in terms of processing, but processing times are not at those levels.
So what are they?
I'm just going to find them for you. They are, we do publish them on our website.
I was having trouble using the website. It just went into a sort of a suspended animation for some reason. Might be me.
That wasn't deliberate, Senator.
Wasn't it? No.
I have some figures if it's...
Do you have...
We can't target it towards particular...
10 days for specialist skills.
Oh, okay. So 10 days versus 7.
And unfortunately, core skills is at 4 months.
4 months? As compared to 21 days?
As you know, when we report on processing times, it's the cases finalised in that particular month. We have been making progress when you look at the number of cases coming in. So that suggests we're working through a bubble in terms of the backlog, and if we continue that progress, those numbers will improve.
Okay. I've still got some questions on outcome 2, but I know you want to go to the anti-Semitism envoy.
Yes. So we are at after the afternoon tea break, but for people's time management for the rest of the evening, we are going to pause outcome 2 because, as you've heard from Senator Scarr, he's indicated he's got further questions, and so does Senator Shoebridge. We are going to return from the afternoon tea break with this Australia Special Envoy to combat anti-Semitism. She's currently on the program for an hour to take us to the dinner break, so it's likely we will get back to outcome 2 post-dinner, and then the rest of the program after that. So we will break now for afternoon tea and return at 5:05. Okay, we'll commence from our afternoon tea break with the Special Envoy to Combat Anti-Semitism, Ms Julian Siegel. Welcome to the committee. Thank you for your attendance here this evening.
Thank you.
Would you like to make an opening statement?
Yes, I would. And I have sent it in, so I hope it's been circulated.
Sure, we can get that done.
All right. Would you like a copy to just hand up to you to have a look at, or?
I think it's being printed now.
Excellent.
But thank you very much.
Thank you, Chair. Well, given events since I last appeared before the committee, which was just a few months ago, but a lot has happened, so it's probably useful to make a few remarks. My central message is this. Anti-Semitism in Australia has reached a point where sustained, coordinated national action is no longer optional. It's essential for community safety, for social cohesion, and for the integrity of our democracy. The events at Bondi marked, I think, a profound turning point for the nation. They brought growing anti-Semitism into sharp national focus and made visible what Jewish Australians had been saying for many months, that fear, intimidation and exclusion are no longer abstract concerns, they are lived realities. And as I noted at the time of the Bondi massacre, a pattern of activity of hateful words, demonstrations supporting terrorist organisations like Hamas, violence directed at Jewish institutions, property and businesses, and unchecked hate online eventually led to an environment that the community had feared, a targeted massacre of Jewish Australians, which also, it should be noted, killed and injured many non-Jews caught in the attack. And that moment crystallised public attention and for many Australians resulted in a realisation that what the Jewish community had been warning about was real. Australians from across the country reached out in solidarity. Community organisations mobilised. Faith leaders did speak up. Individuals offered support and practical assistance. And I want to acknowledge that outpouring and thank everyone who engaged constructively with my office. Many Australians actually expressed to me feelings of guilt that they had not taken my warnings seriously enough. So since Bondi, activity across government and civil society to work on my plan has accelerated, and listening to the lived experience remains foundational. Jewish Australians have spoken clearly about the impact of recent months on their sense of safety, belonging and visibility. Parents remain concerned about schools, students about campuses, families about places of worship, business owners about vandalism and threats. And these are not isolated incidents. Together, they create a climate of fear. So anti-Semitism presents in multiple forms: online, intimidation, vandalism, threats, physical violence. And this is why my work must be sustained, and my plan remains, I believe, a relevant and important blueprint for action, with focuses on education, law and regulation, culture, institutional accountability, online environments and community safety. And community members, faith leaders, educators and civil society organisations have stepped forward. So I make the point in my statement that universities, we are advancing our work in relation to education, work is advancing there. And I continue to advocate for nationally consistent protections against serious hate conduct. And online, we are engaging with platforms alongside international counterparts to address the scale and speed of digital hate. And the public response since Bondi, to me, has sent a very clear signal. Australians do not accept hatred or intimidation as normal. People expect action, coordination and leadership. And the Royal Commission provides Australia with a unique opportunity to examine root causes, institutional failures and systemic responses. This will be an important year working in the fight against anti-Semitism, and I will certainly be engaging with the Royal Commission to assist as much as I can. Thank you.
Thank you, Ms Siegel, for that opening statement. The committee will table that opening statement and will proceed to questions. Senator Blythe.
Thank you, Chair, and thank you, Ms Siegel. You have had a traumatic few months, and I think your leadership in the wake of the Bondi attacks has certainly been reassuring for a lot of Australians. I will start with a press conference that you did on the 8th of January where Prime Minister Albanese finally announced he would be establishing a Royal Commission and you said you wanted the warning signs missed ahead of the Bondi terror attack to be examined. Can you be more specific about what you meant by those warning signs?
Well, thank you. Thank you for the question. Some of that is sort of really dealt with in my opening statement. I have said, and I believe this to have been the case, that hateful speech leads to hateful action. And we've seen over the last year and a half a great deal of hateful speech, demonstrations, as I've said, behind Hamas flags, violent words thrown out at the Jewish community, graffiti, firebombing, threats online. So all of that has taken place in our society as we've carried on our work, but the Jewish community has felt intimidated and threatened. And that has all led to an environment of violence that led, I believe, to what we saw at Bondi. But these are issues to be examined, quite frankly, by the Royal Commission, because Bondi is one of the areas in the terms of reference, in the letters patent. So they will look at this, I'm sure. I'm just giving you my perspective from the community's lived experience, that everything led up to an environment where this was seen as something people warned about it. I warned that there would be violence, and unfortunately it took what happened at Bondi to make everyone realise how serious it was.
And I guess just going on from that, that there were warning signs, do you think that government departments, intelligence, law enforcement agencies maybe missed things or made mistakes?
Well, I think, as I said, I think this will be examined in detail by the Royal Commission, and I do not want to prejudge what they might find. But I think when you live in a country like Australia, where we have had a golden age, I think, of multiculturalism, with welcoming people to the nation and believing our own environment of a really positive democracy, it's sometimes hard to believe that things are as bad as they are. And that's, as I said in my statement, so many people have expressed feelings of guilt to me. Non-Jewish people have said, I feel so sorry because I heard what you said but didn't appreciate how bad it was for the community, and how the firebombings, how the graffiti, how they increased the need for security for kids going to school, how they felt intimidated wearing a school uniform, working to school, how students on campuses felt intimidated in wearing any insignia of their Judaism. We didn't realise what all this was leading to. So it was an environment that escalated. But I think it's hard, if you are outside, always to understand what's happening. But the words of the Jewish community needed to have been listened to. And I think that's where we now are, that people believe that it was bad and that it still is bad, and we need to work together. And it needs, as I've said repeatedly, and my plan says, there's no one answer. It's a whole of society. We have to say this is unacceptable. We have to all speak up. Every voice that speaks up against anti-Semitism is an important voice.
I couldn't agree more with you on that. You've mentioned that there is a big year ahead, particularly with the Royal Commission. Has resourcing in your office been increased to assist you with making sure that the voices of the Jewish community is heard as we fight against, this scourge of anti-Semitism?
Thank you. Yes. Well, I'm in the process of recruiting some additional team members with the support of the department and the government. So it hasn't yet happened, but I've been given the ability to resource up and to retain, obviously, lawyers.
Fantastic. That is very positive to hear. In terms of the single biggest thing in relation to tackling anti-Semitism that the Albanese government should have done prior to December 14 that it didn't, what would you say that is?
Well, I think, I have to say that in establishing my office and bringing personnel such as an envoy on board. What the government did do was it set up a structure to look at the problem, okay, which is an important step. And then the government signed the global guidelines, which are very important in terms of the guide to fighting anti-Semitism around the world. That resulted in my plan, which I delivered a year after with a lot of consultation. And it wasn't as if I spent that first year only consulting, but we started work so that the plan was grounded in reality. The government, after I delivered the plan, did start working on the plan with me. It wasn't as if it stood back. There was a lot of support from different departments as we worked to the key issues in the plan, which I believe are education. If you look at universities and education. And we did have a parliamentary joint committee, a Senate inquiry first and then a parliamentary joint committee into universities. So there was quite a lot of action. What we're seeing post-Bondi, obviously, is an acceleration of that. Understandably, the issue has been highlighted, the need is so much more urgent. So the only thing I could have hoped for was the acceleration earlier. But work had started. I had a lot of assistance and help in putting in place the initiatives at university, the report card, for example, and looking at school, a trial in relation to school education. So it's the pace of it that I would have liked to have been faster.
Do you think if it could have been faster that we could have avoided the tragic events in Bondi?
I really have no idea whether that would have prevented it, because I think so much had already become embedded. But that, I hope, will be something for the Royal Commission.
And I guess in the 5 months between when you delivered your plan in July last year and to mid-December last year, did you provide any advice to ministers or departments warning that implementation was too slow and that things were escalating at a rapid pace?
I certainly have multiple conversations just seeking further meetings and seeking further work. I don't believe I provided any specific advice saying, you know, things are, unless something is done, things are escalating. I think that in each of the areas there was contact. Law reform, pushing for additional coordination in relation to law reform, understanding what was happening at the states, because that's the complexity with federal and state legislation, understanding what was happening in new areas of anti-Semitism, because it's not a static thing. New areas were emerging, and we were working with new departments in relation to what was happening in the arts area, in the cultural area, in the health space, etc. So it was a continuously moving space, and I think that everyone realised that I was constantly in touch, seeking assistance, seeking reaction, seeking support. But I wouldn't be the first person to say that the wheels of government move slowly.
Yeah. And I guess in terms of, I mean, you obviously delivered your plan 5 months before Bondi's tragic events.
Yep.
Is there anything you would change in that plan? Because I know that you've spoken about in your plan that strategic gaps remained, and they obviously still exist. So are there things, even since proposing your plan, which has now been adopted and will be implemented, is there anything left that you think?
Oh yes, I mean there's a lot. There's a lot. You know, I wouldn't want to say that that's the definitive end piece. Okay, it was a view.
Well, things have escalated substantially since then.
There's much more that needs to be done, and you know, I'm pleased that the response has escalated as well. But my office is continuing to work on additional things that need to be done in additional areas. You know, there's work that not the Jewish community, but the general community is doing in response. I'm pleased to say. So, you know, if I give you an example, the universities are working very much to respond to the independent work that's going on that I've commissioned with Professor Craven on the report card, to come in and identify where they are making progress in the matters that were suggested by the Parliamentary Joint Committee, which is really my report card, with an independent person such as Professor Craven looking at it. But the universities are also working independently to see what more they can do. So it's not seen as the end of the process, but merely now an important step in the process. And I will be talking to a group of them today. What more should we be doing as a group of universities? So it's an ongoing dialogue, and there will definitely be more engagement with different parts of government coming from my office, and more initiatives coming from my office.
Thank you, Senator Blyth. Senator Shoebridge.
Thanks, Chair. Thanks, Ms. Gull, for your attendance today. I think the Attorney General's Department indicated that you were consulted on the 29th of December last year about proposals to bring in urgent law reform that eventuated earlier this year. Do you remember being part of consultation on the 29th of December?
My office was part of it.
Okay.
I might put it that way. I wasn't
were you personally part of the consultation?
No.
Do you know, who from your office went?
I have legal people in my office who were part of it.
So what was their position and what was their role?
Well, their role was, their position is a senior legal officer, something of that sort, and their role was to respond. I certainly saw the final submissions, but I wasn't personally consulted. I was part of the process at the end of the day, but they had the carriage of the work. I'm afraid I can't be in all the places at the same time, so I do have a team, as you know.
No, I wasn't suggesting you should be. So was it one or two members of your staff that went to the consultation on the 29th of December, or was it more?
I believe there were two people in that consultation.
And they were legally trained, were they? And they were going there as legal officers?
Yes.
I have previously asked questions about your staffing, what staff are in your office, and they haven't been answered yet.
Oh, I'm sorry. I certainly have answered them. I'm not sure where they are in the process, but I have 5 full-time equivalents in my team at present, which makes I've got a couple of part-time people. Makes 6 employed.
Yeah, but 5 full-time equivalent. Some of that job shared.
Employees, yes.
Yes, and you said earlier that you had an increased budget.
Yes.
What will that do to your staffing?
Well, initially, I'm hoping that it will enable me, I'm taking it one step at a time, because conscious of not wanting to waste resources but being properly resourced, I will respond to the Royal Commission as things develop. So I'm seeking to retain 1 senior legal person, and then possibly through my legal services, legal team, have a secondee for a junior secondee.
Okay, so a senior lawyer and another junior lawyer in addition to the team you currently have.
Yep. But I'm not there yet, so if you know anyone who's particularly qualified and would like to work for a sector,
I'll keep that in mind.
Keep that in mind. Thank you.
When you were when your team was consulted on the 29th of December,
yes.
At that stage, had the government indicated that they were intending only to protect race, ethnicity and nationality in their package of laws? Was that how the government came to the consultation?
I believe so, but if I could take that on notice to check. It's not crystal clear in my mind that it was, but I believe it was in the original proposal, but if I could take that to check.
All right. Well, I mean, it was a matter of significant controversy in the legislation.
Absolutely.
It's a matter of significant controversy in a part of the legislation that was also not progressed, the vilification laws.
Understand.
Did your office endorse the position of limiting protections only to race, ethnicity and nationality?
I don't believe so, but can I take that on notice? I know that there were, the discussions were extremely intense that one day and were rushed, and that not everything was, we put in quite a few views that were different, that some things were not as, I do think that some of the exceptions, and I still maintain that some of the exceptions that were in the draft were not desirable, and we were looking for a body of legislation that was more definitive.
Was that, when you talk about exceptions, are you talking about in the vilification laws?
Yes.
You supported the vilification laws?
Yes.
And you supported their limitation to race, ethnicity and nationality?
Well, that's what I'm not sure, Senator. I said I would take that on notice.
Moving on from the 29 December consultation.
Yes.
When were you first shown a draft of the legislation?
I didn't see a draft of the legislation before that consultation, I don't believe.
Well, the Attorney-General said that there wasn't a draft of the legislation on the 29th of December.
Well,
they said a draft of the legislation was produced sometime in January.
Well, then whatever I saw on the 29th of December was, whatever it was, draft consultation. When I saw the legislation, I don't know. I would have to take it on notice.
But you said you weren't there on the 29th of December.
Well, I was not in that consultation.
So when you were talking to me about what you saw on the 29th of December...
Well, I was responding to the office. Apologies. I wasn't sure you were talking about me, or I thought you were talking about the office. So my office was there.
Were documents given on the 29th of December that you then saw?
No, nothing was actually given, to the best of my knowledge. I was just told about what was in the legislation.
I'm relying on what the Attorney-General's Department said. They may be mistaken.
I'm sure they have a much clearer view, because I actually wasn't there. It was just what my two lawyers participated in. They were called into a discussion with the Attorney-Generals.
Let me go back to the question I was just asking you, which is, when did you first see either a draft of the legislation or the legislation as tabled with PJSIS? When did you first see the legislation?
I would have to take that on notice, Senator.
Were you consulted on a draft before it was made public?
Me personally, or my office?
Well, why don't we start with your office? Was your office consulted on the draft before it was made public?
I would just have to refresh my memory and take that on notice. I'm afraid what was happening in January was quite a blur to me, and I had a number of days leave because I had a death in the family. So I'm just not sure exactly what date, if I could take that on notice.
Right. When do you remember first seeing legislation then? You must have some memory of when you first saw the legislation.
I couldn't give you an exact date, Senator. I think I've already said that. If I could give you a timetable, I'll take it on notice.
When did you first realise that the legislation would cover anti-Semitism but not Islamophobia? When did you realise that? Or did you know that from the outset? That was part of the design?
Oh, okay. I did know that the legislation was focused on anti-Semitism because that was the intent of the legislation. It was to respond to what had been, a rise of anti-Semitism. I don't know when I focused on the fact it was just anti-Semitism, but that will be part. I'll be happy to provide you with a timetable, but I just don't have that timetable.
Did you raise concerns that it wasn't covering Islamophobia, or did you support legislation that didn't cover Islamophobia?
Senator, I don't believe that the issue of whether it covered Islamophobia or not was a matter that my office was concerned about. They were concerned about the scope of the legislation as a whole, and they were concerned about, as I said, whether it would work, and that the exceptions seemed to be rather broad.
Well, of course, for legislation to have broad social support, protecting one religion but not another would be a reason why there might be deep social unease about legislation. Unequal protection for religions is likely to cause social unease. Was that ever a concern for you?
I don't believe that that was an area that I was focused on.
All right. Just one. I did press for answers about conflicts of interest and declarations you've made about conflicts of interest, and I'm having an ongoing FOI battle with the Home Affairs Department about that. But I do know that in partial answer to one question, SE 25025, the answer we were given about conflicts of interest and independence was Ms Siegel's term as president of the ECAG ended prior to her accepting the special envoy role. She stepped away from all authority and decision-making in her capacity as immediate past president. She also resigned from the board of the Australia-Israel Chamber of Commerce and from the board of Rabobank. Was that... The practice is that you would be consulted before answers are put on.
Yes.
You were obviously consulted about that?
Yes.
And did that reflect what you wanted to tell Parliament?
Yes.
Well, you see, that answer suggests that you resigned from the board of the Australia-Israel Chamber of Commerce and the board of Rabobank. On my reading of it, suggests you resigned before you accepted the position of special envoy role.
No, I don't. Well, I don't read it that way, and that's not what I believe it says.
Well, you didn't resign from the board of the Australia-Israel Chamber of Commerce until 17 March 2025, is that right?
That is right. If you would like, I'd be happy to give you an explanation.
Well, just we may as well do it in one job lot because there's not a lot of time. But you also didn't resign from your directorship of Rabobank until the 27th of November 2024. You know, this is
Absolutely,
in one case,
Senator.
5 months after you took the position, the better part of a year after you took the position.
Absolutely. So, Senator, I don't believe either of those activities present any conflict of interest whatsoever. And that's why I didn't resign immediately. ECAJ, as you said, happened, I didn't resign from there. I had finished my term well before I took on this envoy role. But those two, Rabobank, for example, and AICC, I have always maintained did not represent any conflict at all. I resigned from those because of workload. As I started this role, I discovered that although it was a part-time role, it was actually very full-time in the time that it has demanded from me. And I couldn't fulfil those other roles to the best of my ability, which I've always tried to do with any roles I've had. So I did resign. So I certainly resigned from Rabo at a time that suited them, which was the end of the year, December. And I made sure that there was a successor to me at the AICC. It's always important if you chair something. I was not just a director, I was chair of it. That you find a successor, and I was pleased to find an outstanding woman as a successor, and that's when I resigned.
Well, I note the time, and we may come back to this later.
Yeah, okay. I'm going to rotate the call and return to Senator Blythe.
Thank you very much, Chair. Yesterday, the Independent National Security Legislation Monitor gave evidence to this committee and spoke about his own review into the definition of a terrorist act, including whether religion should be removed as a motivating factor from the definition. What's your position on this?
Thank you. Indeed, I have my office has made a submission,
yes,
which is, I believe it's public. I'm not sure if they're public or they haven't yet put it up. But I have been quite clear that I believe religion should continue to be part of the definition, and that if you go back over a number of terrorist acts that we've seen in this country, if religion had been not there, it would have been much harder to establish. And it's a very important part of the definition.
Fantastic. Thank you very much. And then just looking into your report, you've recommended that the Australian government should adopt the IHRA definition of anti-Semitism across all levels of government, public institutions and regulatory bodies. To what extent are you aware that this has been implemented?
Well, my recommendation is that, of course, we know that IHRA has already been adopted by the federal government. It was an observer into IHRA from 2019, adopted it in 2021 with support of government and opposition. So the current government was in opposition and both government and opposition adopted IHRA. So it is the federal government's definition, and it binds the federal public servant and all federal agencies. And in that sense, it binds, for example, the student ombudsman, etc. They use IRA because IRA binds the federal government. The point in my plan is that it maybe is not well enough understood and well enough implemented through the public sector. So that is a matter of some education and further delivery of policy through the public sector. And that is a process that has commenced, but I think will take a little bit of time. But one of the things that my office is doing, and we're following the example of other jurisdictions, particularly the Canadians, is we are going to produce a guide, something that can be useful to the government at all levels to understand IRA better and to put case studies in the Australian context before them so that they see how it works. So it's not just an abstract definition with case studies that they feel they can't relate to, but a document that is meaningful. And I'm hoping that will happen in the next few months.
I hope that it is done, because if it's been 5 years and there's still more time needed, and I sort of look at university campuses and so forth, where if they're bound by that, they certainly haven't been.
Yes, well, universities are an interesting point, because the report card that is underway will be looking at one of the things is whether they have adopted a definition of anti-Semitism, because it is my belief that without the adoption of a definition, they can't have viable complaint schemes that work, and they can't have policies that deal with anti-Semitism. I mean, you need to have a definition. If you can't define it, you don't know what you're dealing with. Yeah. The universities as a whole generally have not adopted IRA. There are a few who have, and they've worked on their own definition, which they call the UA definition, Universities Australia definition, which takes part of IRA. And leaves out the 11 case studies, but adds in a little bit about Zionism. So they've kind of developed their own workable definition of anti-Semitism that they say will be easier to use in their complaint schemes. This is one of the things that the report card process is intended to look at. What definition they have accepted, have they implemented or operationalised it in their policies and in their procedures.
Is it fair to say, though, as federally funded bodies, you would assume that they're public servants, that they would fall under the all-of-government approach?
I think one could take that view, but I've taken the view that certainly the previous government under Prime Minister Morrison did, I believe, write to all the universities to encourage them to adopt IRA. And many of them pushed back and said they found IRA very difficult, etc. So today they've said, well, we'll work on another definition, and they have this other definition, which the Parliamentary Joint Committee looked at it and said they should adopt IRA or a definition close to IRA. Okay. And this is what the report card will be looking at.
And I guess if you look at university campuses have been hotbeds for anti-Semitism, it's probably fair to say that them adopting their own version hasn't been successful in stamping out anti-Semitism and ensuring that students feel safe on our university campuses.
Senator, I think that up until my initiation, my plan and the report card, I don't believe many universities had adopted any definition.
Yeah, wow.
So I think that they believed it was not necessary, and that's what we're dealing with, where we have institutions who need to move culturally into the space of understanding that anti-Semitism is the oldest hatred. It needs to be accepted as a specific hatred, not a general hatred. It's based on tropes and myths and misunderstanding, and we need to focus on it, adopt a definition, educate the important leaders of the university about it, and put in place processes to deal with it and counter it, which is why I think the report card is an important process. And I'm hoping the universities do give it the serious attention that I believe it deserves. Because I agree with you, we absolutely have to focus on universities as being places where we should have important debates about important issues, but it should not foment hatred.
Yeah. I agree with you, and I do not envy your task. You have a huge task ahead of you, and you're doing some really great work.
Thank you.
So, thank you. This is my final question. In terms of your plan, when you released it, your understanding of which minister or department do you feel was responsible for the implementation?
Well, I think the plan cuts across many departments.
Yeah.
So, and that's one of the tasks that I'm in the process of communicating with the different ministers to make it clear what I think they should each be doing.
Okay.
Because perhaps that wasn't clear enough as to who should be doing what. But clearly, the matters that relate to immigration belong to, the Minister for Home Affairs. The education belong to the education ministers, and they certainly understand where I'm coming from and have been very well focused on that. But there are others in there that there are things for Attorney Generals, the database that they're developing in relation to hate crimes. So everybody does have a role, but I'm conscious that I probably need to be very clear with the different ministers.
Without putting words in your mouth, would it be helpful if the Prime Minister took leadership of that to ensure that you have, without you having to go out there, you've got a huge fight to have in an education program?
Yes. Well, I think the Prime Minister does understand the importance of it, and I do think he has not told me this, but I do believe he has encouraged the key ministers to focus in on and be supportive, because I have had a lot of support from the Education Minister, for example, and the Minister for Home Affairs. So I do believe that I'm sure the Prime Minister is also conveying that. I do not know if it's been discussed at Cabinet or anything like that. I can't speak for that, but I do believe there is support.
Excellent. Thank you. Thank you, Chair.
Thank you. That's all the questions we have for you in the room.
Oh, well, thank you very much.
But thank you for your attendance, Ms.
Thank you.
Siegel. We're in a position to release you. We now welcome officials back to the table from Outcome 2.
Thanks for coming in.
Oh, thank you.
Yeah, thank you. We'll suspend broadcast for a moment.
These questions are in relation to data. So
Okay, thank you very much.
If you,
let's resume with officials from Outcome 2, and Senator Scarr, I'll hand the call to you.
Secretary, I was just asking them how much they enjoyed working for you.
I'm sure I would have told you nothing gives them greater joy.
So I'll put these questions. If you've got the figures there, you can provide the figures. If you don't, if you can just take them on notice. How many non-visa holders are there currently in Australia, excluding bridging visas? So how many unlawful non-citizens do you think there are in Australia at the moment?
Senator, we published an estimate of that figure. I think the figure's around 77,000 or 78,000. I'll get a colleague to correct me if that's off.
Okay. How do you come up with that estimate?
Teams look at the instances of visas expiring and then match that with things like fact of death data, and also do sampling to be able to come up with the figure.
Okay, so it's not possible to come up with a definitive figure because people might pass away.
And a large cohort are what you might term historical circumstances, where it may be decades since they arrived in Australia. And some of it even relates to changes in terms of the lawful status of people over time, like going back to different circumstances for UK citizens a very long time ago.
Sure.
Papua New Guinea as well.
Papua New Guinea too, that's correct.
Okay. So that figure, one area, Mr Willard, where I've seen competing reports is in relation to people who were here under the PALM visa scheme or PALM scheme, and then they've left their employer for whatever reason. It might be because of worker exploitation, and there are differing estimates with respect to the number of former PALM workers who potentially are somewhere in the country but not on a current visa. How do you estimate that cohort?
I could take that figure on notice.
Okay.
I know there's figures on disengagement, which is a different thing from a visa expiring, and I know as well that our approach to compliance takes into account that circumstance where it could be a situation of exploitation.
In terms of that 77,000 estimate you've got, do you have any breakdown of the visa subclasses non-visa holders were last on? So whether or not they're on visitor visas, student visas, do you go to that level of granularity?
I'll take that on notice.
Okay. And in terms of your breakdown of bridging visa statistics, can you just, to what extent can you break that down for us in terms of the different cohorts on bridging visas?
Let me give you an overview. Look, in the interests of time, what I can give you is what I have in front of me, which is that bridging visa A, B and C cohorts. That's the vast majority of bridging visa holders.
Okay.
That's the figure I have. So if we look at that figure, students are at 107,000, families at 86,700, so 87,000. Onshore protection, as I said earlier, 77,000. And then the skilled is at 46,500. That's the largest cohorts. There are other cohorts there.
Okay. And what about bridging visa BVE holders in Australia? As at 30 September 2025, there were 8,120. Have you got a more up-to-date figure on that? And can you break that down into subclass 50 and 51?
Is that just total bridging visas, Senator, just in general?
Yes, and then if you can break it down into the two subclasses.
I have the BV numbers, but broken down by UMAs and non-UMAs.
Yep.
So for bridging visa subclass 50 and 51, there were 18,784. And then for BVE's subclass 50 for UMAs, there were 6,356.
So I'm just trying to reconcile this. The last report online said there were 8,128 UMA BVE holders in Australia. That was the last published report. So in terms of those figures you've just given to me, what am I comparing that to? I know this is like a second language to you, catching up.
Those were the figures at the 30th of November 25. So which figures did you have, Senator?
As at, I haven't got the date, 30 September 2025, I had 8,128 BVE holders. Maybe I misread it.
Why don't we take on notice?
Yeah, the specific number.
The discrepancy.
Just that figure, do you know what the figure I've got of 8,120 UMA BVE holders as at 30 September? Do you know the figure I'm talking about there in terms of the report as at 30 September?
No,
don't?
Senator.
Okay. All right. Can I move on to ministerial interventions? How many cases are currently before the minister for determination in terms of ministerial interventions?
Senator, while Michael and Michael find the data, it might be helpful. We have about 5 different ministerial intervention powers, so we don't tend to accumulate them all.
You don't have an aggregate number?
No, we tend to break them down. There's ones relevant to those in the immigration compliance space who are seeking a bar lift or to do with their detention, and then we have those who are seeking.
So can you
visas.
give me the breakdown then?
Yeah.
Senator, I do have the numbers for the numbers referred to a minister. I can give you those numbers if that's useful.
Yeah.
So for this financial year so far to the 30th of November, for section 195A, which is the minister's power to grant a visa to an unlawful non-citizen,
yep,
was 158. How many years would you like back, Senator?
Well, so you're giving me the figures for the financial year from...
So that would be the 1st of July to the 30th of November.
Okay. Well, why don't you give me those figures first and then we'll work out where to take it from there. Yep.
For section 197AB, which is the power to put someone in residence determination, that was 27 for the same period.
Yep.
Referred to a minister. And for section 351, which is substituting the decision of a tribunal,
yep,
255 for that same time period, referred to a minister.
Okay. Any others?
Senator, I might take my element on notice.
Okay. What about under section 501J?
There have been 0. Senator.
0?
That's right.
Okay. (417).
417 was actually repealed back in October 24.
Are there any outstanding under 417 to be processed?
They've all been sort of moved under 351, so they'll all be considered under.
Oh, okay. Okay, thank you. And 48B?
Is that the one you just took?
I'll take that one on notice. Yeah, I do have some figures on 48B, Senator. So 12 in this year to date.
Okay.
Referred to the minister.
Do you have feel free. Oh, sorry, Mr. Willard. I didn't want to cut you off.
And 12 bar lifts.
12 bar lifts. And do you have figures of the number? So those are the numbers that have been referred. Have there any that have been referred in a prior financial year period which are still before the minister, or have they all been dealt with?
I don't have the breakdown, Senator, of when those cases were referred versus sort of this is the year that they were referred to a minister.
Okay.
But not the decision. I can give you the outcome based on year if you'd like.
Okay. If you can do that.
So for 195A, there were 57 ministerial interventions from the 158 referred to a minister.
Yep.
For 197AB, there were less than 5 interventions for the 27 referred.
Yep.
For 351, there were 157 interventions with the 255 referred that year.
Yep.
I should note too, some of the decisions might be from referrals from a previous year, but just to sort of give you that in that sort of linear order. And then, like I said, 0 for 501J.
Yeah, okay. If you can just take on notice whether or not you can provide the numbers for, say, the previous financial year as well, that would be helpful.
We can do that.
Just in relation to the 351s, do you have numbers as to how many were granted under Minister Burke and how many were granted under Minister O'Neill? Or do you calculate on the basis of time periods?
I've only got a financial year breakdown.
You've got a financial year period, yeah.
Not separated by minister.
And what about junior ministers signing off? What's the protocol in relation to that?
Generally, the assistant ministers will make a lot of these decisions.
Right.
It's a sort of conversation process, discussion between the officers to determine which cases should go where.
Okay.
One final question?
I'm just quickly trying to get through as many questions as I can here. Can I move to onshore protection visas quickly? How many, I think Mr Willard, you gave me the figures as at 30 November 2025, which was the last tabled report. Do you have any data with respect to how many were lodged in December, the month of December, or the month in January? Do you have the lodgement figures for those calendar months?
I have November. I don't know if Mr Kiley's got anything later.
Have you got anything later than November?
Only November, sorry.
Okay. Do you have... okay, so November report's got the country of origin. I think I did put a question on notice, and I know Minister Watt's comments about questions on notice. I'm very judicious in terms of my questions on notice.
Thank you. Maybe you could offer some training.
Well, I wouldn't presume to do that, Minister. Wouldn't presume to do that. I put a question on notice in relation to grant rates in relation to country of origin, and I haven't got a response to that yet. Do you keep that data? Do you track that data in relation to grant rates?
We do have that data.
Right.
Senator, we'll chase up the question for you.
Can you chase up the question on notice? And one of the issues, Secretary, is there are particular countries of origin where the grant rates are extremely low. So there are countries of origin where the grant rates are very high, as you'd expect, Afghanistan, Iran, some other jurisdictions. But there are other jurisdictions where the grant rates are low. And in fact, in the answer question on notice, I asked the ART, just to give you one example, for the year from 1 July 2025 to 30 November, there were approximately 77 appeals by people from Vanuatu with respect to denials of onshore protection visas, and one was successful out of 77. So I don't know how many were made to the department and were just knocked back, but that's an example of a very low grant rate. There were people from Ireland appealing to the ART with respect to refusals of onshore protection visas. Taiwan was another one, Republic of Korea. There's a few that stand out in terms of either 0% success or 0.1%. What do you practically do to manage that issue where people are making onshore protection claims from countries where there's, based on past consideration, there's nearly 0% chance of success? How are you practically managing that issue?
Yeah. Mr Kiley can talk a little more if you need, but essentially in the first in, first out processing model, one of those considerations is cases that we can decide more quickly. And when we look at the cohorts that we can decide more quickly, we do look at elements like the success rate for those particular cohorts. Typically, if people have genuine claims, they're much more complex to deal with.
Yeah. Just one follow-up question on that, sorry. How many of these people, maybe take this on notice, and this comes back to my issue about representation. How many of these claimants are actually represented by a registered migration agent or someone who's actually assisting them in preparing their application?
Unless Mr Kiley has a figure off the top of his head, which he might, I'll take it on notice.
Yeah, I would expect to be fairly similar to the rates we see through at merits and judicial review as well, but we'll take it on notice.
Okay, thank you. Thank you, Chair.
Thank you. We'll now break for dinner. We'll return in outcome 2 at 7 p.m.
Just for the we'll be asking some questions about a coronial finding, a recent coronial finding in the matter of Jerwin Mariupa, which was handed down in January of 2026.
I'm sure officials appreciate the notice.
Thank you, Senator.